Good morning, everybody. Uh, I'm Charlie Moxley, adjunct professor at Fordham Law School, who is active in this space of nuclear weapons and international law. On behalf of Jeff Biller, Jonathan Granoff, John Burroughs, and Jules Zacher, as organizers of this event, I am delighted to welcome you. With Russia's threats to use nuclear weapons in Ukraine, China's troubling ongoing buildup of its nuclear arsenal, the U.S.'s continued commitment to nuclear weapons, the new arms race we seem to be embarked on or on the threshold of, and with the change in presidential administrations, this seems a particularly important time to look at the risks posed by nuclear weapons and the potential role of law, which is our focus here, in addressing these risks. But it's not easy, is it? We've gotten used to these weapons. They seem to have become a fact of life, and they aren't much fun to talk about. Plus, it's hard to think that we can do anything about them. So they've become a back burner issue in most places, notwithstanding the huge risks presented. Cognitive dissonance is kind of a human process of denial of a threatening situation. I think this program and really this entire series that these conferences are unusual and I hope consequential in bringing together a diverse and experienced faculty, importantly, across a broad spectrum of views as to the policies we should be following as to nuclear weapons, and most importantly, the potential law to address the risks. What has come out of these conferences and our prep for this conference, and is obvious in the literature, and as was evident in the record of the nuclear weapons advisory case before the ICJ, culminating in the ICJ's advisory decision in 1996, there are a variety of views as to the lawfulness of the policies of deterrence and the nuclear weapons war plans, and that's what they are, of the U.S. and other states that have nuclear weapons. There are a variety of views here, as well as a variety among the states under the nuclear umbrella. The defenders of the status quo believe that with our current deterrence policy and nuclear weapons war plans, we're making the best of challenging circumstances and doing all we can to comply with law in a world with a lot of bad guys who could care less about law. Most fundamentally, that deterrence is the best we can do, although we can always improve it, and who believe that it works in effect. We're stuck with it, and we should take comfort in it. On the other hand, there are those who believe that this entire venture is unnecessarily dangerous, immoral, and unlawful, that the use of nuclear weapons would be contrary to established law, and that our policy of nuclear deterrence and our overall war plans and those of other nuclear weapon states are unlawful, and that with thoughtful leadership, courage, and human capabilities, there's a potential over time, with appropriate verification, for a world in which applicable law can be recognized and clarified if necessary, policies can be aligned with that law, and appropriate detection systems and systems can be put in place to address violations in an effective way, who believe most fundamentally that deterrence and nuclear weapons have themselves become our greatest danger, our greatest risk, greater than any actual international challenge they may be contemplated being used to address. So these are consequential issues here, and this opportunity to address them with views across the political and legal spectrum is truly an important opportunity. Important that we listen carefully to one another and try to advance in our analysis of these issues and appropriate actions to deal with them. So I'm delighted and honored to open this conference by highlighting and thanking our sponsors and to invite representatives of a number of them who've been able to come today to talk and introduce. I mean, it's truly extraordinary, isn't it? I mean, we have the Fordham Law School, Center on National Security. We have the U.S. Air Force Academy, the American Bar Association, Georgetown Law School, University of Pennsylvania Center for Ethics and the Rule of Law, the Catholic Peacebuilding Network, the Lawyers Committee on Nuclear Policy, the Global Security Institute. We have extraordinary range of groups who are interested in this area and have, with Jeff Biller and Jonathan and John and I, been working on this really for a good part of the last year. So let me turn this over to the representatives of various of our sponsors and supporters. I'll lead with Dean John Feerick of the Fordham Law School, the longtime dean of the law school, dean emeritus, formerly a partner at Skadden Arps, the go-to person in the state of New York when the governor has needed someone to put in charge of a central problem in the state. And Dean Feerick's early thing back when he was on the law review at Fordham was he wrote an article on presidential succession that served as the foundation of the 25th Amendment, which he later helped draft for the ABA. So, Dean Feerick, I'm honored to thank you for Fordham's support.
I just want to say thank you to you, Charlie, and how pleased I am that this conference is taking place, even though it's a virtual conference at Fordham. And it's always been an honor and privilege for me to say a few words about you. I consider you a lawyer's lawyer. You have spent an enormous number of years in this field. In addition to attending Fordham College and its graduate program, you have achieved an unbelievable reputation. And your treatise on nuclear weapons in 2000 was considered by many of epic significance. And the recent update of the treatise, and I had the privilege, thanks to you, of introducing a program that we at Fordham sought you out, so to speak, to talk about your book. And your treatise on nuclear weapons is a classic, and certainly most deserving of the widest possible readership. And I was privileged to, at your request, to write one of the introductions to that wonderful treatise. Let me also say that one cannot characterize you as only interested in terms of your commitment in nuclear weapons and war. You have been a practicing attorney covering many areas of endeavor, serving as a clerk to a federal judge, a litigator yourself in a distinguished law firm, a teacher, as you noted, here at Fordham Law School. I was honored, really, to be dean when you had the request of doing a course in this area. And I don't know if the world is familiar, as many of us are, with you as a mediator and arbitrator and a tremendous scholar, a leader in the organized bar, there's hardly a role, frankly, that you haven't played some role in, and made yourself, in my judgment, a very special place in the pantheons of giants who serve as facilitators for peace. It's a pleasure, really, to say a few words about you, and I wish you and those participating in the program a very fruitful and very productive day. I will be myself teaching a class for 2 hours on the rule of law, beginning at 10:30. And then this afternoon, I also co-teach a class on rule of law. And we're starting the class today talking about the Declaration of Independence and how it was put together by a committee, and obviously Thomas Jefferson and others. And last week we spoke about the sources of liberty, and I took the students who studied different documents in the history of liberty, from Magna Carta down to the English Bill of Rights of the 17th century, and now they're moving into the Constitution, educating students and information so that they can go out and teach civics and other contexts about the Constitution of the United States. So, Charlie, thank you so much for being here, and I wish you a very successful program today.
Thank you, Dean Feerick, so much, and thank you for your kind remarks. And you always give us all, you certainly give me and all of us, I think, so much to aspire to. Let me introduce Karen Greenberg, who is the director of Fordham Law School's Center on National Security and is a prolific author in this space, including a recent book, Subtle Tools, the dismantling of American democracy from the War on Terror to Donald Trump. And her earlier books include Rogue Justice, The Making of the Security State, and I'll just mention one others, The Least Worst Place, Guantanamo's First 100 Days. Welcome, Karen. Thank you. And thank you for the center's support for this conference.
Thank you so much, Charles, for that kind introduction, and especially for hosting this conference. And I'm delighted to join in welcoming everyone to today's conference, which promises, from the looks of it, to add vital dimensions to our understanding of the wider legal and policy conversation around nuclear weapons, deterrence, and the law. I wanted to start with a few things this morning on a personal level. From childhood, I grew up with an intense knowledge of the threat of nuclear weapons. I grew up in New London, Connecticut, where nuclear submarines were a cause célèbre, and because some of them eventually carried nuclear weapons, a cause of fear in my town. The sleek vessels were docked down the street from my grammar school. They were built across the river at Electric Boat Shipyard. And as a youngster, because my grandfather was mayor of the town, I attended numerous christenings of nuclear subs. And as a teenager, I was a tour guide for the submarine base, where the highlights of the tour were the nuclear submarines, about which I was told to say very clearly, very little. As much as we admired the novel vessels, we were also very aware of the threat of a nuclear attack. If there was ever a place where duck and cover drills were followed, it was in my schools, my grammar school and my high school. And so I grew up sort of aware of this space. And so I want to talk a little bit about where we stand now in the United States, just a few notes about things people might not know and I think would be interesting to bring to the table in introducing the conference. Charles, you talked about the importance of thoughtful leadership, perhaps starting with the president. And so the second thing I wanted to remark on this morning is the inconsistency here in the United States over successive administrations, both as to the urgency of the nuclear threat and how it is defined. One window into this, and it's just one brief one because that's all I have time for this morning, one window into this inconsistency are the national security strategies issued by successive presidential administrations. In the last year of his presidency, Bill Clinton's national security strategy mentioned the threat of nuclear war over 100 times. Following the attacks of September 11th, George Bush's strategy, perhaps understandably, mentioned the need to attend to nuclear threats a scant 4 times. Since then, the focus on nuclear weapons and the dangers they pose has risen and fallen. None of it has garnered the same attention as during the Clinton years, although the concerns of the Obama strategy offered a close second to Clinton. Another discrepancy I want to point to very briefly, revealed in the national security strategies, is that between a focus on a nuclear policy that identifies specific enemies, nation states like Russia, Iran, North Korea, and non-state actors in terrorism realm. And the difference between that and policies and legal discussions which focus on the need for global policy and global laws rather than on enemy-specific approaches. As today's conference underscores, which is peopled with so many stellar scholars, experts, and lawyers and others, I really think it's just a wonderful conference you put together. When it comes to the threat posed by nuclear weapons, the global context and the power and performance of international law is essential to the future security of the globe. As President Obama's national security strategy underscored, like climate change, global economic insecurity, and other issues, the nuclear threat requires nothing more and nothing less, and perhaps more importantly, given the frightening aspects of a nuclear war, nothing less than a coordinated global response beginning with the law. So thank you so much for hosting this and so much for allowing me to give some introductory remarks, and welcome everybody.
Thank you so much, Karen. Very appreciated. You referred to me as organizing this conference, but that's given me more credit than I deserve. Professor Jeff Biller at the Air Force Academy, along with Jonathan Granoff and John Burroughs and Jules Zacher, have been equally engaged in this whole effort. And Jeffrey Biller, who is an assistant professor of cyber law and policy at the Air Force Academy and part of the Air Force Cyber Warts, which partners with government, industry, and academia to develop innovative cyber solutions, has been an extraordinary leader, frankly, within the U.S. establishment at attracting many of our wonderful speakers with the perspective of which enable us to have the dialogue that we can have today from people who strongly believe in the status quo and people who think that we need to rethink it and look at it and hopefully can make some changes. Jeff.
Well, thank you, Charlie. And I don't think you can get enough credit for the work you've done organizing here, personally. But good morning, everyone. I would like to particularly thank Charlie for all the continued work in this field and his desire to continue the dialogue. The previous versions of this event were incredibly fruitful, and I hope that this year's event lives up to the standard. Conversations like we're having today are critical. The law alone cannot eliminate nuclear risks, but it can help shape state behavior, reinforce norms, and create pathways for de-escalation. By bringing together experts from law, policy, and strategy, we help ensure that informed and thoughtful dialogue can continue to guide decision-making at the highest levels. I encourage all of us today to engage openly, challenge assumptions, and explore solutions that will move us closer to a more stable and secure world. While the risks are real, so too are the opportunities for progress. Thank you, everyone, for joining us today, and I look forward to the discussions ahead.
Thank you, Jeff. Thank you. Let me invite Carlos Ramos-Mrafsovsky to address us, and I hope I've come close there. Carlos is the chair of the international section, which of the New York State Bar Association, NYSBA, which we're so grateful that the section has supported us in these efforts over the years. Carlos is from the same world of international arbitration in New York that I'm with, sort of as my day job. And Carlos is a practicing lawyer who represents large multinational companies and sovereign governments in international arbitrations and litigations, has extraordinary background and perspective, including in the energy, mining, and infrastructure sectors. Carlos, thank you, and we appreciate your support.
Thank you, Professor Moxley. On behalf of the International Section of the New York State Bar Association, I take this opportunity to join in the chorus, I hope, thanking you and expressing our gratitude for your leadership in organizing this program. We are very proud that the International Section of the New York State Bar can support this program, I believe now for the third time, and to be associated with the other institutions sponsoring it as well. Today's program, it goes without saying, addresses a topic of permanent, urgent concern to our members around the world, to lawyers around the world, and indeed to all people around the world. And I'd say that as an organization primarily of practitioners of international law, we are a community that hopefully all believe in the potential of international law to resolve and prevent conflict, to advance peace and security internationally. And that's certainly a value shared by all of the International Section's members in 60 chapters around the world, and that I believe has been reflected in our section's activities through the New York State Bar, whether it be advocacy on issues such as the illegal war in Ukraine, or more generally in efforts to build an international legal community. But it's also the case that these kinds of more profound considerations about the role of international law can at times feel quite remote in what is for many of us still a commercial practice. But in a world of mounting conflict, instability, the nuclear threats that you referred to so eloquently before, this program gets straight to the most fundamental and existential points, and reminds us of what we hope and aspire will be the role of international law in addressing and mitigating. And so for that reason, I'm very grateful to all of the participants for their scholarship and service and attention to the weighty legal issues that I know will be grappled with today. And I'm very proud that our section can support this program again, and I'm sure we will continue to do so for as long as you continue to organize it. So thank you for the chance to be with you this morning.
Thank you so much, Carlos. And it certainly is the case that the New York State Bar Association, the ABA, which we'll be hearing from shortly, offers all of us an extraordinary opportunity to really engage with these broad issues and hopefully to be able to make them more broadly understood and impactful. We have so many experienced people in this conference today who have been active in this space for a long time in so many instances. But we also have some young folks who are so extraordinary. I read the bio last night of Gent Salihu, who is the editor-in-chief of the Georgetown International Law Journal. And as I said in our earlier comments, I felt like, that you're more an ambassador. You've worked for the president of your country. You've been active in international affairs already. You're a graduate of Dartmouth with a master's in public policy from Oxford. And as I said, you worked as an advisor to the president of Kosovo and the Minister of Justice. So thank you. And we're very appreciative, to have the Georgetown Journal of International Law, as the Fordham International Law Journal did for the first of these conferences, publish a special edition of the proceedings, puts these conferences out even beyond the sign up. I mean, we had some 300 people sign up for today, but your publication now will get it further. So thank you.
Well, thank you for that very, very kind introduction, Professor Moxley. We don't want to step on the toes of the Fordham International Law Journal, but we would love to continue publishing the proceedings of this conference in the future. This is the second time we're doing it. We're co-sponsoring this conference, and it's important to continue discussing nuclear risk through the lens of international law. It has never been more pressing, particularly in the context of Ukraine and Russia, developments in the Middle East. At the same time, advancements in AI may shape future military buildups, including in China, which also adds another layer of complexity to global security. And at Georgetown Journal of International Law, we have a particular focus on emerging tech this year. Our upcoming symposium on March 14 will explore the intersection of emerging tech and international law, and I hope many of you will be able to attend in person. As a co-sponsor of this event, we're honored to publish the proceedings of today's conference, which brings together scholars, practitioners, government officials, and civil society. And these conversations are critical, and we're grateful for your participation. We've also got to publish a review of Professor Moxley's treatise of nuclear weapons recently. That's available online. I hope you have a chance to read that, which is summarizes and provides a critique of Professor Moxley's excellent treatise. At the end, I also just want to particularly thank our journalist advisor, Lieutenant Commander Chris Hart, and his team, who've worked so hard in making sure today's conference is a success and that all the proceedings are well captured so that we'll be able to publish everything. Thank you all, and wish you success today.
Thank you so much, Kent, and you will all very much enjoy meeting Chris Hart later, who, as we heard, is a naval officer and will be on a later panel. As a member of the board of the Lawyers Committee on Nuclear Policy, I'm particularly delighted to introduce Deeps Vij, who is the executive director of LCNP, and also the director of the UN Office of the International Association of Lawyers Against Nuclear Arms, IALANA. Deeps has a PhD in international relations and a master's in global governance from Oxford, and has been active in this space and written in it for some time. Welcome, Deeps. Thank you.
Good morning. Thank you, Professor Charles Moxley, and thank you, everyone, for being here today. On behalf of the Laureates Committee on Nuclear Policy, I also want to begin by thanking the international section of the New York State Bar Association for sponsoring this conference, and all the other co-sponsors as well. LCNP is proud to be one of the co-sponsors to the series of webinar on nuclear weapons and international law. I also wish to particularly thank Professor Moxley, Professor Biller, Mr. Jonathan Granoff, Dr. John Burroughs, and Jules Zacher for bringing together this extraordinary list of speakers, stakeholders, and content all on one platform. This conference, of course, is a third in its series, is very timely, and it's much needed to shift debates concerning nuclear weapons from the domain of just stating opinions to underlining law and thereby legal obligations. The potential threat posed by the very existence of nuclear weapons is far more underlined in the present day, as many of you have pointed out, whether in the form of a first strike, in retaliation, or as a result of a nuclear accident or incident. I think this year we commemorate the 80th anniversary of the atomic bombings of Hiroshima and Nagasaki. 1 year from now, in 2026, we also commemorate 30 years of the International Court of Justice opinion of 1996. And so I'm hopeful that this conference, with its timing, will set the tone for 2025 and will remain a gentle reminder that nuclear weapons are inherently indiscriminate, disproportionate, and uncontrollable. For us here at LCNP, it's a reminder for our need to continue to pursue efforts to reinforce the illegality of nuclear weapons. And again, on behalf of the Laureates Committee on Nuclear Policy, we're very thankful and very proud to be a part of this conference. Thank you, everyone.
Thank you so much, Deeps. The focus of this conference is obviously on law. We start with policy and the international strategic situation, but we focus on law. And a particularly hopeful part of this discussion is that we have numerous representatives on the faculty today who are presently members of JAG, the Judge Advocate Corps, the legal law firm, in effect, of the U.S. military, and several who are associated with JAG at this time. Law is important here, and the U.S. has, as we'll hear, from numerous military manuals, from the Department of Defense Law of War manual, which is over 1,000 pages on international law concerning use of force, made a huge commitment here. Is particularly important in that context that we now are going to hear from the presidents of the New York State Bar Association and of the American Bar Association, and hear of their perspective on international law and how it fits into issues of this nature. I think we're first going to hear from Dominic Napolitano, who is the president of the New York State Bar Association. Dominic, thank you and welcome.
Thank you, Professor, for having me, and please forgive me for not being able to come on video. I am traveling, and therefore I see that Tara put up a photo of me for everyone to see. Once again, good morning, everyone. Thank you for allowing this program to go forward. We are gathered to discuss one of the most critical, if not the most critical, international issues facing us today. It is the subject that we have been revisiting every 2 or 3 years, and we do not spend enough time on it. Perhaps that's because many other topics competing for our attention, whether it be the pandemic, global warming, or the growing income gap. However, as destructive and pressing as those issues are, none of them pose the threat to human life on the scale that a nuclear war does. That danger is highlighted by the ongoing war in Ukraine, Iran at the threshold of a nuclear state, and China's emergence as a nuclear superpower. They all pose implications of global security. To put it in more vivid terms, a nuclear war between the United States and Russia would lead to over 5 billion deaths, according to most estimates. We undoubtedly are at a critical juncture at our history. Policies are bound to develop within the next 4 years that will impact the war in Ukraine and the growing proliferation of nuclear weapons in the Middle East and also in China. These policies could open the door for greater stability throughout the world if they are carefully and not properly incorporated. But an impulsive approach could magnify the spread of nuclear weapons in a worldwide arms race. As lawyers, we need to ask ourselves, what is the role of international law in addressing the potential of nuclear weapons? And what are the future concerns regarding that risk? Those are a few of the questions that we will tackle today. The New York State Bar Association has always worked tirelessly to assist innocent victims of war, whether it be through shining a light on the growing issues of sexual assault as a weapon of war, or through the work of our international section that formed a task force on Ukraine to provide advocacy and immigration assistance for Ukrainian refugees. As you can tell from our agenda, we have an extraordinary collection of experts who will speak throughout the day. They come from the worlds of academia, leading non-governmental agencies, and from the armed forces, including Lieutenant Colonel Travis Lieb, the United States Army's Deputy Staff Advocate General of the United States Strategic Command, and Professor Jeffrey Piller of the United States Air Force Academy. Lieutenant Colonel Lieb is one of the most senior lawyers at the U.S. Strategic Command, who has major responsibilities in this area, while Professor Piller is the director of the Law, Technology, and Warfare Research Cell at the Air Force Academy, and one of the primary organizers of this event. We will also hear from experts in science, health, and legal fields, along with those from other areas of practice that are pertinent to our conversations. You will bring fresh perspective to today's discussions, and I appreciate all of you for joining us. I am looking forward to hearing what you have to say. Thank you for your commitment to the preservation of peace and democracy, and for ongoing service to our country. I want to thank Professor Moxley and the members of the New York State Bar Association International Section, and Jonathan Granoff on behalf of the ABA International Law Section for their hard work on this conference. The New York State Bar Association is extremely proud to be involved with this, which, like our other programs, focus on important and sometimes controversial issues. We are committed to supporting international peace and security through the rule of law. I would also like to thank our sponsors for their commitment to today's program. And of course, I would like to thank American Bar Association President Bill Bay, who will now say a few words and whom I hope to see quite shortly in Phoenix in the next couple of days. Thank you, Bill.
Thank you so much, Dominic. Thank you for your leadership and really for the State Bar's commitment to this issue, which doesn't happen automatically. It takes leadership, and we appreciate your leadership and Carlos's leadership in the international section. We're now going to hear from Bill Bay, who pre-recorded because he had another engagement this morning, but we have Bill Bay's presentation. Bill is the president of the ABA, which has supported these conferences from the beginning. I'd also like to thank my brother, Paul Moxley, who was instrumental in the ABA's support, who has been very active in the ABA for many years. Tara, let's hear from Bill Bay.
Hello, I'm Bill Bay, President of the American Bar Association. On behalf of the ABA and our International Law Section, we are pleased to be co-sponsors of this important conference. Thank you also to the International Section of the New York State Bar Association and the other co-sponsors for producing this timely program. The United Nations wrote in a March 2023 statement that the risk of nuclear weapons being used is currently higher than at any time since the depths of the Cold War. That's a sobering reality to consider. So it's very timely that this conference focuses on nuclear risk through a legal lens. The global landscape and relations are vastly different now than in 2020 when this program first convened. We witnessed a long and enduring conflict between Russia and Ukraine, which was the topic of your last conference. The assault on democracy and specter of nuclear warfare moved the American Bar Association to adopt Resolution 506. It condemned the Russian Federation's unlawful invasion of Ukraine in direct violation of Article 2 of the Charter of the United Nations and the Geneva Conventions of 1949, citing the threat of nuclear weapon use, the violations of the law of war and international human rights law. The ABA strongly urged the Russian Federation to respect its obligations under an international law that govern the use of nuclear weapons. The harrowing specter of nuclear warfare underscored the critical need for the global community to reinforce its commitment to international law, to peace, to disarmament, and prevention. But the ABA does more than just resolutions. Through the selfless work of the ABA Center for Global Programs, the International Law Section, and several other parts of the ABA, we proactively work to hold governments accountable under law, to advance global justice, and to work for sustainable development. We work to create a world where human rights are upheld, the rule of law is steadfast, and the global community thrives through unity and diplomacy. It's what we should do. We are an organization that strives to be the home for the legal profession and a model for our communities, domestically and internationally, a place where all lawyers can find opportunity and value. Wherever you practice, we are working to defend, build, and uplift individuals and communities. This past fall, the ABA Standing Committee on Law and National Security, the ABA's oldest standing committee, convened its 34th annual review of the field of national security. A spotlight was on the evolving face of war and the legal challenges of future conflict. Similarly, on today's program, the expert speakers are looking at nuclear risk through a legal lens, tackling practical issues and considerations. These are not new issues. Our country's leaders have faced these very challenges for years. In December 1962, during a meeting with Danish Foreign Minister, President John F. Kennedy decisively noted that once one resorts to nuclear weapons, one moves into a whole new world. President Dwight D. Eisenhower made a similar point when speaking with British Foreign Secretary years earlier in 1958, stating that when you use nuclear weapons, you cross a completely different line. We find ourselves confronted with the same predicament and peril of nuclear weapon use today and the humanitarian and legal ramifications of it. This is why this meeting continues to be relevant. We appreciate the New York State Bar holding this conference, and we thank you all for your contributions and commitment to advance justice, security, and liberty for all. The American Bar Association stands with you in protecting our world through justice and the rule of law. Thank you.
Our thanks, obviously, to ABA President Bill Bay for the ABA's longstanding leadership on these issues and support of this conference. We learned late last evening that, unfortunately, Secretary Bill Perry will not be able to join us today. Jonathan Granoff, who, because of a health issue, Jonathan Granoff, who has been meeting with Bill Perry and worked with him, is going to, and let me just back up. Jonathan, one of the organizers of this conference, is the president of the Global Security Institute. He's the permanent observer to the UN of the International Anti-Corruption Academy, and he's representative to the UN of the World Summits of Nobel Laureates, and is a leading voice in international law and international security. So we're privileged to have some opening comments from Jonathan, based both on work he did with Bill Perry in preparation for this conference, and from Jonathan's perspective himself as an organizer and a longtime leader in this whole area. Jonathan, thank you.
Charlie, thank you for all the work that you've done and those generous remarks. Small correction. I'm the former permanent representative for the International Anti-Corruption Academy, but I'm presently the senior advisor to the Committee on National Security at the International Law Section. Dr. Perry is 97 years old. I know he wanted to participate. I met with him at his retirement community in Palo Alto about 3 weeks ago and discussed this and how important he thinks this is. But at 97, he has some other issues that he's dealing with and regrets that he can't be here. I'm going to first and foremost highlight that this fantastic corpus magnus that Charlie put together with probably, I don't know, he must have had some help of law students and other experts, certainly, because it's huge. But the introduction, or maybe it's the foreword, is by Dr. Perry. And let me quote him and then parse out part of a presentation that he gave when he received the Global Security Institute's Alan Cranston Peace Award a few years ago at Stanford University. Dr. Perry said, in relevant part, modern science has changed the reality of full-scale war. That's why Albert Einstein said, I know not what weapons World War III will be fought, but World War IV will be fought with sticks and stones. States with nuclear weapons assert the usefulness of the weapons, pursue policies explained as promoting strategic stability, all the while seeking deployments designed for military advantage. Pundits believe that peace is kept internationally by policies of deterrence, mutually assured destruction, second strike, and all the rest. Whether a status quo where nuclear weapons remain in the realm of possible use is sustainable is highly questionable. I know from my time as Secretary of Defense in nearly all instances, the US military recognizes and seeks to apply relevant international law, including the principles of the law of armed conflict, to the threat and use of force in conflict. But is it being adequately applied to nuclear weapons? Can nuclear weapons as presently deployed be used in compliance with the law's limitations on causing suffering beyond military necessity, discrimination between civilians and combatants, and not impacting neutral third parties? Hardly. In my book, Journey on the Nuclear Brink, I describe how close US President Ronald Reagan, accompanied by Secretary of State George Shultz and USSR General Secretary Mikhail Gorbachev, came at Reykjavik in 1986 to agreeing to dismantle all their nuclear arsenals, an agreement that both Reagan and Gorbachev wanted. And he holds that promise still before us. And I highlight that, interestingly, President Trump in Davos just recently said that he wanted to move toward denuclearization. It's hard to tell exactly what he meant by that, but it's heartening. I want to make sure that there's a few questions that I have before I come back to Secretary Perry's remarks relating to what he considers to be a fundamental change in nuclear policy arising from Ukraine. He highlighted the importance of international humanitarian law. My question is, the President of the United States has been granted significant immunity from illegal actions by the Supreme Court of the United States. And I question whether that privilege, how far does that privilege extend should the president give an order that would be illegal, but for him, it would be legal? Is Nuremberg still relevant? Does international peremptory law, international humanitarian law, be outside of that immunity? The new Secretary of Defense has expressed a lack of appreciation, to say the least, of the role of justice advocate generals and international humanitarian law. In fact, he even once referred to JAG as jag-offs, which is shocking. And recently, the administration has called for closing the Civilian Protection Center of Excellence, designed to strengthen applicable international law, to minimize the killing of innocent civilians in conflict. I hope we get to address these in today's discussion. Now, Dr. Perry in Stanford highlighted the invasion of Ukraine violated two principles that were important during the Cold War. One, that no country would invade another for the sake of expanding its national boundaries. It was violated in the instance of Iraq and Kuwait, and the international community responded. And no nuclear power would threaten the use or use nuclear weapons except in response to a nuclear attack. He highlighted that these two principles have been violated, and that Putin has raised the nuclear threat by essentially saying, should the United States and other countries aligned with Ukraine effectively use conventional forces in this conflict against Russia, that he would use nuclear weapons in response. So Secretary Perry questioned how to deal with this unacceptable predicament. How far does this assertion of aggression with nuclear weapons extend? If nothing is done to respond to it, will it continue to be policy of Russia? So this very dangerous, destabilizing situation doesn't have an easy answer. I know that during the height of the Cold War, there was an organization that I was the UN representative for, Lawyers Alliance for World Security, and we built bridges with the lawyers associations of the then Soviet Union, bringing lawyers from the Soviet Union to the United States and vice versa. And bridges of trust and bridges of understanding were created. They were instrumental in helping us get out of the Cold War peacefully. I believe that lawyers can speak to lawyers anywhere in the world with a common language and respect for the rule of law, even in countries where there's a lack of understanding and common understanding even of what the rule of law is. And it's those bridges that we have to build again. And it is the in-depth understanding of the relationship between nuclear weapons and the law that is necessary to make those bridges strong. And that's why this webinar today and Charlie's leadership in putting it together is so noteworthy. And I conclude with, put it in the chat, there's an initiative with the United Religions Initiative that was started with Secretary George Shultz, may he rest in peace, Sidney Drell, who ran Los Alamos, may he rest in peace, Ambassadors Thomas Graham, Ambassador James Goodby, and William Perry, and myself, and Bishop Bill Swing, and several other people. And we did we're asking for extra help, so we did a nuclear prayer. And I commend that to everyone's attention, because we need two reins to rein in nuclear weapons. One is the rule of law, and other is basic morality. I hope that we can advance both of those reins to constrain the power that science has given us. Thank you very much.
Thank you so much, Jonathan. You always bring this broad perspective, this visionary sense of potential and of the problems we have to address. I mean, you've given us enough for another 3 days of conference. I hope we can get to much of what you've raised today. We're right on target for panel 1 now. I'm going to turn it over to Jeff.
Okay. I think that I need to drop off for a moment so I can rejoin with that particular panel. So I'll be, if you want to take just a
No, Jeff, you can stay. You can stay on this.
Okay.
Yep, this is the link.
Okay, welcome to panel 1, Contemporary Strategic Environment and Nuclear Weapons Risk. The contemporary strategic environment is defined by complexity, uncertainty, and rapid technological advancements, all of which shape the risks associated with nuclear weapons. While traditional deterrence frameworks remain central to strategic stability, emerging challenges, including geopolitical tensions, arms race dynamics, and the integration of new technologies like artificial intelligence, are testing their limits. Today's discussion will explore how these evolving factors influence nuclear risk, the effectiveness of existing legal and policy frameworks, and the pathways available to mitigate potential escalation. As we navigate this shifting landscape, it is imperative to engage in rigorous analysis and dialogue and ensure that nuclear risks are managed with prudence, responsibility, and foresight. To discuss this important topic, we are joined by a very distinguished panel. We have the Honorable Dr. Christopher Ashley Ford. Dr. Ford served from January 2018 until January 2021 as Assistant Secretary of State for International Security and Non-Proliferation. Before his appointment as Assistant Secretary of State, Dr. Ford served as a Special Assistant to the President and Senior Director for Weapons of Mass Destruction and Counter-Proliferation on the United States National Security Council staff, as well as a U.S. State Department official in the George W. Bush administration, working on issues of nuclear proliferation and arms control verification and compliance policy. We also have Daryl G. Kimball. Mr. Kimball is the Executive Director of the Arms Control Association, a private nonprofit membership organization dedicated to public education in support of effective arms control measures pertaining to nuclear, chemical, biological, and conventional weapons. In addition to policy analysis, writing, speaking, media interviews, fundraising, and staff management, Daryl is also the chief editorial advisor and a contributor to the ACA's magazine Arms Control Today. We have Mr. Hans M. Christensen, who is the director of the Nuclear Information Project, part of the Federation of American Scientists. As director of the Nuclear Information Project, he heads the Federation of American Scientists research and outreach on the status and trends of nuclear arsenals of the world's 9 nuclear armed states. This work includes core research of weapons programs and nuclear policies, disseminating the information to the public debate on the status and future of nuclear weapons, informing journalists, government officials, academics, and non-governmental organizations about these issues, and publishing the information in journals and on the FAS website. And finally, we also have Dr. Shane Smith. Dr. Smith is the director of the Institute for National Security Studies and an associate professor of political science at the U.S. Air Force Academy. He served in the Office of Secretary of Defense as Senior Advisor for East Asia Nuclear Policy and at the Defense Threat Reduction Agency as a Strategic Advisor. He also worked at the National Defense University, Harvard, Johns Hopkins University, and the Council on Foreign Relations. He is the co-editor of the recently published book called Arms Control at a Crossroads, Renewal or Demise. Thank you, everybody, for joining us. All right, I'd like to start with the question of assessing the current risk of a nuclear conflict. And the first question I have is, how do we assess risks? Actually, let me back up, I'm sorry. At this time, I'd like to start with introductory remarks by each of the panelists. We'll go ahead and we'll start with you, Dr. Ford.
Oh, thanks very much. I hope you can hear me. Is that all right?
Yes, great.
Fantastic. It's a pleasure to be here, and thanks for having me. To be honest, I'm not aware of any sort of crisp, precise, and systematic way that the U.S. government, at least in my experience, estimates nuclear risks. I'm not sure. In many ways, it's actually if you're looking for crisp performance metrics and so forth, I'm not entirely sure it's a doable thing. I certainly feel that the risks now are very high. I'm very skeptical about things such as the infamous doomsday clock, which I think we just heard last week or maybe earlier this week is now set to what did they say? 89 seconds till midnight or something like that. Those are political statements and parts of lobbying campaigns by organizations with their own agenda in this field. I haven't come across a particularly systematic way of doing that inside the government. That said, as I said, I do believe that they're high. I fear that the biggest risk at the moment of nuclear war comes out of the potential escalation of a conventional conflict between nuclear armed states and or their allies. And there's no small risk of that, I fear. But the reason there is such a high risk of that at the moment doesn't come out of the existence of the weapons themselves. It comes out of the fact that in the current security environment, we've got some major players, the Russians most obviously, but to some extent China as well, who have made who have returned territorial aggression to the front and center point of their geopolitical agenda, and are, especially in the Russian case, quite keen on using nuclear threats in support of that agenda, not to deter aggression, which is the way that we in the West usually think about nuclear deterrence, but actually to deter anyone from thinking about doing anything to impede their own territorial aggression. So that's that's the primary locus of risk. There are others, of course, and I've been a non-proliferation person for almost my entire professional career, and wouldn't want to slight those risks too. But I think the gravest danger comes from escalation out of a conventional conflict that has been undertaken by a country that wishes to, annex and absorb its, one or more of its neighbors, and is using nuclear threats to scare others out of causing any trouble for that agenda. If that's the gravest location of risk, then I think the path to reducing risks necessarily has to run through the statecraft of deterrence and of military doctrines and force postures and approaches that actually make that kind of geopolitical aggressiveness less attractive and therefore hopefully less likely. That's a very different agenda than one hears out of most of the disarmament community, but I do think that if we are going to reduce nuclear risks in the current environment, there isn't any other way to do so very effectively if you leave that statecraft box unchecked. That's my 2 cents. I'd be happy to talk further, of course, about this. Thanks for having me on the show.
All right, thank you, Dr. Ford. All right, at this time, I'd like to turn it over to Mr. Kimball for any opening remarks you might have.
Well, thanks for the invitation to be with you all for this conference. Very impressive lineup. I congratulate the organizers. Well, let me just provide an overview of what I see as the risk and some of the factors behind what I would say is a heightened risk. I agree with Chris that it's hard to measure quantitatively how much higher, but I would say it is heightened, and it is higher than at any point since the end of the Cold War. And so as we approach the 80th anniversary of the US bombings of Hiroshima and Nagasaki, it is clear that nuclear risks are growing. And one reason is that human civilization remains tethered precariously to the existence of nuclear weapons and the threat they might be used again in South Asia, in Europe, between the United States and Russia, in East Asia, between the United States and China, or on the Korean Peninsula. We have several nuclear flashpoints, all of which are depend upon a tenuous and very hard to sustain nuclear deterrence relationship between nuclear armed countries. And so, in addition, each of the states have policies that would allow for the first use of nuclear weapons in the event that a conflict, a conventional conflict, break out, and they are losing the conflict and feel the need to resort to nuclear weapons. China has a no first use policy, but the confidence in that policy, for instance, in a war over Taiwan, let's say it is not as high as it needs to be or could be or should be. So those risks are exacerbated, in my view, because the tensions between the United States and Russia, the tensions between Europe and Russia, the United States and China have stymied the kind of diplomacy and engagement on nuclear risk reduction and arms control diplomacy that has been one of the key ingredients throughout the nuclear age that has reduced nuclear risk, that has constrained the arsenals of the major nuclear powers. And of course, as you all discussed at last year's version of this conference, Russia's war in Ukraine has heightened the risk of nuclear escalation. That continues today, and that remains an increase, a reason why there's an increased risk of potential for nuclear escalation. And then, of course, we have the risk of a growing nuclear arsenals on the part of the US, Russia, and China as they modernize their arsenals, and in some cases, in China's case, expand their arsenals, and then the agreements that have held back the growth of these arsenals and have moved the US and Russia to reduce are at risk. And in particular, I want to highlight the fact that the new Strategic Arms Reduction Treaty, which was extended in 2021 by 5 years, will expire in almost exactly 1 year. And as of now, there are no talks underway to replace that. But I think interestingly and usefully, President Trump just a few days ago at the Davos Forum said that we want to see, I'm quoting, we want to see if we can denuclearize, and I think that's very possible in response to a question about engagement with Russia and China. So it's good to see that Donald Trump recognizes that the President of the United States has a role and a responsibility to mitigate these risks. It's going to be difficult to navigate any such negotiation with the Russians, especially more with the Chinese. I think Jeffrey will talk a little bit more about what some of the arms control options are a little later in this session. But let me just note here that based upon the history of US-Russian nuclear arms control negotiations, any negotiation is going to be complex and time-consuming. There are a number of issues that have been accumulating over the last decade plus between the US and Russia: strategic, intermediate range, tactical nuclear weapons, missile defense, that would all have to be resolved in a new comprehensive framework agreement. But I think it is possible for President Trump and President Putin to work out an interim agreement that heads off an increase of US and Russian arsenals, which could be on the horizon if New START, after New START expires, and if there's not some sort of new form of nuclear restraint arrangement between Russia and the United States. So let me stop there and look forward to hearing from others and exploring other questions.
Great, thank you very much. All right, I'll now turn it over to Mr. Christensen for opening remarks.
Great, thanks very much, and thank you for the invitation to be here. I'm looking forward to this discussion from so many different angles. And so I thought I would just kick in, because of what I'm doing in my job, with sort of a quick snapshot of what I see in nuclear force structure and operational developments, and then some thoughts about what those implications are. And of course, right now, in terms of threats and risks, the debate is very much dominated, as understandably, of the Russian invasion and continuing war in Ukraine. And their nuclear threats from day one. I mean, literally, it's been sort of a frequent and almost constant part of their behavior around this war, that they were very, very intent and very interested in impressing upon the West that they have nukes. And so they played that up in a variety of ways, initially with more and more strong statements. Then we saw this last spring, and summer, for the first time, some real high-profile tactical nuclear weapons exercises. And as you all know, we have seen sort of very frequent updates to their nuclear doctrine. It is almost as if they're desperate for attention. What's much harder to discern from all of this stuff is to what extent it affects the way the Russians actually intend to use nukes, at what point, and how they would do it. I think, there's concern about it, but it's really, really hard to discern from the rhetoric and the action. Nonetheless, the behavior is driving up not only what they think they need to do and say, but also what the West is reacting with. And here we, of course, have seen a much more muted rhetoric on the part of the West about nuclear weapons. The West clearly doesn't want to go into a tit for tat on this, which is a good thing. Ironically, I think the NATO's U.S. response in operational terms have actually been significant, both in terms of bomber operations, ballistic missile submarines operations, and the way tactical nuclear weapons exercises are communicated and branded in Europe right now. We also see some infrastructure change, of course, that's happening at Lake and Heath. So these things interact, sort of an action-reaction, and we see similar dynamics going on on the Korean Peninsula, of course. Most dramatically, of course, with the North Korean modernization, and most recently, their frequent talks about tactical nuclear weapons and the role of tactical nuclear weapons in their strategy. And then, of course, with that comes the South Korean reaction and the U.S. response to it. And then in South Korea, we see this strong public support, and even among some policymakers, support for South Korea going nuclear, which would have immense consequences for U.S. interactions, of course, with that country and that region. India, Pakistan, a different case. But nonetheless, we have seen border incidents, the rising of rhetoric, warnings that have nuclear tones, and they're in the middle of their own relationship there that is increasing the arsenal as well. India, of course, is becoming more interested and focused in terms of technology and strategy on its long-term relationship with China in the nuclear sphere, of course. But out of all of this, it's sort of a textbook example of what happens when you have nuclear threats and growing international tension. Countries reach for symbols of security, you need symbols of national power, and they try to illustrate that in a variety of ways. And so for me, this thing is nuclear threat is not that a nuclear power or nuclear ruler will wake up one day and then say, this is it, I'm going to nuke them. My concern is, just like John said, that the issue is more that this bubbles out of these interactions of a conventional conflict and that escalates. But this is where it gets tough and dangerous, when we get into this back and forth, this rhetoric, and this increased posturing on all sides, for that matter. We are seeing, I don't know if you've seen some of the bomber interactions and some of the Russian fighter jet responses to that, both in the Black Sea, but also off Alaska. Very serious incidents. But out of this comes these sort of incidents capabilities or incidents potentials that could trigger, a deepening of the conflict, et cetera. So I think it's more from that development, in my view, that risks arise. And then in the response that countries have to it, the way they reach for symbols in terms of capabilities or operations to make their point. Going up that ladder, of course, has to be managed and is dangerous. I mean, we spent 4 decades in the Cold War, so we know a lot about what that kind of action reaction is. I can talk more about the details of the nuclear developments in the various countries, but I thought I'll stop with this in sort of my pitch to what I see as some of the more interesting issues. Thank you.
Thank you. All right, and we have Dr. Smith. We'll close opening remarks with you.
Great. Thank you very much. And thanks for inviting me to be part of this panel. I'm proud to be given this opportunity to try to advance discussions on these important issues. I do want to highlight, as a government official, I want to make clear that none of my comments today should be misconstrued as representing any part of the U.S. government, including the Air Force and the Air Force Academy. I want to underscore, I agree with all of my colleagues who spoke prior to me, but want to underscore 2 what I think are inflection points in the history of the role of nuclear weapons in international politics that I think we are in the midst of. One is about arms control, as Daryl Kimball, I think, articulated very well. One thing that seems certain to me about the future of arms control is that it's not going to look like it has, the future of arms control over the next generation is not going to look like it has over the past half century, right? And in many ways, it needs to look different, right? Trends suggest we're entering into a new strategic era defined by competition among multiple nuclear armed great powers with different sized and diversity of arsenals, different interests, different priorities. We have potential, we face growing intensification of regional conflicts, rising nationalism, the advancement of information and communication technologies, and the emergence of new strategic domains in space and cyberspace, all of which are having really transformative impacts on international security relations and on the requirements for managing strategic stability going forward that I'm not sure that we fully have grasped intellectually yet, right? So arms control will need, I think, by necessity, need to adapt to the realities of this new era to remain a relevant instrument of statecraft. And I think it might be useful to think about arms control today, like the early days of the Cold War, right? When the way that early theorists and practitioners did as they try to identify rules of the road and mechanisms for managing extreme competition in a very new and unfamiliar era, right? Their work in many cases took decades to bear fruit, and it was far from guaranteed that it would succeed, right? But the arms control terms, concepts, processes that they collectively defined in that past era and implemented, eventually became a pillar of non-proliferation, international security, and strategic stability. But those concepts, theories, mechanisms that we developed were designed for a different era, and they may no longer apply. Some may not. And but I think designing the future of arms control, effective arms control for the future, is going to require bringing all of our creative juices and collective resolve. And I'm not sure that we fully have grappled with what that might look like. The other inflection point, which is not completely unrelated from the arms control discussion, stems from the growing consensus within the U.S. strategic policymaking community, as I think is represented by the latter part of the Obama administration, the first Trump administration, the Biden administration, and the the bipartisan Congressional Committee on America's Strategic Posture that concludes, and I think this kind of gets back to Chris Ford's comment about deterrence, right? That our extended deterrence relationships in both Europe and East Asia face growing challenges, and that our efforts to strengthen them to date, may be insufficient, right? So there are growing debates in the U.S. about the need to strengthen our regional force posture arrangements to strengthen those extended deterrence commitments, which of course would come with its own risks, about which I think has already been, a few of those risks have already been raised. But we're also seeing in allied countries growing discussions about developing independent arsenals if the U.S. doesn't take sufficiently strong measures to address what they perceive to be as yawning deterrence gaps, right? And that sentiment among allies could grow into greater regional nuclear proliferation among allies and a breakdown of the non-proliferation treaty, right? And so I agree with Daryl Kimball, right, that it's welcomed. I think many of us have seen arms control as waning and in trouble, and it's good to see President Trump raise arms control as a focal point of discussion and diplomacy. But I'm not sure that his entreaty assuages or intensifies concerns among allies about the future of U.S. extended deterrence commitments. I'm sure it does a little bit of both. I'm sure it increases anxiety and concerns, and also kind of alleviates some concern about the direction that the Trump administration may take. But the point is I think there's a real potential, if and when the United States begins to engage with Russia and China on arms control and potential reductions toward disarmament, right, there will be growing pressure for regional proliferation. And so I guess my bottom line is that there is no silver bullet to resolving the structural challenges to maintaining the U.S. extended deterrence commitments and kind of the new era that we are entering into of great power competition. And we can, of course, debate over what presents the greatest risks and the best approaches to reducing them. But I think we need to take appreciation of the fact that there is no real risk-free solution, right? So I'll turn back to you, Professor Biller.
All right, thank you very much. So from what I'm hearing initially is that we're in an environment with a lot of uncertainty between increased rhetoric, doctrinal changes, current armed conflicts, new weapons, expiring treaties, shifting alliances. In this environment, I guess I'll open it up for anybody. I mean, I heard Dr. Ford say that he doesn't really think that there are any good models for accurately assessing that risk. I'll open it up to the rest of the panelists. Is it possible to assess risk, and how important is it to assess risk as it relates to potential use of nuclear weapons at the current time?
Well, Jeffrey, let me just take a quick crack at that and come back to another couple of points that all of these overview presentations have made. I'm a political scientist. There are others who might try to quantify how great the risk is for nuclear weapons use in a particular situation. But I think in some ways it is an impossible exercise to quantify numerically how much risk has increased, because the decisions about this are by the leaders with their hands on the proverbial buttons, are very subjective decisions that are very specific to certain situations. I think our job as lawyers and experts and advisors to those who might make this decision is that it is crucial to find every way we can to reduce the risk of, the ultimate catastrophe. And so that just brings me back to, I mean, one of the things that I think is important as we enter into these discussions, which is that do we have a common set of broad objectives that we're trying to achieve with respect to international law, national policy? And I would just put forth a very simple proposition, which is that during the Cold War, as today, even more so, there are 4 or 5 major objectives that we need to be trying to advance and defend. One is to prevent nuclear use anywhere, to push back against nuclear threats, and there are some kinds of nuclear threats that some people say are more responsible and some are less responsible. I happen to be someone who believes that any sort of overt nuclear threat is irresponsible and, as the G7 said, inadmissible. We have a norm against nuclear weapons testing, which has held for the most part for about a quarter century, except for North Korea. That's very important in terms of reducing risk. We have a strong norm against the spread of nuclear weapons, and there are many strategies that have been developed that need to be strengthened, new approaches that need to be pursued to prevent the spread of nuclear weapons to additional countries, including the technologies that are necessary to construct them. And then I think there's an emerging norm that some governments believe exists and others are less loyal to, which is that there's a norm against increasing the number and diversity and the salience of nuclear weapons, particularly the number and diversity. For the vast majority of the nuclear age, beginning with the 1968 Nuclear Non-Proliferation Treaty, Article 6, there is an expectation and an obligation that the nuclear armed states will engage in good faith negotiations on ending the arms race and on nuclear and on disarmament and on general and complete disarmament. So that norm is at risk today because of China's nuclear buildup, the United States and Russia not having a pathway, a plan for what happens after New START, and the very likely push from the US Congress and maybe the Trump administration to increase the size of the US arsenal in response to what China and possibly what Russia does after New START expires. So I would lay out these as the broad objectives that we need to be pursuing in order to reduce nuclear risk writ large. Of course, nuclear weapons use is probably at the top of the list. And I would just finally add that deterrence and nuclear deterrence has a role in preventing nuclear war, yes. It has a role in preventing proliferation, that's extended deterrence. But we need to distinguish between assurance and deterrence and nuclear deterrence. And our ability to persuade and deter allies from going nuclear also depends on our political efforts to show support over time for their defense. And so political leaders can undermine extended deterrence simply by making political statements, as President Trump did in his first term. And that's one of the reasons why South Korea is very nervous, why NATO is very nervous today. So let me stop there. I just wanted to lay out a broad framework for us to think about in terms of how we pursue the employment of international law and policy to reduce nuclear risk.
Thank you. I think that's very helpful.
There's a question,
I'll definitely
Jeff.
come back to legal status of deterrence in a bit. So I'll turn it back over now to Dr. Ford. I saw your hand come up really quickly.
Yeah, thanks very much. Daryl and I don't usually agree on things, but I will certainly admit to sharing his skepticism that there's any really crisp way to measure nuclear risks. On the other hand, I'm not totally sure it's that important to have that fine grain a way of measuring things. Whether it's 89 seconds, 90 seconds, 3 hours, that's not really, to some degree, I think that's a sort of a distraction from the important policy issues we really should be trying to focus upon. The only time I'm aware in recent years, at least that I can recall seeing any reference to a specific sort of percentage of nuclear risk was actually just within the last couple of years with the early phase of the Ukraine, this phase of the Ukraine conflict, when it was at least reported in the papers that the CIA had supposedly assessed that something about the likelihood of nuclear use might rise to 50% or even higher. I don't even know if that's a quote from anybody's assessment, but that's what the New York Times recounted being told that the CIA had assessed. I think for the most part, those kinds of things are distractions from real serious policymaking. When it comes to that serious policymaking, though, I would push back on Daryl a little bit with respect to the idea of the alleged norm against increasing the number and diversity of weapons. The answer to that challenge seems to me to be very contextual. All of the things being equal, I'd love to have fewer of the damn things in the world. And that's hard to argue with, but clearly there isn't a norm to that extent. We've got the Russians who've been steadily building up their arsenal of shorter range and theater range nuclear systems, and indeed building them up in violation of arms control agreements for quite a few years. We've got the Chinese who are sprinting towards what looks like it will be at least parity with the United States within the next decade or so. India, Pakistan, North Korea. They're all growing. So, in terms of the relevant universe of nuclear stakeholders, even the Brits announced a slight uptick in their force posture, although it's very, very small. So, in terms of the relevant universe of stakeholders, if anything, there's a norm the other direction. I hope that's not actually the case, but I think to suggest that there is any kind of a norm against it by anybody who actually matters in this context is just wrong. And I'm not entirely sure there should be. From a U.S. perspective, we face challenges today with the emergence of two nuclear, basically near peers in the very near future that we will have to somehow manage to deter and to handle threats from, whose arsenals together will be, double our own before very long. It's not at all clear to me that a norm against doing anything to augment capabilities in response to those kinds of threats would be a good idea. That would be a recipe, arguably, for potential deterrence failure. So I think it's not for no reason that the clear trend in the U.S. nuclear weapons policy community on both sides of the aisle, and you can see this from the bipartisan conclusions of the Strategic Posture Review Commission, just to give one example, the bipartisan trend seems to be that at least some sort of augmentation of U.S. capabilities is absolutely needed. Now, how much? That's a hell of a question. I don't have that for you. But I think, if anything, there's a wise understanding in the policy community that one needs to have the capabilities and the numbers that are necessary in order to preserve stability as much as we can. And if that requires going up, then that's too bad, but so be it. I think that's at least my take on this. So I would push back against the idea of a norm quite strongly and argue that we may need to be doing more. Indeed, I've argued publicly that we should be doing more than we are currently doing, because to continue to do less is to send signals to our adversaries that they clearly think they can. That it is in their interest to do the building up that they're currently doing. I think it would be very helpful for the prospects of arms control negotiation, among many other things, to send a signal to them that, hey, by the way, that's actually not in your interest, and here's a concrete reason why your lack of restraint is not a good idea for you. And the only way to really concretely send that to people who don't care about norms or laws is to present them with a counterpoise capability that they don't like. We're not very good at doing that in the present era, but I think we can do better. Thanks.
All right, and in a minute, I'd like to come back to Dr. Kimball on this question on diversity of weapons, particularly potential increased risk from low yield weapons. But first, I want to turn back over to our other panelists for comments. I'll turn to you, Mr. Christensen, first.
Yeah, thank you. So quantifying risk, of course, I totally agree here with Chris that this is very difficult. And if anything, the 50-50% in the Ukraine crisis that was quoted, in a way, says we had no idea. It was like it go either way. But it's bad. It's worse than it was, et cetera. And so the question is, what do you do about this? And it's not just about Russia. It's in general sort of posturing and deterrence a relationship. And here I think it illustrates really well, in my view, this conundrum we have about deterrence. That not only are risks very difficult to quantify, but so is deterrence. It's very difficult to quantify and specify what works in terms of deterrence. And I don't think that the need for that deep analysis is very well reflected in the public debate today. Therefore, so we see these, what I consider very simplistic, reaching for new regional nuclear capabilities in order to reassure allies better or deter, adversaries better and something like that. And I think that the nucleus LEACM is a nuclear sea-launched cruise missile that has now become a program of record, is a good example of that, I think, where there's sort of we don't know what to do, so let's reach for this, then at least we have something to show. But I also want to remind people that if and when they get this LEACM out there, and it's on the submarines, and we've been talking about it for some time, and we discovered that the adversaries do not change their behavior to anything better, and the allies do not feel more reassured, then I think the very same people who argue for the LEACM is needed now to do those things will be up there arguing for the next nuclear weapon. And this is sort of the futility of sort of numerical and icon deterrence, in my view. And I also think it misses the point that the way, my understanding of the way U.S. Strategic Command does deterrence operations today is significantly different from the way it was done during the Cold War. There are, of course, many, many parallels, but it is certainly not just nuclear. And the response is not just about even a military response. Anybody who has read the preamble to the current nuclear war plan will understand that. But I don't think those realities and those changes that have happened are reflected very well in the public debate. And then also, of course, just a reminder, the US is not very well postured to take on the Russians and the Chinese in a nuclear kind of arms race today. So we sort of have to think carefully about how we do what we think we need to do on deterrence operations and reassurance before sort of walking too far down that path. So that would be sort of my 10 cents here.
All right, thank you. Dr. Smith.
Hi, I apologize. It seems like my video is completely blurred out and I can't
That's
correct
we got you good on audio, so that's okay.
Okay. I guess that's what matters. So I just wanted to add, I think there are, there are two different ways to think about nuclear risks. One is about related to the growing arsenals and diversity of weapons and changing of postures that could put those weapons in the hands of more and more people, right? And as you go in that direction, the theory is that because of human fallibility, eventually, the risk grows that there will be accidents, miscommunication, inadvertent use or unauthorized use of nuclear weapons. That's one way to think about risk, and I think those are very real as we see changes in postures and countries begin to adopt new doctrines and incorporate new capabilities into their militaries. I think those risks are, in my mind, clearly growing, especially during times of change. The second way to think about risk is whether or not leaders are contemplating or increasingly considering using nuclear weapons. And I'm not sure, again, I don't know what, how to agree with all my colleagues. I don't know how you account for that. And to be frank, I find it, paradoxical the way, that, along with the paradox of the nuclear age, which is, presumably as the risk of nuclear conflict grows, it's going to have increasing sobering effects on decision makers and how they behave, and to get them to back away from taking actions that could precipitate the catastrophe, right? And so that is the challenge of the nuclear era, is that only through credible nuclear use and increased risk, right? Nuclear deterrence is inherently about risk and dangerous, right? And of course, it only needs to fail once to be, a terrible event, historic event. But it just occurs to me that as the perception of risk grows among leaders, that there is potentially an equal but opposite inclination to do things among leaders to that would push us toward that threshold. So one level, so just kind of recap that, on one level, I think risk is potentially more identifiable in terms of the growing numbers, diversity of weapons and different nuclear command and control arrangements to operationalize different nuclear strategies among the nuclear armed states. And those changes are introducing new risks that we're pretty, that are unfamiliar. And then there is the risk that we are approaching nuclear war, and I'm not, purposeful entry into nuclear war or nuclear attack by leaders, and I'm not sure that is the case.
Okay, thank you. I want to return to this question, give Dr. Kimball a chance to respond kind of on the question of diversity, because a lot of the discussion recently has surrounded, some people call them tactical, low yield, variable yield nuclear weapons. And then you mentioned the sea launched missile. So this question of diversity, in what ways might that increase risk? And if so, should there be some sort of a norm against development of new types of weapons?
Well, I wish I had a PhD, but I don't. But thank you for the compliment, I guess. I'm Darrell Kimball, Executive Director. That's all right, Jeffrey. So Hans started talking about the push by the U.S. and others to develop additional capabilities like the sea-launched nuclear-armed cruise missile that provide the president with more options to respond to adversaries in a regional conflict. To make the idea behind this from a nuclear deterrence standpoint is we're making nuclear deterrence more credible by providing the president with options to use nuclear weapons in a more tailored fashion. We're not resorting to all-out global nuclear Armageddon. Russia has been doing this too, of course. The Chinese are doing this too. North Korea has been doing this too. Pakistan, India. The challenge, I think, is that there's a paradox. If you make your threat of nuclear weapons more credible, it can, on the one hand, deter your adversary from launching a conventional attack or a nuclear attack, but it can also, it lowers the threshold for nuclear use. It gives leaders the sense that, okay, I can employ nuclear weapons in a situation in which my side, my forces might be outnumbered, outgunned, might be losing, might be defeated if I don't resort to nuclear weapons, and I have this option. So, I mean, and once nuclear weapons are used against another nuclear armed state, as we all know from history and from common sense, there's no guarantee that that nuclear use can be limited, that it can be controlled, and it will not escalate into all-out nuclear war. So I think we need to look at this trend with a great deal of caution. In my view, it increases nuclear risk in the long term. It leads to action-reaction dynamics. So that would be my take on this, Jeffrey. And I think one other factor I hope we can come to in this discussion, because Shane brought it up very briefly, but the emergence of new technologies in the militaries of the major nuclear powers, hypersonic weapons, the introduction of automated systems, artificial intelligence. One of the things that this will do, according to many of the analyses about the impact of these weapon systems, is it will reduce the amount of time that decision makers have to assess what's happening on the battlefield in a hot war. And so it has the potential to compress the decision time. This can have a negative effect on decisions regarding nuclear use and escalation. And finally, I mean, there is the question, which is now a very live question in the US, China, to some extent Russia. To what extent do we employ artificial intelligence in our early warning and our nuclear command and control, or not? And operationally, how does that work? And how do we make sure that humans are the ones who are really making decisions about nuclear use, and not AI algorithms that are developing options for the decision makers and perhaps confining the choices to a much more limited set of choices that could lead to catastrophic outcomes. So that's another important issue for those who are responsible for these operations. It's an important issue for the policymakers, and I think for the legal profession as it regards who is responsible, who is accountable for these decisions that could lead to nuclear escalation and use.
Okay. And we'll come back to that question in a minute, but maybe let's turn towards a slightly potentially positive note on arms control. We've heard a couple mentions recently that Trump's remarks regarding denuclearization. What are some of our options for the future as it relates to arms control? Are there, do we have some path forward that we can see that where we might be able to increase despite all of this uncertainty that exists? And I see Mr. Christensen's hand go up, so I'll go ahead and go to you.
Yeah, I want to do a little preemption here by raising my hand very early. All right, before I get into that one, I just want to say a little thing about TAC nukes and low yield nukes, because unfortunately, in my view, that the public debate is so simplistic about that. It's as if it's sort of a different thing. It's as if we don't have it. It's as if it would solve a particular problem. Here, I think right now, today, we have loads of low yield options in our stockpile. And they range from aircraft delivered, both gravity bombs and cruise missiles, and most recently also some small number of low yield warheads on the Trident submarines. So this notion here that by adding more to that, to the arsenal, you can sort of influence the adversary's behaviors, I think at least is something that should be discussed. And I don't really think it is. My problem with that issue is not the yield. I mean, in my view, the yield is somewhat irrelevant, because I think the nuclear weapons are given their yields based on whatever mission they have to serve. And, if it's a hard target, you will find these systems that have low yield options don't just have low yield options. They have a range of options in terms of the cruise missiles and the gravity bombs. So it's way too simplistic a debate in my view about whether those things are needed to make a difference or solve an issue. On arms control, my remark is that it obviously will have to change in the sense that now it has almost all fallen away when it comes to numerical limits on forces. And this is the biggest problem, that if the strategic force level limit falls away, we're entering a phase where it is inevitable, of course, that the militaries will begin to plan worst case scenarios that involve larger numbers of weapons, and that begins to happen. So I think it's very important that in whatever shape or form they reach this, they reach some form of an agreement. If it's a handshake agreement, that's fine with me, but under the circumstances. But I think also the problem with arms control is that during the Cold War, arms control came about. It didn't sort of drop off the tree or fell from the sky. I mean, it came as a response to nuclear risks, specific nuclear risks. How to manage them, how to react to them, how to limit them. Then when the Cold War ended, instead, nuclear arms control shifted to become sort of an instrument, if you will, for a managed drawdown of excess forces. You know, how can we know that we're doing this in a verified way, and we're going to low deep cuts, and you know, all that stuff. And now it's shifting back again to this sort of arms control potential in the future, becoming a way of managing nuclear risks. And here, numerical is one way of trying to do that. That is one way. There are also potential ways that relate to operations, incidents, notifications, things that are not sort of, you know, up there with the heavy numerical arms control agreements, but nonetheless, in some shape or form, can help sort of massage the environment, so to speak. So I would stop here with just a pitch for those two things.
All right, Dr. Ford.
Yeah, thanks. I'd love to pick up on that because I think Hans gave us some really interesting stuff to chew on, which is really valuable. But let me just quickly say also, with respect to adding capabilities, you know, the issue, of course, if the objective is deterrence, the issue isn't, of course, whether or not adding X capability, you know, to our toolkit would, you know, would concern or be of interest or would deter, you know, Hans Christensen or Chris Ford or Daryl Kimball or Shane Smith, right? The objective is to figure out what kind of capabilities would, in effect, push the adversary's buttons in ways that would conduce to more moderate behavior. That's a factor that you know, we certainly should be considering as we evaluate what sorts of capacities to build for ourselves. That's a hard question to answer, and it's necessarily somewhat speculative. But I think you know, this needs to be taken through the prism of how we understand the adversary's decision calculus to be working. But on the issue of what's available in arms control, one sort of moderate expectations point and one optimistic point. The moderate expectations point is that we not forget as New START comes around to expiring, and potentially people talk about what might replace it. We shouldn't forget what I call the China shadow here, and that is that the growth of China's capabilities and the need of U.S. planners to be able somehow to have a posture that works adequately well against potentially both of them at the same time, even that's going to provide, I fear, an unavoidable limit on what range of things might be possible with the Russians. If China, you know, had stayed at its prior, you know, very modest nuclear posture, you might imagine it being very possible for Washington and Moscow to agree upon, you know, at least some continuation of nuclear limits, conceivably even reductions, who knows, but certainly limits. With China doing what it's doing in terms of its extraordinarily large nuclear buildup, I think that's going to necessarily put a big brake on the range of numerical things that would be agreeable, if you will, and available as options with respect to Washington and Moscow talking to each other. That said, I think Hans's point about you know, things like notifications and dealing with incidents and things like this nature, that, you know, sort of transparency and confidence building measures, you know, to use some of the arms control jargon, there may well be some interesting potentials there. You know, it's hard to say exactly what, but you know, you could imagine a multilateral launch notification treaty with the development of communications links, you know, equivalent to what we in the U.S. describe as the NERC, the National Nuclear Risk Reduction Center communications process. You can imagine incorporating, you know, the three major powers, Russia, China, and the United States, into some kind of a thing like that. Even that kind of arms control is not foreign to the Chinese. I believe they have an actual launch notification agreement of some sort with the Russians and have had it for some years. So this is not, terra incognita as far as either adversary is concerned. And there may be some things that we can do that would be a useful way to put our foot back into the water and get people accustomed to engaging with each other once more on arms control stuff. I suspect it won't be numerical very easily or very quickly, but there may well be some really useful things to do. And grateful to Hans for pointing that out. Thanks.
And thank you for kind of pushing us in the direction of risk mitigation and some of the things, instead of just, pondering on all the different risks that are out there, moving towards how do we mitigate some of those risks. So as I knew would happen, this panel is flying by, and there's so much to unpack. I want to turn it over to Mr. Kimball and Dr. Smith, because they had their hands up, and hopefully maybe as part of your remarks, you can include something related to kind of these emerging technologies and now how they might affect both increases of risk, but also might mitigate risk. And then we're going to close it by giving each of our panelists a few minutes for closing remarks. So I'll turn it over to you, Mr. Kimball, now.
Okay, well,
Jeff, let me mention, we also have a couple audience questions you might want to try to work in.
Okay, yeah. So hopefully we'll have a couple minutes at the end and we can get those in.
all right. Well, I will. I raised the question of new technologies. I'll leave it to others to try to answer some of that. I just wanted to very briefly weigh in on the question of what arms control options are available. And I think, Chris just offered some good ideas about risk reduction dialogue between the U.S. and China. I would note that there is a 5-party conversation, the P5 dialogue, that currently is ongoing. That's chaired by China. That is an opportunity for the 5 NPT nuclear armed states to engage on issues related to nuclear postures, risk mitigation. That may be an opportunity in the next year or two. This was the group that issued a statement about nuclear war cannot be won, must never be fought. They might discuss how to expand on that. They might look at the 1973 US-Soviet agreement on preventing nuclear war. But when it comes to nuclear arsenal sizes, Chris has flagged one of the key questions that is going to be part of the debate in the next couple of years. How many nuclear weapons does the United States need to deter 2 so-called near-peer adversaries? On one side of the debate are those like Chris who would say that the United States needs more nuclear weapons to deter 2 countries with similarly sized arsenals. There are others who would say, and I'm one of them, the United States has a sufficient number of nuclear weapons to deter the US and Russia, even if China increases its arsenal substantially. More nuclear weapons are not going to change that equation. So the outcome of that debate will have implications about how long the United States and Russia can maintain their current limits under New START. If the United States increases its arsenal, the Russians are going to reciprocate, and China will likely accelerate its buildup. So we need to think about how to manage these things. I think one of the most important things President Trump could do in the next 2 years is to reach an informal agreement with Russia not to increase the US or Russian arsenals beyond the New START levels of 1,550 deployed strategic nuclear weapons, so long as the other side does not do so. As the US tries to engage with China on risk mitigation and asymmetric arms control options, not necessarily numerical number matching. So let me stop there, and so we can get to some of the questions and the other comments.
Okay, great. And so we do have a couple questions. The first one relates to legal structures and constraining nuclear risks from nations who don't recognize or intend to adhere to international law. I'm going to ask that we put a pin in that one because I know we have several panels following that are going to address those very questions, unless one of the panelists want to address that. And then the other question has to do with the mushrooming nuclear proliferation that President Kennedy feared, and whether or not that we might be the risks are there increasing risks for first use? And so what I'm going to ask is I'm going to go ahead and turn it over to you for your closing remarks. And then if somebody wants to address one of those questions, you're welcome to address that as part of your closing remarks. So I'll turn it over first to Dr. Smith for your closing remarks.
Great. Well, thank you again for inviting me to be on this panel. I would like to associate myself with all the comments from my colleagues. I really, I couldn't agree more with many of the things that they said, and just wanted, and in fact, Dr. Ford stole a lot of the from the words that I was going to offer on the prospects for the future of arms control right out of my mouth. But I would just, highlight that, not to dampen spirits more, but Russia and China have to date been pretty resistant to engaging in conversations about the future of arms control. I think Russia sees it in its benefit to increase the perceived risk, nuclear risk on our part, to leverage in advancing its aims in Ukraine and more broadly in Europe. And China, I mean, if I recall correctly, right, we offered, State Department released a report not that long ago, maybe 4 or 5 months ago, that it had proposed some pretty modest confidence building measures, risk reduction measures with China, and that it's still yet to respond to those proposals. And so I think there are things that we can do perhaps moderately to try to build some confidence, but with both Russia and China, that can hopefully build toward more robust arms control. But right now, I have not seen a willing partner in either capital. Now, perhaps President Trump, has the key to unlocking some of that, and again, it's good to see that he has raised it as a focal point for his administration early on. But my level of confidence is cautiously optimistic, I guess. I would just like to address that last question about the ballooning proliferation, the concern that President Kennedy had. I think I am concerned as well. I mean, I think a lot of the countries that were projected to develop nuclear weapons at that time were countries that are now fall under the U.S. nuclear umbrella. And I think there is decreasing confidence in the credibility of those related security commitments, and that could lead to a growing number of countries developing their own independent nuclear capabilities. And does that move us increasingly toward the potential of someone actually using them first? Well, like I mentioned earlier, I'm less confident in weighing in on the increased risk of decision making that could lead to such catastrophic consequences. I'll leave it there. Thanks very much.
Thank you, Dr. Smith. Mr. Christensen.
All right, there was the button. Yeah. Yeah, thanks very much. And again, very much appreciate not only the opportunity to be here, but also the comments that have been made from my panelists. And I cannot wait to hear the rest of the panels here. It's very rich conversation. If you will, my sort of final words here would have to be something, about what are we facing here in the next several years, in the foreseeable future. Starting off with deterrence. My appeal is be smart on deterrence. Don't be sort of chest thumping type of deterrence. Be clear and succinct and cool-headed about what it is that is likely to affect the decision of the leadership in the adversary countries. That's the key here. More numbers will not fix the problem. In fact, it might even make it worse, because certainly in the case of China, it could further stimulate even greater increase, not necessarily numbers, or even that too, but even in capabilities. We don't want the Chinese to also start to develop all sorts of tactical nuclear weapons from the regions. They have some that we're concerned about already, but so we don't want to go down that path. So be smart about deterrence. What are the different whole of government, the menu of things that can be used to influence adversary decision making. And again, and then finally on arms control, I think there is a broad range of hypothetical possibilities, of course, on this. We benefit from an enormous amount of history, lessons learned, technologies, interactions on this. There's a wealth of history to draw from here. But of course, it comes down to this. If there's political willingness to do something, then everything is possible. And if there's not, you can forget about it. So it's just that, we can't roll out and sort of say, you Chinese, you're bad. You should be part of arms control. If not, then it's an outrage, and therefore we don't. We have to find out something that, if we want to engage them, if we want them to sit at the table, what is it that we're willing to trade, what we're willing to offer them in an arms control or arms control-like kind of arrangement that is in their interest? Nobody goes into arms control agreements unless there's something in it for them. So instead of pointing fingers, I think we spend a lot more time on trying to figure out, what is that linchpin in the case of the Chinese? Where is it that we can start engaging in something that they want? Other than that, I think it's a fruitless exercise. Thank you.
Thank you. Mr. Kimball.
Well, thank you. Well, just let me reinforce what Hans just said about the immense importance of effective diplomacy. I mean, this is our best weapon, if you will, to reduce nuclear risks and to reduce the risk of nuclear war. And the last decade or so has seen a deterioration of U.S.-Russian relations. The leaders have not been able to get to the table to have effective, meaningful conversations, Democratic and Republican administrations. A lot of this is because of Vladimir Putin and especially the war against Ukraine. But it remains in the U.S. and the Russian, and the U.S. and the Chinese interest to engage in meaningful dialogue on nuclear risk reduction and ultimately arms control and disarmament. Right now, there is more interest on the part of Russia in talking with the United States. We will see discussions between President Trump, President Putin, and their close advisors on the issue of Ukraine. And in the context of that, there will be opportunities to discuss how the two manage their two countries' delicate nuclear relationship. So I think there will be opportunities for discussions. How ambitious the two can go, I don't know yet, but there will be dialogue. Last thing let me mention, since one of the questions that you brought up, Jeffrey, was the risk of further proliferation to additional countries. Just a quick word. And this is a serious issue of international law. I'm not sure if you'll be able to cover it, but the most likely next nuclear armed state could be Iran. And the breakdown of the 2015 agreement, the JCPOA, Iran's buildup of its capabilities put us in an extremely delicate situation right now. By the end of this year, it is possible, if not likely, that the US and the E3 will snap back UN sanctions on Iran if Iran does not curb its nuclear program. The Iranians say they want to engage with the US on the nuclear file. The Trump administration, half of it says they want to do this. We don't know exactly what their plans are, but this is going to come to a head by the end of the year. And there are possibilities for a breakthrough. There are possibilities for catastrophe. And I would just note that, Iranian leaders have threatened that they will pull out of the Nuclear Non-Proliferation Treaty if sanctions are snapped back through the UN Security Council. And it becomes once again an issue for the Council to resolve. So watch that channel. That's something that we're particularly concerned about. We should all be focusing on diplomatic solutions for. So thank you very much for this session.
Thank you. And Dr. Ford, you have the last word.
Thanks very much. I'll try to be brief. Kudos to Daryl for bringing up the Iranian issue. This is obviously a huge question, and the time, just to stress that the time is really short for coming up with constructive approaches, because the option of snapback, which I would strongly support and I think is really indispensable for giving us the negotiating leverage to engage with Iran on a more enduring answer to this problem. There's a time clock running on that, because Resolution 2231 will disappear in October. It will itself sunset, to use some old JCPOA jargon. So we need to figure this out, and we need to figure this out really quickly. That doesn't mean a deal needs to be arranged before October, but it means that after October, if snapback is not taken, we lose the leverage that it would provide. And the way that the Security Council is structured right now with the Russians and the Chinese is very, very likely that the UN will be a non-factor in a solution to the Iranian problem after October, unless there is snapback in place, in which case the Security Council will become important, and it will be Iran's task to negotiate with credible compromises to negotiate its way out from under those sanctions. So yeah, watch this space on Iran. That's going to be extremely important. With respect to with respect to comments made by one of the previous panelists, I think we spend too much time telling Russia and China what it is in their interest to do with us. We need to do more to lead them to the conclusion on their own, rather than just having us be lecturing about what their interests are. I think what we can and should do is give them a reason to want to engage in talks aimed at negotiated reciprocal restraint of some sort with us. And that means putting ourselves on a trajectory that makes it clear to them that if there aren't such talks, things will be, from their perspective, as they see the world, materially worse and more complicated and more challenging place. And that's what deterrence is about, and that's how deterrence can be leveraged into arms control and perhaps even into nuclear reductions. With respect to more numbers, I agree this is not a magical solution, but I do think that it may well be that at least some degree, and I'm not urging 1 for 1 for goodness sake, but I suspect that some degree of numerical augmentation of our posture may well be useful in order at least to buy us a bit of time before China reaches parity. So that we can think through the conceptual challenges of how to handle the so-called 3-body problem of 2 near-peer deterrents. No, it's not a magical answer, but it may be a bridge that helps us get to a better place of being able to handle the challenge and to do so in a negotiated way. On non-pro, generally, I would agree with the comments made before. I think Shane brought this up quite correctly. Historically, U.S. extended deterrence, that's not just nuclear, but including conventional, but extended deterrence by the United States has been the most powerful non-proliferation tool ever since the dawn of the nuclear age. We risk losing the impact of that tool if we don't do more to buttress our ability to deter aggression and to deter nuclear threats as a tool of aggression. And very finally, in response to the really excellent question about so what do these legal things mean? I'm going to have to drop off and won't be able to listen to all the rest of this conference, but just to offer some, to stir the pot a bit, I guess, for your all's future discussion today. I think it's pretty clear that the legal structures and approaches that one can take to nuclear weapons, which will be very much the topic of what we're discussing, or you all are discussing later today, they are not nearly as relevant, I fear, as we lawyers would like them to be. But I do think they're relevant in one sort of backhanded way. I think our approach to nuclear morality and our approach to nuclear legality is very relevant to how our adversaries structure their approaches to us. Not because our adversaries care about those things. I think very unfortunately they don't particularly, but because they know that we do. And I do think you see, especially in Russia's approach to nuclear threat making and saber rattling, you see an approach that is designed to weaponize our nuclear neuralgias and to push our psychological and political buttons with nuclear threats and nuclear risks in ways that they believe will allow them to accomplish more in their aggressive strategic agenda. They think that the more they rattle that saber, that we are so afraid of talking about nuclear deterrence and about and so afraid of their manipulation of nuclear risks that we and our allies and partners and friends will be easier prey for them. That's a huge challenge for us to manage from a deterrence perspective. And I fear that they have assumed, they've baked into their strategy that we are perhaps almost dangerously afraid of being engaged with them in the unavoidable nuclear risk management that is deterrence. So that's going to be an interesting challenge for us to have to struggle with in the years ahead. Thank you very much for having me as part of this discussion.
Thank you, Dr. Ford. And thank you to all our panelists. There was so much we wanted to talk about that we knew we wouldn't be able to get to everything. But I think it does serve the point of this panel and this conference, and that's to set the stage, provide context to all the following discussions that more narrowly focus down into those legal issues. So our panelists did that outstandingly, so I want to give my great appreciation to them. And with that, I will turn it over to Professor Moxley.
Thank you so much. And this discussion did give us a lot, which we'll integrate, hopefully, into the legal discussion. So thank you all. We now have 10 minutes. So let's come back at 11:20. And in the meantime, let's let panel 2 come on stage here and get organized. And John Burroughs is the moderator for this panel, who will now lead us forward on this.
Good morning. My name is John Burroughs. I'm senior analyst with the Lawyers Committee on Nuclear Policy. As I think you can see in your screen, this panel will consider the application of international law to potential uses of nuclear weapons, practical considerations as to how it works and should work. And our panelists are Lieutenant Colonel Travis Lieb, who's Deputy Staff Judge Advocate at U.S. Strategic Command, Professor Sean McElvey, Assistant Professor of Law, U.S. Air Force Academy, Professor Charles Moxley, Professor at Fordham Law School. He's an arbitrator, and he's also author of a recently released book, Nuclear Weapons and International Law, Existential Risks of Nuclear War and Deterrence Through a Legal Lens. Finally, Alan Weiner, Senior Lecturer in Law and Director of the Stanford Program in International Law. So, Travis, we're going to start with you on the role of legal advisors, and if you could explain how the lawfulness of weapons, nuclear weapons, is assessed from design to acquisition to use. And I asked you just to spend a few minutes on this, like no more than 5 minutes, please.
Sure. Thank you very much, Dr. Burroughs. I really appreciate it. And before I get started, I just want to thank the New York Bar Association, Fordham, Professor Moxley, Professor Biller, and all the rest of the folks for being here today and inviting me to join you. I really appreciate it. I'm honored and humbled by the opportunity. And also, before I begin, I should probably say that the views that I express today are my own, not necessarily those of the Department of Defense, United States Strategic Command, the United States Army. So yeah, any mistakes that I make are absolutely owed solely to me. So how do we take a look at the lawfulness of nuclear weapons? And really, it starts from inception all the way through potential execution. So at the very beginning, when someone has the idea of a new capability to deliver a nuclear weapon, legal advisors are working with those folks that are designing the weapon at the very beginning, like I mentioned. They will work with the designers of the weapon to understand exactly what the intent is, what need we're trying to fill with that weapon, because it will have to go through a legal review to ensure that it would be lawful under the law of armed conflict if it was to be used. And so understanding that intent, how the weapon is designed, how it's supposed to function is critical for that legal review. And that has to be done whether it's a nuclear weapon or any other sort of weapon that we would look to employ by the military. There's a Department of Defense instruction that actually covers that. And please don't ask me which one it is, because unfortunately I can't quote it off the top of my head right now. But it is set out by both law and policy that we do that. And then as to how we employ those nuclear weapons, again, legal advisors are involved at the very beginning of the planning process for any sort of campaign or operation that could potentially use nuclear weapons, to work with those planners to understand exactly what the commander is looking to accomplish throughout the campaign. I know it was mentioned in one of the previous panels, that if the goal there is to control escalation, contain it to one theater of operations, that's exactly how we'll help the planners try and craft things. Moving then into the targeting process, again, we're involved at the very beginning of identifying potential targets, helping the targeteers nominate those targets, and then working with them to understand what potential weapons might be used to exercise those targets, and then through the nomination onto a target list, and then in the event it's called upon for eventual execution, there'll actually be a legal review that's conducted prior to execution, because all the legal reviews that we may have done before that are dependent upon the ultimate legality of using the weapon is dependent upon the facts that are operating at the time. And so, we'll work to gather as much information as we can from the folks that know it. Oftentimes it's that intelligence section to understand exactly what the facts and circumstances are prior to employment of that weapon. So hopefully I didn't take up too much time, Dr. Burroughs, but that's kind of a quick thumbnail sketch of how it works in the real world.
Well, thank you. I appreciate that. And I think that the public is not necessarily aware of the role of legal advisors. So I think that was a good thing to start with. Now, we're going to first go through several questions that relate to bases for legal analysis and decision-making. And I'll lay out the questions in brief form in just a moment. And I'd ask each speaker to spend something like 8 minutes, and that should give some time for discussion of the issues that are raised in this phase of the panel. So briefly, these are the questions. What potential effects of the use of a nuclear weapon are or should be considered by legal advisors and decision makers in assessing the lawfulness of potential uses of nuclear weapons? There's blast, fire, and firestorm radiation, electromagnetic pulse, climate effects rising from damage to civilian infrastructure, the risk of escalation. So how are those effects considered? Second, and related, how certain must legal advisors be and decision makers be of various potential effects of a potential use of nuclear weapons for the effects to be relevant to their assessment of lawfulness? Third, what information do legal advisors and decision makers need to have to make the assessment of whether the use of a nuclear weapon would be lawful and whether the weapon's use may proceed in the absence of such information? So, Travis, we'll start with you.
Sure. Thanks a lot. I appreciate it. For the use of any of these weapons, not to some folks may take a look at nuclear weapons and look at the scale, the destructive force of those weapons, and think that there's probably this intricate analysis that has gone through, and there is definitely a lot of nuance to it, but for the most part, it comes down to the four principles under LOAC, really, I guess five, but four for the most part, of necessity, distinction, proportionality, and then humanity. For the types of effects that you were asking about, Dr. Burroughs, really goes into proportionality and humanity. And we are fortunate enough that we work with some really, really smart people inside the Department of Defense and here at United States Strategic Command, so we can capture many of the effects that you were talking about, whether it's the blast, the fire, fallout, the potential plume, the radiation plume that could go along with it, EMP. So those physical effects that go along with it, and that's worked into the initial targeting that I talked about before. When a target is initially proposed to go on to a target list, all of those things are factored in there, so that when a decision maker looks as to whether or not that target should go on the target list, we, as the Office of the Staff Judge Advocate, have taken a look at that potential target under those four principles, and determined that, yeah, at a very basic threshold, it does meet those requirements and could go onto the target list. Now, we also use that to tee up that conversation with the decision maker in there as to General Sir or Ma'am or Admiral Sir or Ma'am, with this weapon system, here are the likely effects and outcomes that you could have. But under proportionality, do you determine that with this target in the notional scenario that we have right now, do you think that the expected incidental harm is excessive in relation to the concrete military advantage to be gained? And walking through many of those same concerns that we can model fairly accurately.
To determine, do you guys still have me?
Yes.
Okay, good. To determine whether or not
and that may
Now we lost you, Travis.
Oop.
okay. Do you still
Okay,
have
you're back.
Okay. All right. So as I was saying, proportionality absolutely take into effect many of those things that we were talking about before. With the fallout and blast, EMP, those sorts of things in there. As far as humanity, though, or unnecessary suffering, it can't be excessive in relation to the military advantage to be gained. It can't be, the destruction, I should say, can't be unnecessary to accomplish that legitimate military purpose. So we can't be destroying something just for the sake of destroying it in there by using that weapon. But yes, we take a look at the potential effects that could happen, whether discreetly for that one target or as a whole, depending upon how many targets are actually going to be exercised within that package as well. To the second question that you had in there, what standard do we use? And that's something that I like to remind my fellow legal advisors that I deal with, whether or not it's at the Joint Staff here at the Combatant Command or at the Office of the Secretary of Defense. under the law of war, the standard for that commander is reasonableness. So if we are going to object to something, essentially what we have to say is that no reasonable commander could determine that it was lawful under proportionality or humanity. So it's somewhat of a low bar in there for that. It's not clear and convincing. It's not beyond a reasonable doubt. It's just, could a reasonable commander get there on it? And I think that some folks, whether they want to or not, at least from a legal advisor perspective, we shouldn't be imposing a higher threshold on those commanders. Allow the commander to have the freedom in there to have discussions with other decision makers, whether or not they want to exercise that target. For example, in 2015, President Obama issued the presidential policy guidance, which for some terrorist strikes on terrorists outside of an area of active hostilities, the president was requiring near certainty that you were going to hit the target you were looking at and that there would be no civilian casualties with it. Well, that was done as a matter of policy, but not as a matter of law. And the decision makers, the president and other folks, are free to impose those obligations on the military, but it's not necessarily done from a legal perspective. And then finally, you had asked about what information is considered in there. And with that, we're trying to get our hands on as much information as we can. So the most accurate intelligence that we have available, whether it's in real time or near real time, the modeling that I talked about before as to potential impacts of those strikes. What's the current weather over the target, and what do we forecast the weather to be when the munition will be delivered? Because all of those things are going to play into the effects on the ground once we actually use that weapon. But no, we take as much information into account as we can. And the biggest thing in there is that we are not excluding information just because it's inconvenient for us in there. It doesn't go towards what we'd like to do. We can't be willfully blind to information that is out there. We have to take into account all information when we're evaluating that target under the LOAC principles. At that, I see that my time is almost done, and I'll turn it over.
Okay, thank you. Professor McElvey.
Well, very much appreciate being able to be here. I call this portion the bait and switch. For those that may have read the program about a week ago, you would have seen Professor Mike Schmidt listed in this block. And while he and I may have some similarities as far as where our careers started, both as Air Force JAGs, also both as professors at the Air Force Academy, his trajectory has taken him to become one of the giants in the field of IHL. So I apologize for those that were hoping to see him. He has big shoes to fill, and my size 10.5s are going to do the best job they can here today. So one of your questions, your very first one is how are we to consider effects? And I think the first part of the answer is it depends on where you're from. And I say that because when we look at national positions, treaty obligations, and practice, we may see a divergence in some of these areas, especially when we talk about whether we call it the reverberating effects, the knock-on effects, those effects that might be foreseeable or those that may be so remote that it become difficult to adequately determine how do we approach those things. And so I think it's important to at least initially appreciate that we may approach this from different perspectives by given the uniform that we happen to be wearing or the organization that we may be representing. So effects. If we look at U.S. policy in the DoD Law of War Manual, we look specifically at foreseeable harms versus remote harms. And when we look at foreseeability, we try to do our best, as Lieutenant Colonel Lieb has mentioned, in gathering the maximum amount of information possible before making any decisions on the employment of weapons, employment of force, and things along those lines. So I think this conversation, and I hope it does sort of branch out into some of those greater effects. The International Committee of the Red Cross, for about the last 10 decades, have had this on the sort of the agenda for all of their international conferences. Looking at both explosive, remnants of warfare and in an urban environment, as well as nuclear, weapons and nuclear war. So I commend the Bar Association and everybody that's on these panels and that are tuning in, that are still shining the bright light on this question and on this issue, because I think it is of utmost importance. As far as certainty goes, the last panel walked us through the evaluation of risk. And if there was anything that I could take from those eminently qualified experts in the field, it's that who knows? Who knows what the risk of escalation really will be? My good colleague, Jeff Biller, who was our moderator last panel, has recently finished a piece asking the question of whether or not the idea of retaliation, a retaliatory strike, the escalation of nuclear weapon use, if that must be or should be moving forward, an item that we would conduct as part of a precautions under the proportionality analysis. In other words, if we're able to determine whether or not the adversary is likely to use those in response, then perhaps we must calculate that into our overall proportionality analysis and take effective precautions to avoid those greater risks. But given the talk from the previous panel of the difficulty of actually assessing whether or not there will be an escalation, I think that question of certainty, Dr. Burroughs, becomes a very tough one. What is the certainty of a response, the certainty of escalation, and how might we, or those that are in uniform advising commanders, or those in the Oval Office or the Situation Room advising a president or head of state, take those things into account before making any strategic decisions or tactical ones for that matter. So I think that's an important thing that we can kind of maybe peel back as a group here and continue to discuss. And then as far as what information do legal advisors need, as a former legal advisor, as a person that has sat inside Cheyenne Mountain, a place that is not too far from me right now that I imagine others might want to target should we ever see a nuclear war. I would echo what Lieutenant Colonel Leib has mentioned, maximum information on all facets. We're going to want to know technology, technical aspects of the weapon system. We're going to want to know the medical implications of the use. We've already heard people mention at least the initial effects of whether it be blast, intense heat, firestorms, and then certainly radiation and the long-term consequences thereafter. Whether they be to human beings that walk this earth or they be to the environment that we stand on. Those effects are things that certainly we should be asking the question with those smart people that Lieutenant Colonel Leib mentioned, at least from a U.S. perspective, and be trying to seek maximum information before making any decisions as part of that robust legal review process that the U.S. does by matter of policy. Additional Protocol 1 nations do as a matter of treaty obligation under Article 36. So again, I think I'd love to come back to others with the conversation of the effects question, because I think that's probably the devil's going to be in the details of that one to determine whether or not these weapons could be used in a future conflict. Over.
Thank you. Professor Moxley, Charlie, over to you.
Okay, thank you, John, and thank you, Lieutenant Colonel Leib and Professor McKelvey. This is obviously an important topic. Jeff Biller and I kind of came up at the end of last year's conference with this as the next topic, because the question was, do we need to consider in assessing the lawfulness of a nuclear strike under consideration if one is a JAG lawyer or a lawyer in DOD or Department of State who's asked to opine on these things? What do we need to consider? And I think the discussion has been very helpful. Where I guess we get into a gray area, as Sean, you referred to, foreseeable versus remote. And Lieutenant Colonel Leib, you referred to physical effects and, how one defines and what we consider. The legal issue here, really focused on the law, I take it, is what's the legal standard? And I would like to suggest that the legal standard that what one must consider as a legal advisor or decision maker is foreseeable, non-speculative effects. I think that's the standard. I think that may go a little beyond physical, and I think we may get into a debate. I mean, this is where, the issue arises, I suppose, on direct and remote and so forth. I'd suggest it's foreseeable, non-speculative. And as to what that includes, I take it that quintessentially for nuclear weapons, we know you have the blast and the fire, you have the so-called prompt radiation, you have all the immediate effects. Then you have the radioactive fallout, which is going to happen in every case, however low yield or high yield. There's going to be some radioactive spread, and with higher yield, there's going to be a lot of it. You have these electromagnetic pulses that can shut down electronics across an entire continent. We have nuclear winter. If you have enough nuclear weapons exploded at ground level, you throw up enough dirt and soot, you're going to have nuclear winter. And you have, as has been mentioned, you have the nuclear response to the target and escalation. I would suggest and ask for consideration for Lieutenant Colonel Lieb and Professor McElvey, that if I'm correct, that we need to consider foreseeable non-speculative effects, that we need to consider all of these things. None of them is speculative. All of these effects that we know come from nuclear weapons. And it's just a given that these are the physical facts of what can happen. So is my sense or suggestion of what our standard is it a correct standard? I think the basis for it is just it's throughout our military leadership and international law literature that you look at the rules. They're not limited as to effects they consider. You look at the prohibition of uncontrollable weapons. Their very purpose is to pick up the whole level of effects. We look, Lieutenant Colonel Lieb, as you mentioned, reasonableness. That's the element of all these rules, right? When Jeff and I were talking about, one point that came up before, obviously in a conventional weapon context, I think we've all understood for a long time that we kind of bend over backwards in favor of the military person on the spot, right? There they are. They're in war. They're in this incredible situation that, they have no time and they're acting on reflexes and they have to just act on the information they have, right? But to John Burroughs' question as moderator, is it different with nuclear? I suggest it is. I suggest, and maybe even Lieutenant Colonel Lieb, your point on reasonableness, maybe that needs to be rethought a little in the context of when we're talking nuclear. Jeffrey Korn, in his article, who was a former head, as I understand it, of law of war for the Army, and now he's a professor, and he has an article in a Pepperdine law review where he says, look, the burden of proof, in effect, I think he uses that term, shifts sometimes. And I'm going to suggest that it really shifts when we're doing nuclear, right? Don't we need a higher level of determination of what we're going to do? I appreciate, Sean, your comment on Mike Schmidt. I don't know Professor Schmidt, but I've read his literature. I have the greatest admiration for it as the chief editor of the Tallinn Manual, which is what we need in this nuclear weapons area, right? We need a Tallinn Manual restatement of the law for this area, and I hope some of you all on the inside can make that happen. But Professor Schmidt writing about that, and he had a law review article in the Harvard International Security firm, he said, what do we need to consider when we're applying proportionality? And he answered it in a way that I think, and he wasn't talking nuclear necessarily there, he answered it in a way that I think, it resonated with me in coming up with this standard of foreseeable, non-speculative. He said, look, we have to consider everything we can identify. And that's what the Joint Chiefs tell us in the Joint Risk Analysis and the nuclear targeting memos, we have to consider everything, even uncertain and highly uncertain effects. We have to consider everything. And then the debate is, as Professor Schmidt said, do you discount them based on probability? But I think what I'll finish with, and really with a question for Lieutenant Colonel Lieb and Professor McKelvey, is, we by hypothesis are doing this analysis in advance, right? Before the weapons are used. All we know are what we can foresee. And we know it's foreseeable that we're going to have radioactive fallout, EMPs, we're going to have nuclear winter potentially if there's a large enough number of exchanges, and we're going to have escalation if it's between certainly the U.S. and Russia, as we heard in the earlier panel, the policies that are in place. So, here's the question: how do we assess a low probability risk but a high impact? What Professor Schmidt told us in his Harvard Security Journal article is we have to consider low probability, foreseeable low probability. We have to consider them, right? And so how do we do that? What value do we put, on a 10%, a 1%, a 0.5%, risk of the kind of effect that we heard in last year's conference of, and one of the speakers this morning mentioned it, there was a projection that we could have 5 billion deaths from a U.S.-Russia thing. How do we put a value on that? I mean, and don't we have to value that very highly? And shouldn't that be a real restraint on the usability of these weapons? I think I'll stop there.
Okay, thank you, Charlie. Now, let me turn it over to Alan Weiner.
Well, thank you very much, John, for moderating this panel. My colleagues, Sean, Travis, Charlie, it's great to see you all and to have a chance to listen to you all and learn from you all. And I also want to be sure to thank the organizers of the event, the New York State Bar Association, the various co-sponsors, and a particular shout out there to Cara Forgia for kind of making everything work. I have organized enough of these things that I know that, like, a lot of people are talking about big ideas, but nothing happens if the Zooms don't work, and the schedule isn't set up. So thank you very much, Cara. I want to make, I think this is a fascinating discussion. I want to make just 3 points. I hope they're in the right order. Number one is the role of lawyers generally. The U.S., I think, is unusual among nuclear weapon states, maybe unique in terms of the extent to which JAG lawyers are integrated into operational law planning. That's something that, as a former executive branch lawyer, I spent 11 years working in the legal advisor's office of the State Department, including closely with the Defense Department on various political military issues. And it's comforting to me. It's reassuring that lawyers are involved in that process. One thing I would note, though, I have enormous respect for lawyers with whom I've worked at the General Counsel's office, in the Office of the Secretary of Defense, with various JAG lawyers. I didn't have a chance in my own time in government to work with lawyers at Stratcom, but I've gotten to know people like Ted Richards since then who have been in that role. Again, enormous respect for these folks. That said, I mean, there is a cultural difference in some respects between the way I think State Department lawyers think about the law of war, even the fact that we call it IHL, International Humanitarian Law, kind of reflecting our kind of more kind of European sensibility rather than the law of armed conflict, LOAC. I mean, the minute you hear whether people use the acronym LOAC versus IHL, you can immediately figure out something about their orientation. And I would say that it is military and DoD lawyers who really run the assessment of planning about the use of nuclear weapons. I think State Department lawyers are involved in the nuclear posture review process, but they are not leading that effort. I think it really is lawyers from the Defense Department who are driving the train on that. And certainly, if we ever get to the point where we're talking about operational decisions, it's going to be JAG lawyers, right, rather than State Department lawyers who are going to be involved in the decision making. And I just raise that because I do think that there are certainly some differences with respect to the way that we might interpret our obligations under international humanitarian law, depending on whether you sit in the State Department or whether you sit in the Defense Department. Second thing, a very small point, I teach international humanitarian law or the law of armed conflict, law of war here at Stanford Law School. And one of the things I'm kind of amazed by is we can never even really agree on what the key principles are. I mean, we all agree on distinction and proportionality. And then the question is, wait, does necessity count? What about humanity? But one of the things that I was struck by is that in Colonel Lieb's remarks, he didn't mention the principle of precaution. Which I think we do accept. It's a principle, of course, that's reflected in Article 57 of Additional Protocol 1. The United States is not a party to Protocol 1, but I do believe that we believe the principle of precaution or some variation of that idea is a customary international law rule that the United States is bound by and that accordingly would apply with respect to our nuclear targeting. So to me, that has some significant implications, John, for the question you've raised about what effects do we take into account. Part of what we are concerned about in the context of the use of nuclear weapons is the uncertainty that's associated with at least some of the kinds of effects of nuclear weapons that might arise. And it seems to me that the principle of precaution would induce us to be skeptical about the use of nuclear weapons, right? Even if we're not certain that those things are going to happen, we have a responsibility to reduce that risk under the principle of precaution. So I think the principle of precaution, when we think about direct versus indirect effects or foreseeable harms, I think the principle of precaution, which is essentially a risk mitigation strategy, is underutilized in that analysis. It sort of gets dropped, and we tend to sort of think about the kinds of effects that we should be considering only under the principle, as I think both Professor McKelvey and Colonel Lieb suggested, under the principle of proportionality, where we're trying to think about what the incidental civilian harm might be for an attack that is directed against a military objective. And the third point I want to say is maybe now that I've warmed up a little bit, is maybe the one kind of really substantive point I might want to make, which is I think there's a fundamental sort of tension or even incoherence in the way that we articulate the kinds of harms that need to be taken into account. If you look at the law of war, of the DoD law of war manual, which I commend, it's a wonderful statement of LOAC in many respects. But on this question, the law of war manual says that we draw a distinction between foreseeable harm on the one hand versus remote harms on the other. And what that gets glossed as, what foreseeable then gets glossed as, is as, I'm looking at the language, is immediate or direct. And, I'm enough of a lawyer, trained as a lawyer, thinking about good old-fashioned, tort law, to realize that those are not synonymous. Foreseeable, on the one hand, does not mean the same thing as immediate or direct. There could be lots of effects that are not immediate and that are not direct, that are nevertheless completely foreseeable. Now, the law of war manual language says the reason we don't want to deal with remote harms is because of the difficulty in accurately predicting the myriad harms that might result from an attack. And I think that's right. I think Colonel Leib's statement that the commander has to make judgments that are reasonable. I mean, that's a well settled IHL. The commander has to kind of make judgments about what the reasonably, foreseeable implications or effects of an attack are. But the notion that we construe foreseeable to mean immediate seems wrong to me. It is certainly the case that with some second order effects of nuclear weapons, they are quite speculative. Do we know what the risk of escalation is? I think that's very difficult to predict. Will there be risk of nuclear winter? I think that's quite difficult to predict. But I do think that it's quite clear that some of the second order effects or the indirect effects of the use of nuclear weapons are completely foreseeable. We know a great deal about radiation fallout impacts, and we can model that. Scientists kind of do this all the time. I think estimates of fires, right, are pretty clear as well. And yet, according to some work that has not yet been published, but that's going to be coming out, according to some work, we've actually, some colleagues of mine, Scott Sagan and Unita Delhi, have done some interviews with U.S. government officials. And according to them, the U.S. government does not take into account EMP, climate, radiation effects, right? Even though they are foreseeable, this is where we make the move of interpreting foreseeable to mean direct. So I think that there is room that does not involve like an expansion of our interpretation or understanding of what IHL or LOAC requires. That is to say, to require planners to take foreseeable effects of weapons into account in doing a proportionality analysis. I think under that well-settled rule that I think DOD, JAG, and JAG lawyers accept as the prevailing law, that does mean that there are still secondary or indirect effects that need to be taken into account. In other words, if the reason why we only look at foreseeable effects is because of the difficulty of accurately predicting certain kind of indirect effects, to the extent fallout effects and fire effects are not difficult to predict, to the extent that we have really developed much better research and science that allows us to do so, those factors, in my view, should be taken into account. And then with respect to some of the more speculative effects that are more difficult to predict, where we don't have very, very well-developed models, I would just suggest that it's important to kind of go back to the principle of precaution, right? Which is, even if there are risks of harms that we can't predict, the principle of precaution should require us to try to select means and methods of warfare that would minimize the risk of harms to civilians, not the certainty of harm to civilian. So I think we can, without adopting new rules of international law, subject kind of our nuclear targeting and planning to somewhat more exacting kind of controls than maybe the ones that were applied. Now, again, I say this as an outsider. I've never sat in Cheyenne Mountain. I don't know what it's like to be a Stratcom JAG lawyer. I'd love the gig. I'd love a 6-month TDY there to kind of have the chance to do this work and figure out what it's like. But from the outside, it seems like the United States applies international humanitarian law rules in a way that we agree on the content, but applies them in a way which maybe allows us to use nuclear weapons more liberally than the law would permit. That's it for me.
Well, thank you, Alan. I want to give all of you a chance to comment on each other's remarks, but I also want to raise what I think is an extremely important question that perhaps you can address as well. And that is, are there objective limits on the extent of collateral effects permissible under the requirement of proportionality? Or is it just a matter of balancing military and humanitarian considerations? When I read about wars in Afghanistan or Iraq, there's issues of, can 50 people be killed as collateral damage in order to get one high-level commander. Well, that's very grisly, but it's sort of, to me anyway, it's sort of conceivable as something to think about. When you start saying that there are going to be tens of thousands or hundreds of thousands or millions of casualties connected to an attack on a military target, I can't see that as being reasonable. And I think there's a basis in international law for objective limits. The ICJ, International Court of Justice, referred to elementary considerations of humanity. There's the Martins Clause, which refers to dictates of public conscience. So if you can comment on that question in responding to each other, and let's not take too long in these responses, but a few minutes each. So Travis.
Thank you. And thank you, gentlemen, for all your comments on this. I really appreciate it. Are there objective limits to the casualty figures? I don't think there are. I think it's very subjective. And it is up to that decision maker under U.S. policy that happens to be the president of the United States that makes the decision as to whether or not nuclear weapons will be used. And going towards what Alan had discussed in there, there are lawyers at every step in the process that take a look at what's going on. When I say that the president is the ultimate decision maker as to whether or not we'll use nuclear weapons, there are attorneys at every step of the process in there that weigh in on it. In addition, each president fashions his National Security Council as he sees fit, but some of that is set out by statute. And each of those principal members in there also have general counsels, and attorneys that advise them. And there's an interagency lawyers group that also meets in there. And there's a fair amount of churn and friction that exists in the process in order to get to what is hopefully the right answer on each of these issues. So I don't want it to appear from the outside that all of these things are happening in a vacuum. Now, the question of time that Professor Moxley raised, is important, and there may be certain conditions where we do have time in order to make that decision, and it can be a much more deliberative process, and hopefully diplomacy will have a longer time to play out in there, so we can avoid escalation or avoid continuing to use nuclear weapons. But there may be other circumstances where, unfortunately, we don't have that time. And our chances of certainty tend to diminish then, along with that compressed time that we have. However, going back to Alan again, I think that some of the models that we're incorporating right now do take into account a lot of the factors that you were discussing. So foreseeable has extended beyond some of the things that we were going into. Even in our criminal justice system, though, we don't require perfect knowledge in there. It's beyond a reasonable doubt, not all doubt. So I think that we try to do the best we can given the circumstances that we have. And then finally, precautions in the attack. I think we do take that into account. It's nested under proportionality analysis that we do, though, and the weaponry that goes into that before you actually deliver it, as well as taking a look at the target, initially as to how it's going to be exercised. So weather conditions, time of day, all of those factors actually come into play. Now, with some of the weapons that we use, it may not matter. But you can mitigate some of it through height of burst, whether or not it's a ground burst, some of those other things in there to try and limit it. So we absolutely do, and we do take precautions into attack. You'd mentioned working at State L, the Matheson memo is where we get that direction from. It was the state legal or deputy state legal advisor that drafted that memo in conjunction with members of the Department of Defense that did say that precautions in the attack were part of customary international law. And as it goes towards how DoD views the law outside the United States, we do take our lead from State Al. It is not the Department of Defense that decides how we're going to view things in there. It is the State Department that speaks for us in a lot of those things. So Brian Egan and other state legal advisors out there give us direction as to how we should view things in the international arena. I know that there may be some churn right now or discussion angst about civilian harm mitigation and things of that nature. Whether that exists as a separate part within the department, I don't think that ever goes away though in what we do. And it's been part of how we do things from the very beginning. And LOAC drives us to do that. We're always seeking to minimize the amount of civilian harm that we have while bringing the conflict to the end as quick as we can. So with that, Dr. Burroughs, I'll turn it back over.
Okay, Sean, you go ahead.
Yeah, thank you very much. And I probably should have said on the front end of this, that same disclaimer that we heard from Travis. I work for the United States Air Force Academy, the Department of the Air Force, the Department of Defense, but certainly the things we're talking about here aren't necessarily reflective of those. And sometimes they're not even my own ideas. But at any rate, I think one thing that we appropriately maybe have not necessarily spent much time on yet, because nuclear weapons are different. Nuclear effects certainly can be very different. But the other half of the equation, these rules aren't sort of in a vacuum, and they aren't all on the humanitarian side either. And I think it's appropriate to sort of look at, when you ask the question, is there an objective number? Military necessity is neither, quantitative or qualitative. It's a mixture of both. And I think, to be fair to states, especially if the survival of the state may be at risk, that is the other piece of the equation that we haven't spent perhaps time talking about. And, to your point of certainty, I think that certainty element goes back to that as well. What is the certainty of the advantage that we're going to gain if we're going to use this ultimate weapon, if you will? So I think, again, no objective number exists on paper, and certainly no nation would agree to one that I'm aware of. But we would have to put that as part of that overall calculation and making sure we're doing our due diligence on both sides as we press forward. And I think I'll pass over to Alan next.
Well, no, let's go to Charlie.
All right, thank you. So many interesting questions. I've only in private practice had a couple cases that went on to the Supreme Court, and I think we were denied cert on both of them. But in this conversation, when I have this opportunity to talk Colonel Lee with you and with Alan Weiner, who spent time in government and has that perspective, I feel like I'm before the Supreme Court on these questions because you guys are the insiders here. Here's a broad question. Back, 25 years ago, when I got involved, I remember John Burroughs and Jonathan Granoff then in these issues. We had a concern about nuclear weapons, and we felt we had made great progress when, particularly in the ICJ case, the advisory case, the U.S. and other nuclear weapons countries said, look, law of armed conflict, whether you call it that or IHL, applies to nuclear as well as conventional. And I think we made that progress, but I think we stopped there and we need a quantum leap. And I think respectfully, it comes out of the sense that, well, reasonableness is enough. And even in our criminal justice, it's beyond a reasonable doubt. Might it not be worth considering? And I really, put this, Colonel Lieb to you and also Alan, because I know you and Scott do such extraordinary work in this field. Might we not need a quantum leap to different standards here because, as Sean said, the effects can be so much greater? I mean, I think we need that. I think that, and I saw someplace that there's over 2,500 JAG lawyers. I saw in another article, I think it was one that Scott Sagan and others did, and I saw a number of 10,000. But applying the law is good, obviously, and essential. But there is this range of views. And so does this range of views as to, the potential effects get factored into that legal analysis? Should there maybe be an outside, input in terms of ways of looking at this law? To me, the principles here, and I go back to the Law of War manual and the other manuals. I don't think, Alan, on your point, I don't think we have to say the rules are, there's a question about the rules. We have thousands of pages of what the rules are. And as you say, though, the question is, how do we apply them? And I'm going to suggest that this notion of, nuclear winter and even radioactive fallout, and escalation, that they're not foreseeable or express enough. I mean, this is John's question, how certain do we need? I think Mike Schmidt is right in his article in the Harvard Security Journal. We have to consider all these foreseeable risks. And we can't put our head in the sand. We know the literature tells us that the probability of escalation is high. I mean, we know that's high. It is a risk, right? The Joint Chiefs of Staff in the Joint Risk Analysis are considering what the enemy would do. So I'm going to suggest that each of these foreseeable risks, including escalation, certainly including nuclear winter and EMPs, they all have to go into it. And then we come down to how we value these risks, including, even if one thinks in a certain circumstance it's a low probability risk, but if it is the 5 billion deaths, how are we going to deal with that? I mean, I'm going to stop there. I don't, that's the challenging question.
Okay, thank you, Charlie. And Alan, if you have any comments.
Just three observations. I'll try to be kind of quick, John. Number one, on the question of objective limits, I agree with my colleagues from the military side of the house, which is that, no, there is not a formal objective, numerical limit on civilian harm when we're engaging in a proportionality analysis. I mean, if you look at the just war literature, you see some people who kind of try to engage in this somewhat macabre exercise of the risk transfer ratio, which is how many unintended civilian deaths can one anticipate in exchange for, saving the lives of some of your military personnel or achieving a military objective. It's a kind of a grim math. I think, we've seen interesting reports coming out of the war in Gaza. Don't know if they're true or not, but from 972 magazine, which is an Israeli publication, did an investigative report saying that in the early stage of the conflict, the Israelis were accepting a willingness to accept up to 20, incidental civilian deaths in exchange for killing one Hamas kind of mid or low level fighter, which in my mind is an intolerable, kind of application of the principle of proportionality. But we don't have a formula for that. Second thing I would say, John, you asked about the question of causing.
Alan, I'm going to interrupt. Sorry. It's intolerable, but legal? Is that what you're
I would
saying?
say if I were advising, I would say it's not legal, right? It's a standard, right? When we're dealing with, when we're trying to apply the principle of proportionality, we're in the world of, all first-year lawyers, we learn about the distinction between rules and standards, right? Bright line rules, you have to be 18 to vote. Very, very easy to administer, maybe over and under inclusive in terms of whether it achieves the policy, but you gain the benefits of easy administration. A standard, much more open-ended, allows you to take in, broader figures like, oh, well, everybody has to exercise a reasonable standard of care in tort law, right? Well, what does that mean? I think, we're clearly, when we're talking about the question of proportionality and balancing civilian harm versus military advantage, we are dealing with, number one, apples and oranges. I've never really figured out how we equate military advantage on the one side versus civilian harm on the other, right? They're not reducible to a quotient. These are standards, but I think they're still law. And so when I say, if a commander came to me and said, "Can I kill 20 civilians to take out a mid-level fighter?" I would say, "No, sir. That level of civilian harm would be disproportionate." And then I would have to try to figure out, what standards I could point to justify why I'm not just that's not just me speaking, out of my top of my head. Let's use it that way.
Okay, interesting. Yeah. All right.
And then just the third point I will make, or second point I will make, John, you asked about the potential of causing tens of thousands or even more, unanticipated or unintended civilian casualties in attacking a military target. I mean, I think one of the things that's important to stress, to me, again, that would also, probably not satisfy the test of proportionality, but one of the things that Scott Sagan and I have argued in the piece that we have published on nuclear targeting in international security is part of the military advantage of using a nuclear weapon is the advantage of preventing further nuclear attacks, particularly if you're in a responsive scenario against your own population. So, we think the calculus allows you to take into account the civilian lives in your own country that you might be saving, right, in carrying out such an attack, right? Now, again, this is not without controversy because some people think you can only look at the first order, benefit of the military advantage, and if you end up actually having the deterrent effect, if there's escalation control that comes as a result of your use of nuclear weapons, some people disagree that can be factored into your military advantage calculation. Sagan and I argue that you can. And then the last thing I'll say, and I think this just goes to Charlie's question. I was trained in international law as somebody who represented a powerful country that often wanted to try to maximize flexibility. On the one hand, we wanted to comply with the law. On the other hand, we wanted to kind of make sure that the law was applied in a way that was consistent with the commitments states had freely undertaken and consented to. International law is a consent-based regime. I sometimes think a lot of these questions that people the fact that some of these kinds of concerns may not be that you've described, Charlie, about potential effects of nuclear war, the fact that we might not have black letter law that would prohibit or doesn't obligate us to take these things into account doesn't mean as a matter of policy that we shouldn't. And I think that my own view is sometimes as lawyers we tend to we tend to want to make too much of what is really a policy debate a legal debate. So I am, dead set against the use of nuclear weapons and think that they'd be likely to be catastrophic in almost any circumstance and would be, a bad idea. Whether or not they are necessarily unlawful and it's illegal to use them, I think is a separate question. And so I'm persuaded by your concerns about the kinds of risks that nuclear weapons present, and I think that's the kind of thing that certainly policymakers should have as top of mind. Over.
Right. Thanks to all of you so far. It's been a rich discussion. Now, we have about a half hour to go, and I think we should discuss the question of nuclear reprisals. And that's even though I hear from people in the military, well, we don't really think about use of nuclear weapons in terms of reprisal, but there's a popular understanding that retaliation / reprisal is a basis for reliance upon nuclear weapons. And sorry to go right back to you, Alan, but since you've written recently on the subject, what limits are there on lawful reprisals, including whether it's lawful to target civilians and civilian objects.
All right, thank you, John, for teeing up that question. You're right. This is something that is also a topic that Sagan and I touch upon in that international security article, which I think came out in 2021. So, Colonel Lieb referred to the Matheson comments. This goes back to 1987. There was an event at American University, and Mike Matheson, who was then the principal deputy legal advisor, somebody whom I worked for, had enormous respect for, and was honestly a little afraid of during my time as a government lawyer, was the one who laid out a lot of our position on that. What one of the State Department's kind of leading international humanitarian law experts. And in those remarks that Matheson gave at AU, he acknowledged that the U.S. recognized the principle of distinction, codified in Additional Protocol 1 as a principle that we basically accept as an IHL principle. Principle of proportionality is one that we accept as a customary international law principle, some variation on the principle of precaution. In separate remarks at that same event, the then legal advisor, Abe Sofayer, said, but we don't recognize the prohibition on reprisals against civilians that's in Additional Protocol 1 as a customary international law rule, and basically said, yeah, it would be bad policy for us to accept this as an international law rule because it would take away our ability to hold what the enemy holds most dear, which is their civilian population, and it would undermine our deterrence. It would undermine our ability to prevent our own civilian populations from being targeted by an adversary. So that has been, and the U.S. reiterated that view in its comments in the 1995 statement before in the hearing before the International Court of Justice. The U.S. hasn't said too much about reaffirming the notion that we believe the prohibition on reprisals is not customary international law. I think until fairly recently, there's been a statement. I think people may have read the memo or the paper that Sagan and Weiner wrote, suggesting that the U.S. had failed to continue to be a persistent objector. And I think somebody said, "Holy cow, we got to object." So there have been some recent statements which the U.S. has reiterated its view that the prohibition on reprisals against civilians. Now, my own view is that the prohibition on reprisals against civilians will set aside the question for right now of whether or not the U.S. is a persistent objector to the rule. But I think in my mind, it is quite clear that the prohibition on reprisals has acquired the status of a customary international law. States that had taken reservations to that provision in AP1 have withdrawn or taken positions which are incompatible. There were only a small number of states that took reservations to that provision in AP1. They have either withdrawn or modified their views on that. I really see no state, right? When we think about how customary international law works, which is, practice of states informed by a sense of legal obligation, I really have seen no evidence of states saying, like, yes, we reserve the right to target enemy civilians in response to attacks against our civilians. It happens sometimes, to be sure, right? But states deny it when they do it. They don't assert that they have a legal entitlement to do it. And in those few cases where combatants or belligerents have made arguments that have kind of resonated, like belligerent reprisal, we see this most during the so-called War of the Cities in the Iran-Iraq War in the 1980s. The response of the international community was to condemn attacks on civilian populations in response to a prior round of an initial round of attacks against civilians. So my own view is that as a customary international law matter, it is not permissible to intentionally attack civilians, even if the other side intentionally attacks your own civilians, right? And the main reason is it's just abhorrent and immoral to punish people, civilians, who are not responsible for the wrong that has been inflicted upon you. That's the basic logic about why reprisals are immoral, and increasingly, starting with the 1949 Geneva Convention's prohibition on reprisals against persons in occupied territory and against POWs, So I think we've increasingly taken the view that it's wrong to punish people essentially for acts taken by their side that they're not responsible for. I'll stop there.
Well, thank you, Alan. And Charlie, I know this is something that you have thought and written about because you've addressed almost every legal issue there is relating to at least the use of nuclear weapons. So do you have any comments you wish to make?
I do, and thank you for those comments, Alan. David Lubin, who teaches at Georgetown, many of you know, and also at one of the military academies, wrote a fascinating article, as some of you may be familiar with, after a long career in the State Department, if I recall correctly, about military JAG lawyers and sometimes the challenges they face with their client because they're in the military, they're in the chain of command. And like all of us, we want to be part of the groups that we're with. They want to be part of the band of brothers. But he talks about, the challenges of getting independence. And he talks that this is a challenge all of us have as lawyers for clients or big clients, big companies. I've certainly had it when I was at Davis Polk, and the clients were among the biggest in the world. And, so the question has been, can we broaden the perspective? And that's why I suggested, and Colonel Lieb for you on the inside, and Mike Schmidt, if you all can talk with him, I know Jeff is, can we get a Tallinn manual where the guys on the inside get a perspective, and can we bring in the broader perspective on this question of targeting civilians? It's the same thing as to the question of numerical limits on collateral effects. Perhaps we should listen to the ICRC, right? The International Committee of the Red Cross, which is certainly one of the, if not the broadest humanitarian law groups. And they've said, look, in terms of collateral effects, they're supposed to be collateral, secondary, limited, and they have a long history under, the AP1, some of the sections there, that collateral effects are limited and they can't be extreme. And they've said something similar as to this area of targeting civilians. And Alan, as you've said, and John alluded to it, we have heard in these conferences speaker after speaker from within the military. And in fact, I think Colonel Lieb, you said it in our prep session, we have the U.S. position formally is that we can target civilians lawfully because of Abe Sofair and what he said back in the day. But, do we really do it? I remember Colonel Richard referencing this last year, and the sense one gets is that, well, while technically we can target civilians and that's our position on the law, we don't really do it. I think this relates to what my takeaway was from the earlier panel, which was on risk. How do we reduce risk? And I think while what's happening in the world and Putin's aspirations and China's and Taiwan, the real world things are important, but the declaratory policies, I think, are important in terms of the risk, right? And our position as a matter of law is that even if Moxley and some of these other people, Burroughs and Granoff, even if there may be some merit in some of their arguments, or all of them, that the use of weapons nuclear weapons would be unlawful under the rules of Law of Armed Conflict, IHL. Even if they're right, we can do it in reprisal. And so that's our declaratory policy. And it sort of throws law out the window. And so does that not raise the risk? So it's a long-winded way of saying, I agree with Alan Weiner, that there are real questions about lawfulness of targeting civilians. The ICRC, the last time I looked at their protocols on it, they say, well, there is a dispute, but the trend is moving towards that. And there are some decisions out of the International Criminal Court and other of these tribunals which have recognized as established law that we can't target civilians. So I'm going to stop here, but there's real, limits there. And I guess my question for the Supreme Court here is, can we get the ICRC and a broader perspective? Because the fact that we're lawyering up at the design phase of the weapons and the war plans, the targeting plans, is encouraging, but subject to a concern that the legal review is only useful if it incorporates, a realistic version of the law. And as we can see in these debates, there's a spectrum of views on that. So how to deal with that is a question.
Okay, thank you, Charlie. I'll turn next to you, Sean.
Yeah, maybe a tie-in is appropriate now, reflecting back to the first panel and the idea of deterrence. Alan mentioned we're in a consent-based regime of laws. And as anachronistic as reprisals may be, there is a tradition and a legal basis for them. And to your point, Professor Moxley, even though the JAGs or the governments may be unlikely to flex that muscle, there may be something to be said about having that in your toolkit if deterrence is realistic, achievable. And so maybe it ties back to the first question in statecraft and sort of whether or not deterrence is even a meaningful thing, because I think that's the whole purpose of reprisals, right? To have something left in your bag of tricks to try to coerce the other side into better behavior. And if you take that off the table, are you actually increasing potential risk by the other side if they know that you are unwilling to use that particular weapon in the arsenal?
Thank you. Travis.
Yeah, thank you. And I think Sean really hit it right there. It does come back to deterrence, and I know we're going to talk about this again at a later panel. Let's take a step back with reprisals, though, and maybe for some of the folks in the audience, I know that Colonel Richard is on, and Swede, and a few other folks that are much more expert at this than I am. But so you have a state that takes an unlawful action, and you're looking to respond to that unlawful action with another unlawful action. They may have blown up Los Angeles, and now we're going to take out St. Petersburg. That would be one example. But you have to point out that unlawful action. You have to give them an opportunity to stop. You have to tell them that you're going to take the reprisal, give them an opportunity. So my point with that is that there's a way to do it lawfully that has been laid out over time. One point, though, from the inside, we have two roles as judge advocates inside the military. We advise on the law, and then we give oftentimes a policy recommendation to the decision maker as well. So you can have something that is legal but stupid, and that's where I would likely try to frame something like this. That is, yes, it's an option available to us under the law. As the United States, we have not sworn off reprisals for, the same reason why our policy on national self-defense is so broad. If a state knows where we draw the line, then they can know where they can walk up to without stepping over it. But if it's a bit fuzzy, then there's some uncertainty there, going back to deterrence like we talked about before. So I would probably tell my boss that, as a matter of law, we still recognize this as being an option for you, but we only have so many munitions potentially to use in this situation. So why would we use ammunition in a situation like this when we could use it to go after a military objective that might actually stop the war as opposed to prolonging it by taking out another city in there?
All right, thank you. Now, unless somebody really wants to say something more on this topic, I'd like to move on. And first of all, I see a message from David Lubin that I gather he did not have a career in the State Department. So just passing
my misremembering, my apologies.
Yeah. So There's a question from Jonathan Granoff, which relates to a question I had been planning to ask. So let me first ask my version of the question, and then I'll ask his related question. So what is the role of an attorney who has advised in a particular instance that a potential use of a nuclear weapon would be unlawful when he or she knows the decision maker intends to proceed with the use nonetheless? Here's Jonathan's related question. What could JAG lawyers do if there was a president who said, quote, "I don't care about legality. I am immune from the constraints in exercise of my core duty as commander-in-chief. Why should I care about IHL? It's not even law created by Congress. In fact, foreigners have been part of its creation. I can do whatever I want." End of quote from this president. What should the JAG lawyers do? So perhaps I'll start with you, Travis.
Talk about putting a guy on the spot.
Once again, these are my own personal views, not the views of the Department of Defense, the United States Army. No, and that's a great question, and one that is a hypothetical that's been posed to us ever since we put on the uniform and began with our initial entry training as a judge advocate in any of the services. At that point, you seek clarification. You know, did I hear you right? You know, is this exactly what you're looking to ask us to do right now? You know, they double down on it. You know, or at that point, come up with alternatives. Boss, I hear that this is what you want to do. You know, here's your intended outcome. I think that we can take these other steps in there, which are in fact legal, to get you to exactly where you want to be. You know, so going through those things, as we all do as attorneys when we have difficult clients out there, you know, how can we walk them back from where they're going right there and get them to a better place. And then for us, fortunately, it's a matter of using the technical chain in there. So we have the chain of command on one side, the President, Secretary of Defense, and then my boss, General Anthony Cotton. You know, but then we have legal advisors that advise each one of those individuals. So, you know, Captain Tony Mayani is the General Counsel for United States Strategic Command. We can reach out to the legal advisor, the chairman, and then the General Counsel to the Secretary of Defense in there. So working through those technical chains in there, you know, to try and work out that issue, you know, prior to execution. We have a duty, though, not to obey an unlawful order or an illegal order. And you know, if that's the case, then that's the advice that we provide. Make sure that we document that advice that was given, and then really go from there. And hopefully our client doesn't walk down that road. But those are many of the steps that I would likely go through in that situation. You know, if I was faced with that, ultimately, I'm going to tell my boss not to. Unlike the Israeli armed forces, though, where their advice, it's my understanding, is actually binding on their commanders. Mine isn't. Mine is just advice. Although I'm subject to the ethical rules of the licensing authority that I have. But I am just another advisor to my commander, but the one person that can actually tell him no as well, you know, and base it on that legal ground. But that's how I would likely handle that situation.
Okay, thank you. Sean, what are your thoughts?
Yeah, thank you. As somebody who not too long ago took off the uniform that Travis is wearing, albeit Air Force version, we almost don't have to make this a hypothetical. If we change two facts, we might be able to get an answer there. And the two facts would be, we don't have a commander-in-chief that says law be damned. We have a commander-in-chief that suggests, I want, you know, here's my commander's intent, and here's what I'd like to see happen. And then if we go back about 20, 25 years to what we might refer to as the torture memos, and the advice that State Department, White House counsel, others, and JAGs and service TJAGs were providing to the President of the United States as it applied to enhanced interrogation techniques and how we're going to treat people in our custody and care in the hopes of extracting information that might avoid another 9/11. And so all of the things you heard Travis talk about were things that were pursued and done. The JAGs at the front level, receiving advice from on high, from Secretary of Defense and above. When appropriate, raise those concerns, raise those questions, and the service TJAGs push back. And so, again, at the end of the day, as Travis said, JAGs advise, commanders decide, and the commander-in-chief is the top of the food chain when it comes to those commanders. But we do all of the things that he suggested. And the other thing I would say is, again, assuming the language from the commander-in-chief is, is not so abrasive as, I know what I am doing is unlawful. This conversation alone has sort of taught us one thing, which is the law is probably not exceptionally clear in this area. And when we provide advice, we provide risk assessment to commanders. And at the end of the day, commanders have to assume that risk and that responsibility in making the decision that they believe is the best. And so I think, again, the hypothetical is more fun than probably real. And those would at least be some of my initial thoughts.
Go ahead, Charlie.
I think I'd build off of Sean's comment about the law not being clear. We all know what happened with the torture memos and OLC, the Office of Legal Counsel went along with it and people went along with it. There were things that people didn't go along with. There was a proposal at one point within the George W. Bush administration that promotion of military officers should be approved by political officers, by political appointees. And the press got wind of that. And there's a bunch of stuff out there that at least as a formal matter, I don't know what really happened, was prevented. But here's what I think, and I go back to Mike Schmidt's Tallinn Manual, which is kind of a Bible. I have it right in front of me of the law in these areas because it's such a recent restatement, right? We need this on the nuclear weapons area for the reasons, Sean, I think that you gave, and we've all addressed that there are a number of these areas of uncertainty, right? Even if you look at the ambiguity of our deterrence policy and the notion that ambiguity is a good thing. I mean, we'll talk about this in the later panel, perhaps, but for this discussion to be meaningful, that the military has to disobey and as you say, Colonel Lee, discuss and offer alternatives and so forth on unlawful instructions. One needs to know what the law is, lest one is in the position of just exercising judgment that, may well be good judgment, but isn't it better to have more clarification? So that's my kind of plea to the system. Is there a way to incorporate into our decision-making or our judgment-making, a broader review of this body of law, which we've underthought, right? Because the Soviet Union disappeared and this area, hasn't been that front burner, but now it is.
I'm going to turn it over to Alan in just a moment, but I do want to make a comment. We've had a good discussion of how to apply rules of the law of armed conflict and international law to use of nuclear weapons. And obviously there is a debate about it. On the other hand, in my personal opinion, and in the view of my organization, the use of nuclear weapons in all circumstances is against the law. And I actually think that's the right position. It's certainly a reasonable position. And, you can exclude what our President Emeritus if you want, you can exclude situations like the mini nuke in the Gobi Desert. But I mean, in typical scenarios, I think it's reasonable to say that the use of nuclear weapons is unlawful. So I didn't want there be sort of a lack of clarity about at least the view of my organization. I actually think it's Charlie's view, despite what he was just saying about the need for a Tallinn manual. Okay, over to you, Alan.
I don't have very much to add to the, insights of people who are serving or have recently served in a military role. I mean, clearly, commanders have not only the right, but the duty to disobey orders that are, we often use the phrase manifestly illegal. I think it's actually a little bit misleading. I think sometimes the phrase manifestly implies like obviously illegal. If you actually look at kind of the standards and the actual test that comes out of the Lieutenant Calley situation is that it's okay to, it's a defense to any charge for someone to disobey an order that he knew to be unlawful or that a person of ordinary sense and understanding would have known to be unlawful. So that to me sort of kind of implies like a reasonable standard test, right? If a reasonable person would know that an order is unlawful, then one can obey it. Former Stratcom generals, both Kaler and Heighton, have testified or have commented that they believe that they have the authority to disobey an illegal order from the president to use nuclear weapons. Although, again, it goes a little closer to what Colonel Lieb said. It's not like I would basically say, up yours, Mr. President, but it would be more in the nature of like, let's have a discussion about what you want to try to accomplish and whether there are, other ways that we can do that might be consistent with international law.
All right. Well, thank you all. We're really right at time. If somebody wants to say something like in 30 seconds, you're welcome to do so. All right. Go ahead, Charlie.
One thing, I think, Alan, you mentioned, the dichotomy between policy and law. And I think Colonel Lieb, you mentioned it, that sometimes, what we hear is policy and not law. And that's certainly the case. I'd like to suggest that the potential importance of the role of law here, in light of this big body of law that does exist, is that if we could get a recognition, as John suggested, that the use of nuclear weapons or the use of high-yield nuclear weapons, I would say all nuclear weapons, but if we could get a recognition that some or all uses of nuclear weapons are unlawful, and that we have to adjust our policy of deterrence to only threaten the ones that are unlawful, that the fact that biological and chemical weapons are unlawful makes it easy for the policymakers, who are sometimes the politicians, who sometimes are under political pressure. The policy of deterrence is intuitive. Oh, all we have to do is make a threat, and we're not going to be in a war. I mean, we know that the policy of deterrence is much more than that, as we'll discuss this afternoon. But policy may never yield a real clear answer here. It may give us arms control, but it would never give us abolition. Whereas if we could recognize that nuclear weapons are as unlawful as chemical and biological, we could delegitimize them and really change the risk structure if we could then internationalize that.
All right. Thank you, Charlie, and thanks to all of you. I think it was a worthwhile discussion, and I appreciate the willingness of all of you to contribute to this. So onward to the rest of the conference.
Here we are, right? It went by fast, John. You're so right. So now we're right on time. It's strange to say. So we are on lunch from 12:50 to 1:50, but our actual break for the over 100 people who are with us now. Our break is really only 10 minutes because at it's 12:50. At 1 o'clock, we are going to have the keynote, which is going to be we styled it Luncheon Reflections. It's going to be introduced by Daryl Kimball, whom we heard in panel one, the executive director of the Arms Control Association. Will introduce the discussion between Jonathan Granoff, whom you met earlier, and Thomas Countryman, who is the board chairman of the Arms Control Association. So from 1 o'clock till 1:45, we're going to have a discussion introduced by Daryl between Jonathan and Tom Countryman. So everybody, we're off the clock for 10 minutes to get our lunch in front of us if we can, and then really the conversation with Daryl, Jonathan, and Tom Countryman is not to be missed.
There we go. Okay. What a substantive panel we just had. Really impressive. Just fantastic. Charlie, I'm so glad you took the initiative to do this. I'm going to introduce Daryl Kimball. He was introduced a little earlier. But what I want to say is, yes, he's the executive director of the Arms Control Association and the publisher of Arms Control Today, which everyone should subscribe to. He was the executive director of the Coalition to Reduce Nuclear Dangers, a consortium of over 17 organizations. Before that, he was director of programs for Physicians for Social Responsibility. The most important thing about Daryl is that he has been over decades providing platforms for lots of other voices. He is, in a sense, of course, been a very powerful advocate in his own standing, but he's amplified the voices of so many other people. And it's exactly that kind of generosity of spirit that we're going to need in the coming years to address nuclear weapons, artificial intelligence, and all sorts of weapons that are going to require sanity and the rule of law to constrain them. So, Daryl, I hand it over to you to give a few remarks and then introduce Tom and myself. And again, let me express my personal gratitude for your leadership and hard work.
Well, thank you, Jonathan. The feeling is mutual, and I am really impressed with this virtual conference. It's a great gathering. The last session was a fabulous discussion. But let me just frame this more informal conversation that you and Jonathan are going to have by noting that, as you said, the Arms Control Association is one of the several organizations in the nuclear arms control, non-proliferation, disarmament field that seeks to advance progress in reducing nuclear risk, eliminating nuclear weapons. And we work very closely with a wide range of organizations, experts, and institutions in the US and abroad, because no one organization has the ability to move the needle on these massive issues alone, but together we can make a great difference. And so what I just wanted to do to kind of introduce your conversation together is to remind us of what the broader context is, and what some of the key issues are that organizations in the nuclear arms control, non-proliferation, disarmament field are focused on as we move into 2025. And so to start, I want to just quote UN Secretary General Antonio Guterres, who delivered a statement earlier this year at the Arms Control Association annual meeting on June 7, that I think is very powerful, and it frames the problems we face. He said, quote, "Humanity is on a knife's edge. The risk of a nuclear weapon being used has reached heights not seen since the Cold War. States are engaged in a qualitative arms race. Nuclear blackmail has reemerged with some recklessly threatening nuclear catastrophe. Meanwhile," he went on, "the regime designed to prevent the use, testing, and proliferation of nuclear weapons is weakening. We need disarmament now. All countries need to step up, but nuclear weapon states must lead the way." So I think that very well encapsulates the challenge and the direction that we need to be trying to move in. And I just wanted to ask the two of you to, as you will, take on some key questions that organizations in the field have discussed and reached agreement on, are priority issues. Last December, the Arms Control Association, along with the Nuclear Threat Initiative, gathered almost 30 organizations, mainly US-based civil society organizations, for a strategy retreat in person to discuss the challenges ahead, some of the ways in which we can work together. And among the key issue priorities that we identified that require work is, and we've been discussing these this morning, the continued risks that nuclear deterrence strategies pose, particularly the threats of nuclear use that we're seeing from Russia and other corners of the earth, how we respond to the ongoing risks of nuclear deterrence and threats of use. How can we reinforce the norm against nuclear testing that the CTBT has established? As many know, some former advisors to President Trump have suggested a resumption of US testing. We know that Russia has withdrawn its ratification from the Comprehensive Nuclear Test Ban Treaty to mirror the US policy. So the norm against nuclear testing is also at risk. As we discussed earlier this morning, there is a risk, number 3, of an unconstrained three-way nuclear arms race between the US and Russia after New START expires, and of course between the US, Russia, and China as China increases its nuclear arsenal. And interestingly, we saw President Trump talk about the need, his interest in engaging with Russia and China on nuclear arms control through diplomacy. How can we pursue that and encourage engagement with China and Russia on risk reduction? And the other issue that we NGOs agreed is a priority is to encourage US policymakers, particularly in Congress, to evaluate the question, does more nuclear weapons increase US security or not? We have a number of proposals that are going to be coming forward this year in Congress, perhaps from the president's budget request, calling for preparations to actually build up the number of deployed nuclear weapons, additional nuclear weapons types. And then finally, and I know, Jonathan, this is on your mind, another key question, whether it is a Republican or a Democratic president in charge of the proverbial nuclear button, how do we ensure adequate, better checks on any decision to use nuclear weapons by the commander-in-chief? As we all know, the president has the sole authority to order the launch of nuclear weapons. But then in addition, we have the challenge of artificial intelligence being incorporated into nuclear command and control decisions in the US, Russia, and China. And helpfully, last year, the Congress approved a policy statement that reinforces a Biden administration statement that says that in all cases, the United States will maintain a, quote, human in the loop for all actions critical to informing and executing decisions by the president to initiate and terminate nuclear weapons decisions. So, that is another contemporary reality that we're facing, another challenge. So I lay those out as issues for all of us to think about, but also for the two of you to explore and discuss. So with that, let me just formally introduce Jonathan Granoff and then my friend and colleague, Tom Countryman. As we heard a little bit before, Jonathan Granoff is president of the Global Security Institute, a lawyer and former professor of international law. He's currently a senior advisor and representative to the UN for the permanent secretariat of the World Summits of Nobel Peace Laureates. Jonathan was one of the few people at the White House late last year for some ceremonies recognizing Americans who've done good deeds at the White House. He's been deeply involved in the American Bar Association as senior advisor to its Committee on National Security. I didn't know this, Jonathan, but he was nominated for the Nobel Peace Prize in 2014, which is prestigious, but that only begs the question, what have you done for us lately? You need to step up your game to get another nomination. So, and Tom Countryman is currently the board chair of the Arms Control Association, but even more importantly, Tom is an experienced diplomat, 35 years of service in the U.S. Foreign Service, serving in multiple roles, European security in the Balkans, at the UN mission to New York. He was Assistant Secretary for International Security and Nonproliferation at the State Department for several years and acting Undersecretary for Arms Control and International Security before his departure in early 2017. And so I leave it to you two for further exploration of these and other issues. So, Jonathan, do you want to lead us off, please?
Sure. Thank you. Thank you, Daryl. One small correction. I'm the senior advisor of the Committee on National Security of the International Law section, because there's different sections of the bar, which is relevant to our conversation. Tom, I think people should know the breadth of your experience to begin with. And I'm just going to help supplement some of Daryl's remarks. First of all, you speak Serbio-Croatian, Arabic, Italian, Greek, and German. You know, that's not too bad. You began your diplomatic career in the early 1980s. You've been stationed in Belgrade, Yugoslavia, Cairo, the Office of Counterterrorism. You were a special advisor to our UN permanent representative, Madeleine Albright. You have been a special expert on Middle East and South Asian policy in the State Department. You've been stationed in Rome, Athens. You've been a political advisor to the Commandant of the Marine Corps, General Conway, in addition to being Assistant Secretary of State. And you're also a member of the board of the Arms Control Association. So this is an amazing career of a broad range of postings and experiences. But I want to just ask you, what brought you to the passionate engagement of being a diplomat? How did this happen?
Well, thank you, Daryl. Thank you, Jonathan. Thank you to all the organizers of today's event. I remember, as Dr. Freeberg remembered, the duck and cover drills in my parochial school. And until I went to college, I was more interested in physics and astronomy than in politics and the world. That changed after some travel as a student, and the Foreign Service career suited me perfectly. The diversity of tasks on a daily basis and over a career always fascinated me, always convinced me each day that I was doing something useful for the security of Americans and the security of the world. So I had the opportunity at different levels to do rewarding work of varying levels of significance, from reunifying families divided by the Iron Curtain, to advising the democratic opposition in Serbia, how they could peacefully end the regime of the dictator Milosevic, to speaking on behalf of the United States in efforts to reduce the risk of weapons of mass destruction. And as I said, in all of them, I felt every day not just fascinated, but convinced that I was serving the American people. Now, today, there are a number of politicians who'd like to put forth the idea that the Department of State represents foreign countries rather than representing Americans. And nothing could be further from the truth. When I have the chance to speak around this wonderful country, I like to tell people that we don't have a Department of State, we don't have a foreign policy because we love foreigners. We have that because we love Americans. We want Americans to feel safe and secure in their home or whether traveling overseas. We want them to sell the world's best food and best products overseas. We want them to know that the tiniest portion of their tax dollar, about the same amount that we spend on nuclear weapons each year, goes to alleviate suffering in other countries. And above all, we want them to know that their loved ones, our heroes, America's servicemen and women, are not put in jeopardy simply because of a failure to pursue non-military solutions. So following my somewhat abrupt retirement a few years ago, it was natural for me to go help out the Arms Control Association. We've got two existential risks facing us: climate change and nuclear war. They are both important, but I choose to work on this because even in the worst projection of climate change, the human species will survive. You cannot say the same thing about the survival of the species in many scenarios of nuclear conflict. So that's what I've done and still try to do.
That last point you made is what brought me to the issue. In the late 1960s, I was interning in Washington, and then Senator from New York, Robert Kennedy Sr., took a bunch of us to lunch, and he told us what happened in the Cuban Missile Crisis, and it was pure good luck that saved us. But I'll never forget what he ended with. He said, "Nuclear weapons are the moral and practical litmus test of modernity. If we get every other issue right and don't get this right, it won't matter." And that really has stayed with me. And so I've been a civil society advocate ever since that lunch, really. And that's the point you just made. But the other issue of climate, which is our relationship to the natural world, really requires a level of cooperation that we have to obtain. I think every day that 60 to 80% of our oxygen comes from phytoplankton. People don't realize that we are literally all breathing a third lung. And it's at risk because of climate and because of pollution of the oceans, which cannot be solved at a national level. And one of the biggest hazards of nuclear weapons is the institutionalization of existential adversity. So it seems to me that for diplomats, the idea that on Monday you have to work toward cooperation in protecting our shared home, our shared lung, for example, and then on Tuesday, you have to explain why you're pointing weapons at your counterpart, threatening the annihilation of their entire population, and they're doing the same in the interest of stability. So I wondered if you could share with us in your career an example of a success that was inspiring, that really, helped enliven your passion for continuing this work as your lifetime work. So just one or two examples of successes. People need that. I need it.
Okay. A quick one would be in 2013, after Syria used nerve agent against its own citizens. I went with Secretary Kerry to Geneva, and together we worked out with the Russians a very practical program for the destruction of Syria's chemical weapons capability. And despite the fact that Russia was a good friend of Syria, we not only got to agreement quickly, we implemented the destruction of Syria's chemical arsenal, as we saw later, not 100%, but pretty darn close. And some of that same experience is now needed as we have another opportunity to once and for all put the specter of a chemical arsenal in Syria behind us.
That's a great example, because Syria is not a party to the Chemical Weapons Convention yet.
It is now.
It is now, but at the time we took the position that it's bound by the constraint as a matter of customary international law. And I think that, when people say, well, what does the law mean? Well, this is what it means. It means that policies like this can be executed because we operate based on legal concepts. Today, we're seeing, we have a president of our country who doubted who just made a mockery of 60 court decisions upholding the 2020 election, who derides foreigners as a regular. Ironically, he's married to a woman who wasn't born in America, but he regularly derides. Well, I mean, he's even considering annexing Canada, for God's sake. And the need for cooperation is increasing. Describe like where we are today, from your vantage point. Where are we with respect to the web of treaties, the Nuclear Non-Proliferation Treaty, the Chemical Weapons Convention, the Biological Weapons Convention, the entire web of constraints by law that have built up an architecture? Where are we with respect to that? And then we'll talk about where we need to go. But first, tell us where you think we are, your vantage point of how critical is the moment.
Well, to do that, let me give a brief conceptual history of arms control. I hope you can see a slide that I've used before. We had a consistency of approach to nuclear arms control from President Eisenhower to President Obama, that arms control is not the alternative to national security, but restraining an adversary's arsenal is valuable for our security. We don't show weakness when we engage with an adversary. We look for common solutions. We solve problems one at a time instead of insisting on solving everything at once. And that the US has to take the lead in reducing risk. That was a consistent US policy that significantly reduced risk from 1962, I would say, up until 2014. There's been a change. And I think that in the President Trump's previous administration and among many members of his party, there's almost opposite views about what arms control is. That real men don't do arms control because it's a sign of weakness, it's a giveaway to opponents, that all treaties are negative because nothing should ever restrain United States freedom of action, that an agreement that solves only one problem is unacceptable if we have other problems with a country, and the recurrence of an old idea that weapons are not just for deterrence, but to give us a strategic edge, and that there could even be circumstances in which nuclear combat can be limited and won. I see all of those trends as dangerous, and I think they have contributed to what we face today, which is a gradual erosion of the important agreements and norms that did so much to reduce 85% of the weapons held by Washington and Moscow and reduce the risk that they would be used. Now, the risk remains, and I think it was covered well in the first panel. I agree with Dr. Ford that the primary risk is of Russian and Chinese belief that nuclear weapons are not just for deterrence, but in fact can be used for compellence. But there are other risks as well, and those include the numerous flashpoints around the world, the fact that false alarms and mistakes cannot be eliminated from consideration, and just plain the unreliability of the 9 men who have their fingers on nuclear buttons. This is not the Churchill-Kennedy generation of leaders.
The unreliability, they're just fallible human beings. But I had a discussion with the permanent representative of Russia to the UN at a reception, I think it was about 2 years ago, in which I suggested that when our president said the people of Baghdad would greet our soldiers with flowers in celebration, that my wife said, "No, I don't think so." And that when his president said that the people of Kiev would greet Russian soldiers with flowers in celebration as liberators, I said, nah, I don't think so. And I pointed out that if you'd spoken to any cab driver in Baghdad or Kiev, they could have told you, they could have told anybody that the invading troops would not be greeted with flowers and celebration. And yet, two heads of state of these countries with over 90% of the nuclear arsenals could be so wrong, could have so little common sense, and that this human fallibility sits as a sword over all of our heads. That's, to me, so we had an actual sane conversation, is what I wanted to point out, because I pointed out that there is no winner in a nuclear war. And I want to go back to how we got to reducing the arsenal by over 80%. And one of the ways was one of the points you just pointed out, that you do one thing at a time. And I was asked to be, and I was the outside commentator on the 20th anniversary of the Geneva Summit, which was hosted by the city of Geneva. So you had Bud McFarlane, Jack Matlock, who had been our ambassador to the Soviet Union at the time, Mikhail Gorbachev, Besmirnik, the foreign minister, was there. And I was asked to comment as to whether we were safer in 2005 or 1985. So I immersed myself in the preparations for the Sherpa work, the preparations for the Geneva Summit. And I came across a session, the rapporteur of which was the brilliant, brilliant diplomat, Jack Matlock, was the rapporteur, of Secretary Schultz and Shevardnadze at the UN mission to the United Nations in preparation for the Geneva. And what Schultz did was he took the skills that he had as a businessman and he said, let's lay out one at a time the issues in which we have clear agreement. And the first one was a nuclear war can never be won and must never be fought. They both agreed with that. And they began with laying out the places where there's clear agreement and mutual interest. Then they laid out the issues in which they believed progress could be made by negotiating. And then they said, we'll make a list of the things that we don't believe we're quite ready to deal with yet. And that blueprint, I thought was, I mean, that's exactly how you negotiate a commercial transaction that's complex. And from that, the second paragraph of their communique in 85 was a nuclear war can never be won, must never be fought. And the last sentence of that paragraph was, and neither party shall seek military advantage over the other. And that is what people said. It was that sense of cooperation and common interest that led to cooperative threat reduction and reducing the arsenal by 80%. It seems to me that where we are today is can be informed by where we need. The successes of the past can help inform us of where we need to go. And I wondered if you could talk about where we need to go.
Sure. First, I have to comment on the famous sentence, a nuclear war cannot be won and must never be fought. Yes, there were additional texts that Reagan and Gorbachev used, but it was the power of that single sentence that made an effect on the world. I happened to go back into the State Department for just a year in the Biden administration, and I was present at the meeting of the 5 nuclear powers as we discussed reissuing that sentence. Nobody at the table thought that you could simply issue the one sentence, and all 5 had suggestions for what else we had to say. And the net effect was, of course, to dilute the power of that single sentence. That was a little disappointing to watch. Much of the success that we had was a result of continuous contact between Washington and Moscow, between genuine experts. There was always a media focus on the big summit and on the last meeting before the big summit when a real treaty would be signed. But the real work and the real progress was not made at those summits. it was done by hard, continuous, unpublicized contact. Today, we have a hard time getting back to that because both the United States and the Russian Federation have used non-contact as a lever in their disagreement over Ukraine. And I think that's terribly unfortunate. In addition, the few times we did have a strategic stability dialogue in 21 and 22, there was so much media hype. And I have to say, both sides spent more time preparing for their post-meeting press conference than they did preparing for agreement in the meeting. What I would hope is that in the Trump administration, there's a different relationship with Russia than in the Biden administration, and that it is possible not to pin everything on one giant summit meeting, but instead to find a way to have regular weekly discussions among experts, not at the most senior level either, but real experts at the medium level. If you have to go to a back room in a cafe in Nicosia in order to have privacy and not have a press focus on it, that's what I would do. Now, what could they do? And I think this is important, that we do have a new opportunity in this administration. Now, of course, I do not take at face value everything that Mr. Trump says, but I am inclined to accept at face value the very important statements he made about denuclearization, reduction of risk at Davos last week. I have to take it at face value because I'm basically an optimist and because of the urgency of the situation, but also objectively because Mr. Trump for 40 years has expressed an interest in nuclear arms negotiations, and for somewhat less than 40 years has expressed a strong interest in winning the Nobel Peace Prize. I think we can build on that. I think that there is a possibility to get that kind of expert dialogue going with the Russians, not in order to address Mr. Putin's wish to write a comprehensive strategic equation that covers every possible crisis and every type of weapon, but exactly in order to solve one problem at a time. And here's a couple of suggestions. I mean, Daryl has already mentioned the importance of having either a handshake or a simple written document that both sides will continue to honor the New START limits as long as the other side does. I think there's more than that they can do. But let's also not overlook the things that ought to be addressed within the US political and legal system. One of them is continuing to refrain from nuclear testing. And I would hope strong voices in Congress would push back against those who think that nuclear testing is an effective form of chest-thumping deterrence. It's not. It only damages US interest in global security. But we should also talk at this moment about whether we can revisit the concept of presidential sole authority to launch nuclear weapons that has been in place since August of 1945. There's a big difference between the president having responsibility to respond to an immediate attack on the United States and a president taking it into his head that this would be a good time to launch weapons. An earlier speaker said that the main risk today is not that one president will wake up and launch an all-out nuclear attack on an enemy. It is the risk of gradual escalation from accident to incident to conflict to nuclear conflict. Still, there ought to be some kind of consultative process required before the US president could be the first to initiate a nuclear exchange. So we have these opportunities today, but we should particularly seize on the possibility of a renewed, continuous, unpublicized dialogue between Moscow and Washington.
Yeah, it's process. It's process is the
Process matters.
Process matters, you know, it's not just grandstanding. And I don't think the public appreciates that in the, you know, in the events in which we see publicity, there's an entire staff of people working late hours and building relationships. Now, one of the things that that got sidelined with the intoxication of the fall of the Berlin Wall was there was a process that had 98 senators supporting it, and President Gorbachev, who helped found the Global Security Institute with Senator Cranston and myself, strongly supported, which was the creation of a crisis center, a bilateral crisis center, to address the dangers of mistakes, misunderstandings, that would be in regular dialogue, addressing preventing crises from happening, and should they happen by computer era or human era, ensuring that they don't escalate. That had momentum, and one of our mentors in this endeavor, Secretary Perry, strongly supports this idea. Ambassador Graham strongly supports it. Bill Urey wrote a book, one of the people who created the Harvard Negotiations Project, called Beyond the Hotline. The idea was to create an institutional structure to address crises. What do you think of that idea now? And it would certainly have to include the Chinese, but to build up a culture of people with expertise of diplomacy, technical issues, military issues, legal issues, to talk with each other on an ongoing basis to avoid nuclear exchange. Is that viable? Is that a good idea?
It is a good idea. It's not so easy at the present moment. I mean, the fact, and this also goes back to something Dr. Ford says, because other countries know that we care about nuclear conflict, they believe that they can use our concern as a point of leverage by rejecting the opportunity for dialogue. And that's been the Russian approach for the last 3 years.
Mm-hmm.
We do have an institutional mechanism, the National Nuclear Risk Reduction Center, housed in the State Department.
Mm-hmm.
Among other things, they handled literally tens of thousands of notifications under the New START agreement until Russia suspended its participation a year ago. But I was astounded to learn that one of the most important times we could have sent a message, we chose not to use that channel. When 3 years ago, shortly after the invasion of Ukraine, Russia announced it was putting its nuclear forces on a higher alert, the right institutional thing to build up such a mechanism would have been to reply through the Risk Reduction Center.
Mm-hmm.
We saw your announcement. We would welcome any further explanation of your announcement. We are not going to change our nuclear alert status. That message was conveyed through diplomatic channels, but not through the Risk Reduction Center created to convey such messages. And partly that's because I would wager 3 years ago, and definitely today, the top level of the State Department had completely forgotten that the Risk Reduction Center exists.
Mm-hmm. Mm-hmm.
So if there's a way to elevate it, to make it something other than routine, that would be welcome.
Well,
but it's got to be face-to-face contact as well between American and Russian experts.
It would have to be like no one washes a rental car, you know, and this was our car, that institution. The idea is to create a multilateral institution with that collective mandate So even the creation of it itself, in my opinion, even discussing the creation of it would have threat reduction value. And that one of the things that I've noticed in my years of advocacy at the UN is that the diplomats, if they were really free to have agency, many problems that we face would be solved.
Sure.
Because there's that there was that movie North by Northwest where that great scene in the delegates lounge, that delegates lounge is a place where a community exists. It's very much like college campuses, where people are interacting as human beings. And the more human contact that can be created, in my opinion, the safer we become. So the idea it would be to have rebuild that community, build that community. As George Shultz said, the coin of the realm is trust, and that's what's broken down. There was another point that I wanted to comment on was about the moratorium on testing. So we have the engagement of the American Bar Association in this webinar, and there was a resolution that I was very involved in this, a resolution by the highest body of the governing body of the ABA to support ratification of the test ban treaty. I am going to now advance, at least in pursuant to fulfilling that ultimate goal of that resolution, supporting the ongoing strengthening of the moratorium. Because that would be something that, and we could say it came out of this webinar, this idea, because I agree very much that should we go back to testing, it will be violating one of the principles of the NPT indefinite extension in 1995, where the test ban was specifically mentioned. What do you see of the future of the NPT now? The challenges to it and the possibility of its survival.
Yeah. I just spent the weekend in Istanbul discussing that question with colleagues from Russia and Europe and the Middle East. So I can't give a quick summary of that. The NPT is weakened in credibility, but is still strong in effect. And it still remains in the national security interest of every country in the world, even those who are not members of the NPT. So despite all the difficulties and despite the fact that we have contentious and unsuccessful meetings under the NPT, I feel quite optimistic about its continued relevance, importance, and durability. I wanted to, since you mentioned testing, there are two things that I think would make the people we identify as our adversaries, China and Russia, very happy. One of them is happening right now, the cessation of all US foreign assistance programs, creating a big opening for China. But the other is US resumption of nuclear testing, because it would give China, Russia, not to mention Pakistan, India, North Korea, the capability to elevate their level of physical knowledge about nuclear weapons up to the US level, which is far higher than they can achieve without testing. If I could make one more comment about how people perceive international law. First of all, I think ordinary people, whether lawyers or military experts or not, would find it hard to believe that the use of a nuclear weapon, even a so-called low-yield nuclear weapon, could ever be judged to not be indiscriminate and disproportional. I think that's ordinary people would see the arguments that our very good colleagues in the military have to make to be inconsistent with the fact of what a nuclear weapon is. Now, does that matter to most people? No, because international law does not matter to most United States citizens. It is an object of scorn by a significant number of politicians. It has been so thoroughly violated in recent years, particularly, but not only by Russia, that there is little to be lost for those countries to take it to the next step of a violation of international law. And our own citizens see a president who has issued within 10 days a number of decisions that are blatantly illegal and unconstitutional. And therefore, why do we even care about international law? It is correct that if there's going to be a change of direction in nuclear policy, a genuine reduction of risk, it will come about as a result, as has been noted, of a policy debate, not a legal debate. But still, since you were unwise enough to give me this platform, I'll make one more point. I admire so much the lawyers in the military who work on these impossible questions. I'm not a lawyer myself, but I have to give one little example. When I worked at the United Nations 30 years ago, my counterpart, another expert on the Middle East, from a friendly country, a country that's undeniably a democracy, told me he was going back to his capital to head the legal affairs department at the foreign ministry. And I said to him, I didn't know you were a lawyer. He said, no, I'm not, but that's not what the legal affairs department does. We find the justification for what we need to do. And I think that's concerning. I'm not pretending to give advice to people who have devoted their careers to this. But again, as an outside observer, I would hope that one job of a lawyer is to make decisions by his client defensible. That, I don't want to say CYA, but I want to say that they have a justification for what they do. But I think a bigger responsibility of any attorney, or for that matter, any advisor in policy, is to keep their client from digging themselves into an inescapable hole. And that's what nuclear war is. It is the ultimate inescapable hole, after which any post hoc legal justification will have no meaning and no audience.
Daryl, I would like to give you the floor because I know you probably got 100 ideas have come in. So pick whichever one you want to jump in on, because your expertise is to be respected here.
And Jonathan, we need to wrap up. The other panel is knocking at the door to come
okay.
50.
Okay. Daryl did it, and then we're gonna wrap it up. Okay.
And I say that with apologies. This is
No. It's my fault. I just got so involved in the wisdom that Tom was sharing that I
yes.
Yeah.
No, we have to
that was a fascinating conversation, Jonathan. Well done, and Tom, as usual, wise and eloquent. I'm going to leave it there. Some of my thoughts on the risks to the global de facto nuclear test moratorium are in the essay I put in the chat. There's much more to explore, but I want to hear more from Charles and the rest of the panelists. So thank you, Jonathan. Thank you, Tom.
Charlie, give me 15 seconds.
Of course.
We have to honor the fact that over 90 countries are supporting a treaty on banning nuclear weapons. There's no nuclear weapon states in it, but it's a call for progress by a lot of voices in the world, number one. Number two, the International Court of Justice, in addressing the legality, could not say that in all instances nuclear weapons were illegal because a hypothetical was put before them, whether using a weapon, a depth charge in the high seas or in the Gobi Desert. That exception to the norm, not the norm of how nuclear weapons are postured, is what prevented them from saying that in all instances. But because of the anomaly, they said, of a weapon that would destroy the state which was protecting itself, that the only solution to the predicament is negotiations to eliminate them. And that was a unanimous decision of the International Court of Justice, consistent with Article 6 obligations under the Nuclear Non-Proliferation Treaty. So as a bottom line, there's a legal obligation to have good faith progress toward abolition. It's not a fringe issue. It's not a marginal issue. It's literally fulfilling the supremacy clause of the United States Constitution, making the NPT the supreme law of the land. Charlie, I apologize.
No worries. And this next discussion, Tom, picks up right where you were on, and Jonathan, on the comments you were making. Does law matter? And we're all keenly aware, of course, of what's going on in Russia invasion of Ukraine. But on the other hand, and we're aware of the concerns, but there is a body of law there. There is a Department of Defense that put out a 1,000-page law of war manual. We have thousands of JAG lawyers who are struggling with the standards. And maybe a big thing is, how we apply this law. And maybe we need to be more aware than we have in the past that we can't just go by our deference in the conventional context to, well, the lawyer on the spot, the soldier on the spot has to exercise his or her best judgment, with the consequentialness of the nuclear weapons. We need to somehow get to the next level of what is the duty of care here. And then, we can't, I take it, convince the rest of the world of anything until we figured it out ourselves and gotten on the same page. Anyhow, sorry to launch into that, but I'm, trying to say the next panel, which Jeff, you're going to pick up on, is this very topic of, what is the role of law now? And do we have any basis for confidence that law matters? And we have the ICRC here as well. So you were referred to earlier. Jeff, take it away.
Well, great. Thank you very much, Charlie. And I think you pretty much, with that wonderful transition, really took everything that I was going to say in my introduction and said it better than I would. So with that, we're going to go ahead and just jump right into panel 3, which is contemporary realities as to the role of international law now and in the future as concerns potential uses of nuclear and other weapons. We've assembled another fantastic panel for this. We have Dr. Laura Grego, who is a senior scientist and research director at the Union of Concerned Scientists, where she focuses her analysis and advocacy on the technology and security implication of nuclear weapons, ballistic missile defense, and outer space security. She is the author or co-author of many peer-reviewed published papers on a range of topics, including cosmology, space security, and missile defense. She is a technical expert for the Woomera Manual on the International Law of Military Space Operations, an associate editor for the Journal of Science and Global Security, and a member of the American Physical Society's Panel on Public Affairs. We also have Lieutenant Commander Christopher Hart, who is a submarine officer on the permanent military faculty at the U.S. Naval Academy's Leadership, Ethics, and Law Department. He teaches elective courses on the law of armed conflict, the law of the sea, as well as core courses on law and ethics for naval leaders. Graduating from the Naval Academy in 2009, he has been stationed on the fast attack submarine USS Albany and the ballistic missile submarine USS Rhode Island, including 2 strategic deterrent patrols. He holds a Juris Doctor from the University of Maryland Francis King Carey School of Law. Bradley May is a legal advisor with the International Committee of the Red Cross, where he advises UN member states, the UN Secretariat, and internal colleagues on matters of international humanitarian law in a multilingual environment. Of particular relevance, he develops and promotes ICRC positions on arms and disarmament issues and participates in relevant fora with relation to autonomous weapon systems and nuclear weapons. And finally, we have Colonel Ted Richard. who is at the Staff Judge Advocate for United States Space Operations Command. He is the principal legal advisor to the commander of Space Operations Command, providing leadership and professional oversight for over 90 full and part-time attorneys, paralegals, and support staff at 2 U.S. Space Force garrisons and 8 deltas. In a previous assignment, Colonel Richard served as the Deputy Staff Judge Advocate at U.S. Strategic Command. All right, and to start our panel, we're just going to do a roundtable of opening remarks. And for that, I'll start with Colonel Richard.
Thank you. Hopefully you and everyone else can hear me okay. And I will start out with the, thank you. And I'll start out with the standard disclaimer that the opinions I'll be speaking about at today's panel are my own. They're not the opinions of DOD, of the Department of the Air Force, or any command I've ever been associated with. So I think I'd just like to start out. I think there's an important point about the law of war to this discussion, and I think international law in general. And I know Professor Biller and I have had discussions about international law, but I think important for this panel is to kind of remind people, especially if you don't have a military background, if you haven't studied military philosophy. Karl von Clausewitz is a strategic thinker, and he points out that there's what he calls the unchanging nature of war. His description of that unchanging nature of war is that war is always violence for a political end. And that violence will result in enmity and hatred, but that political end is always rational. So the law of war, to me, fits in that equation because it's the means one of the means of the rational political constraint on the violence to try to prevent that hatred and enmity from overriding. And I think what's important to keep in mind here as we talk about the role of law and its ability to constrain conflicts, I think people on both sides of the equation just need to keep in mind that if you think law does not apply to war, or shouldn't apply to war, or can't apply to war, you don't understand Clausewitz and the need for the political constraints on the violence. But on the other hand, if you think the law of war is going to be an effective constraint to violence in all circumstances, you have to understand that violence that hatred and enmity that comes with the violence can nullify the population's tolerance for a rational political end state, or whatever that was at the beginning of the conflict. And therefore it can serve people that don't want to have those legal constraints because that violence brings that hatred and enmity that can override. That's the important lesson from Clausewitz. So as we think about the application of international law, I would suggest that potentially if we're talking about nuclear weapons, it's really most applicable on the front end before the violence starts, because that's when it's most meaningful and it's mostly it's going to be applicable and people will be willing to tolerate legal constraints on force. I think they want the legal constraints once war begins, but that gets into a mixed bag. I'm not a political scientist, but I just throw that out there for people to keep in mind as far as the power of international law and how it will work in reality, and how I think if you go back through conflicts, you will see that over and over again, and it explains a lot of behavior of both politicians and warfighters. The other point I think is important to make just at the outset, and it's very unrelated to Clausewitz, but there was a former commander of what was Strategic Air Command at the time, who was also a JAG at one point in his career, and he had gone from being a bomber pilot to a JAG, back to being a pilot, and then worked his way up to 4-star as commander of U.S. Strategic Air Command, and that was General Doherty. And he wrote in a 1980s book that was edited by Ashton Carter, former Secretary of Defense, I believe under the Obama administration. But he wrote in that book that he had a major who, whenever they asked him if he'd be willing to turn the key to launch a nuclear missile, would always give a qualified answer about how, if the orders were proper and if it was legal, and he went through a whole litany of things that he would pulled the trigger on, and Doherty had him removed from nuclear missile duty and wanted him kicked out of the Air Force because he needed to be able to follow orders. And I think we all know that in the military, you have a duty to disobey clearly unlawful orders. And so where was the, how do you square those two concepts? And I think to me, it took a little bit, and I've had conversations with General Kaler, and he wrote in a Dedalius article several years ago, and explained that the issue is in the missile silo, we're on a submarine. The people who turn the key, they can't make that legal analysis because they're not going to have any of the strategic concepts of a conflict in nuclear war. They are not going to necessarily know what the targets are because they'll have been given coordinates. And so unless they have coordinates ahead of time, they wouldn't know what they're striking. So it's important for operators, and it's important for I think this discussion to understand that the legal analysis has to happen and does happen at the highest levels of command. So for nuclear weapons targeting, the legal analysis really happens where it gets planned, which is U.S. Strategic Command. The different subordinate commands can recommend targets, and they'll have a legal analysis when they recommend it. But ultimately, those plans happen at U.S. Strategic Command. And then as they leave DoD, because it's the decisions to launch are at a very high level, they'll get looked at and scrutinized again at the DoD level, potentially by the State Department and Justice Department level, depending on the time to coordinate. And then the president has his own legal advisors. And maybe not under the current administration, but we've had several administrations where the president himself was trained as a lawyer. So and even when they are not trained as lawyers, we know from Reagan and we know from statements from other non-lawyer presidents that the law and morality weighs heavily on their decisions. But that's really, I think, some of the key concepts to keep in mind as we have these discussions. So that's my opening remarks.
Great, thank you. And no conference dealing with military matters is complete until we have a discussion of Clausewitz. So I appreciate you for checking that box for us. All right, and now I'd like to turn it over to Mr. Mabe.
Thanks very much, Jeff. It's a pleasure to be with all of you. So I want to sort of frame our discussion a little bit by just by making sure that we're clear on the legal landscape that we're talking about. I don't want to repeat our previous panel. I think it was really excellent, and I would recommend it to any attendees who are just joining us. But I want to, lay all of that out and say a little bit about who believes what about it. So. We were not always in this situation where we are now, but I think now we're in a place where it's fairly uncontroversial to say that any means and methods used in armed conflict, including nuclear weapons, must comply with the rules and principles of the law of armed conflict. So these rules include distinction, the prohibition of indiscriminate attacks, proportionality, precaution, as well as other rules and principles like the prohibition of unnecessary suffering and protections for the environment. These rules apply in any circumstance, regardless of whether a party finds themselves in a situation of armed conflict via the use of self-defense or for any other reason. Now, states that have nuclear weapons obviously believe that they can use those weapons in conformity with the law. Several of their allies would agree. For the ICRC, it's our position that it's extremely doubtful that nuclear weapons could be used in accordance with the rules and principles of IHL. But at least 73 states go further than that. In the Treaty on the Prohibition of Nuclear Weapons, which more than half of the states in the world have signed and 73 have ratified, they say that any use of nuclear weapons would be contrary to the rules of international law applicable in armed conflict. So there's a range of beliefs when it comes to applying the law, but I think it's positive that we're in a place now where we can agree on the very basic that the law does apply to the use of nuclear weapons.
Okay, great. Thank you very much. And Lieutenant Commander Hart.
Hi, thank you, Professor Biller, for moderating this, and to my fellow co-panelists for what I'm sure will be a robust discussion. I should start off by emphasizing that although I am licensed to practice law, I'm not a JAG. I'm in the Navy. I'm an active duty submarine officer, so my perspective may be a little bit different on some of these issues than my colleagues, and hopefully it's valuable. I should also mention that these are my personal opinions. None of this necessarily reflects the position of the U.S. government, Department of Defense, or the Department of the Navy. Having said that, I want to take a question that Jonathan Granoff asked at the very beginning of this today. I want to answer it directly. Jonathan, you asked if Nuremberg is still relevant today. And I want to answer with a definitive yes, it is. And I want to explain why. In that context, to your question, you're referring to the Nuremberg tribunals, which was, as probably everybody here knows, just a monumental moment in international law and international criminal law. It communicates through the ages something very powerful to military commanders. It communicates an idea that was fairly novel at that time, which is military leaders cannot hide behind the shield of the state from the international community when they violate international law. The tribunal held that it was people, it was the men being charged in front of the tribunal who violated international law, not the state, and they'd be held accountable for that. Also, importantly, from the Nuremberg Tribunal, we get this idea that military leaders also can't hide behind the shield of following orders. Many German leaders tried to do that, and many of them were hung because their defense failed. So many of the panelists have already mentioned this idea that comes out of Nuremberg, which is that military leaders only follow lawful orders. That is the extent of their legal obligation, and they have a duty to disobey clearly legal orders. That finds its way into more modern criminal tribunals, the ICTY for Yugoslavia and ICTR and the other hybrid tribunals that occurred in the 90s and early 2000s. Those ideas followed into those tribunals, and Nuremberg's fingerprints are all over the ICC. And I have to imagine that my counterparts in the Russian military, who for, almost 3 years now have been living a reality where their president seems quite willing to use nuclear weapons in a context that they probably had never thought very hard about, I have to imagine they've noticed that the ICC has issued arrest warrants for 6 Russian leaders, despite Russia not being a member of the Rome Statute. And I have to imagine they realize that the international community is going to take a harder look at a war crime associated with the use of a nuclear weapon than almost any other war crime. And so they must know that if indeed they execute an unlawful order, they are going to be at the top of the list for prosecution by the international community. Now, I've written elsewhere that I think, based on the facts in Ukraine, that any order to launch nuclear weapons against Ukraine in the present crisis would be clearly illegal or manifestly unlawful in the terms of the Rome Statute. And I think my counterparts in the Russian military must realize that. Having said that, I should emphasize, as many others have said today, I think that the legal analysis for a nuclear strike is heavily fact dependent. With the right facts, a nuclear strike could be lawful. And I think we'll explore a little bit more in this panel what those facts are. And I think I'm at the end of my time for intro remarks. So I'll end it there and we'll pick up the discussion a bit more in a little bit.
Okay, great. Thank you, Commander Hart. Dr. Grego.
Hi, can you hear me?
Yes.
Great. Well, thanks for the invitation. And I wasn't able to see all of today's panels, but what I did see was excellent. And at the risk of repeating some of the context, I thought I would, I've been invited here as a scientist and to talk about what we know about the effects of nuclear use. And so I thought I'd lay out what we know, especially what's included in the legal analysis that we believe in and what is excluded and what are the limits of what we know, because that'll be important as we go forward. Well, according to a 2024 study by the National Academy of Science and Engineering and Medicine that was looking at the risk analysis methods for nuclear war and nuclear terrorism, and that was informed by classified briefings. The Defense Threat Reduction Agency provides estimates of the impact of nuclear weapons to most of the Pentagon. And that consequence assessment is focused on prompt effects and military objectives, as well as whether the nuclear use would impact US and allied troops' ability to continue to fight. DTRA uses probabilistic models for targeting and for damage estimates. They focus on blast, cratering, ground shock, dust, fire, essentially prompt thermal and air blast effects. It's less clear how things are included, although of course some people in this audience may know specifically, but from the external point of view, how much is included in terms of high altitude electromagnetic pulse. But as the National Academies say, this certainly results in a partial accounting of the consequences, which lead us to have a limited understanding of the breadth of the outcomes and neglects the broader and longer term effects. It certainly doesn't include political, military, economic, social, information, and infrastructure impacts. Those are not included in the models. It doesn't include climatic effects such as nuclear winter, and it doesn't include the assessment and estimation of psychological, societal, and political consequences of nuclear weapons use. That nuclear war would be catastrophic and potentially immediately kill hundreds of millions of people. That's been known for decades. But we do have reason to believe that our current knowledge is incomplete as for the full effects of nuclear war, and some of it is definitely out of date. And we don't have, in general, a public repository of the most up-to-date information. The last time the United Nations commissioned a report to do that task, to pull together everything we know, was its 1988 study on the climactic and other global effects of nuclear war. Since then, the world population has grown, it's changed in distribution, economies have become more interdependent, the environment has become more fragile, and also new scientific information has yielded insights that we should bring to bear on these questions, including updates to our understanding of and our ability to model the atmosphere, studies of the long-term effects of radiation on affected populations. Those studies have yielded new information. Some of that technical work has been presented in the 4 conferences on the humanitarian impacts of nuclear weapons. Those were lead-up events to the Treaty on the Prohibition of Nuclear Weapons. But it's also clear that additional research continues to be needed. We still have important knowledge gaps. New studies are still being published and commissioned in those research gaps. There have been recently updated studies published about the radiological fallout impacts of atmospheric nuclear detonations and of ground bursts. Ground bursts is a particular problem in scenarios of counterforce targeting, which we have reason to believe form many of the targeting plans, where hardened military installations are part of the target set, and so ground bursts might be used. Recent research out of Princeton took a relook using updated models at what fallout effects would be of a counterforce attack on US missile silos in Colorado, Wyoming, Nebraska, Montana, and North Dakota. And for a simulated attack on any day of 2021, those scientists computed the resulting fatalities, and the estimates ranged from 340,000 to 4.6 million, really depending on the way the wind blows on any given day. So, and just where those people lived and how many would be hurt depended really sensitively on the weather predictions. But based on historical weather patterns, there's essentially no place in the US that would be immune to those fallout effects. So this points to an important point that civilian effects may depend sensitively on conditions just at that moment. Are we prepared to have, to present decision makers with those to-the-minute models? Especially if the US president has the ability to exercise their power to launch promptly, they may not have that complete information. Another thing we know, and this has been mentioned in this conference, of course, is that fires will surely be ignited, and under some conditions, they may transform into a firestorm and loft black carbon soot high into the stratosphere, where it may persist for months or years, and that'll decrease the sunlight that reaches the ground. This nuclear winter issue has been studied for decades, but a recent relook has looked at even a smaller, lower exchange of nuclear weapons that might have the ability to produce these long-lasting effects, which might create famine, kill hundreds of millions or billions of people. The National Academies is looking at the science right now and is expected to publish its study. It was expected last year, so hopefully we'll see it sometime soon. In the 2022 report, the National Academies urged the development of a research program to better understand the effects of low-dose ionizing radiation, which might persist for years, using recent advances in epidemiology. And it's also been clear that our understanding of how radiation affects women and children differently than men is incomplete. So to kind of sum up, there's an enormous amount that we don't know. And what we do know is not all included in our calculations, but the U.S. National Academies of bottom line in their study was that we do need to improve the understanding of our less well understood physical effects of nuclear weapons, such as fires, damage in modern urban environments, electromagnetic pulse effects, climactic effects, as well as the assessment and estimation of psychological, societal, and political consequences of nuclear weapons use.
Great, thank you. That was very comprehensive. Just a quick note/warning. This panel is going to be a little unusual because we have Congressman Ted Lieu of California, who's going to be joining us, I think, in about 15 minutes. So what we're going to do is work right up until then and then take a brief break for his remarks, and then we'll come back for the remainder of the panel. So just giving a heads up on that. Okay, my first question that I have, we're talking about contemporary realities right now, but the reality is that we have a long history where we can examine the compliance of international law as it relates to military strikes, including nuclear strikes. And so my question is, are there any lessons from history regarding compliance to the laws of war that we could apply to the potential use of nuclear weapons in today's environment? So to start with that, I'd like to turn to Colonel Richard, because I know you are a bit of a history of the law of war aficionado, let's say.
Thank you for that, Jeff. Yeah, and I think most people are probably familiar with my the article I published in Military Law Review several years ago, and I'm sure there will be a link to it in the materials at some point, and if I'll make sure that they get in the Georgetown Journal when that comes around for review. But let me just start out by saying that I have learned in my studies of history that there really are no lessons of history, because history is not determinative of the future. So I think you see trends in history, and I think we can go over examples of history, but history is always very contextual, and there are a lot of variables that can really lead to unexpected results. But as far as the U.S. goes, I think it's important to start out in a historical discussion that the U.S. has traditionally been a leader in international law and law of war developments. I think when you look at the Declaration of Independence, it's very clear in there that a lot of it is based off international law violations that King George committed against the colonies. And then when you look at George Washington, it was very clear that the law of war really mattered to him. I think he saw it as an affront to his honor when, as a colonial major, his forces executed without his orders the French that he had taken over during the French and Indian War, the event that triggered the war, and that resulted in him becoming a disciplinarian. And then the colonists and Washington's army also saw the advantages, the political advantages in treating prisoners well and law of war compliance, because it helped their political cause. And then during the American Civil War, of course, the Union Army unilaterally issued the Lieber Code, which had law of war rules in it that would apply to them, even if it did not apply to the Confederacy. And then that became kind of the inspiration for a lot of the codification of the law of war that we have subsequently seen. Then I think if you fast forward to World War II, an aerial bombardment, I think there was a perception that all sides were attacking civilians. So at Nuremberg, there were no cases brought against the Germans for their air attacks, for the V2s, for the bombing war against Britain, because it was perceived that all sides were doing it. And all sides were frequently justifying the attacks under an industrial worker theory, and also due to a lack of precision. So when you look at the two nuclear well, they were atomic weapons, slightly different physics from what I understand, at the end of World War II. Hiroshima was a giant military deployment center, and where they put their forces together for overseas operations. And if you look at the amount of military facilities in Hiroshima, it's significant. And I think even at the memorial the Japanese have, one of the opening lines is Hiroshima was a military city, and by that they mean it had such a large presence that the military was kind of the engine driving the entire economy of the city. Now, Nagasaki was slightly different. It was an alternate target. The primary target was a giant arsenal, but Nagasaki had military industry that was seen as valuable. It was an alternate target, but it was ultimately struck because of that. I believe it was a torpedo manufacturing plant. I forget what the other one was, but they were both put on the target list because they were considered to be valid military targets, or had those valid military targets in the area. And at the time, there was not, I don't think, at least I can't find any record contemporaneously, that people understood the radiation or the radiological effects of the atomic weapons they dropped. It was very clear that they understood what the TNT equivalency was. And so they did not see that as a significant difference from, let's say, the bombing of Tokyo that had happened weeks prior. So that was the template that the United States then entered the Cold War with. And so when you look at the declassified plans, the war plans from the 1950s, there were categories in those plans of civilian populations to be struck. And I think that's because at the end of World War II, people just kind of put cities as targets, and they saw civilians as civilian industry and again, industrial workers. In 1968, there was a General Assembly resolution about the application of the law of war and international law to nuclear war. And the U.S. made a declaration at that point that does say, that recognized that the law of war did apply to the use of nuclear weapons, specifically proportionality and no attacks on civilian populations. So then what we see in the declassified war plans from the 1960s is that the population targets then were removed from the U.S. Targeting lists. It's clear that civilians would have still been affected, so I'm not saying that, but they were not expressly targeted anymore. So again, what that tells us, and I think what the trend for the rest of this is once the U.S. says something about its obligations under the law of war, it follows the obligations to the best it can. Now, the law of war got better defined in the late 70s with the negotiation and eventual signature of Additional Protocol 1 to the Geneva Conventions, and that really defined a lot of the targeting rules. The U.S. signed it, but then, of course, in the 1980s, they rejected the treaty as being applicable, although they recognized aspects of it as customary international law. I think Alan Weiner mentioned that he worked with Matheson and discussed, I think, a lot of Matheson's statements on that. I think what's also important to keep in mind is, I think with Additional Protocol 1, what that also came with is when you look at the 1980s, probably starting around Grenada in 1983, but definitely up through Panama and then Desert Storm, is you start getting the judge advocates in the military who prior to that really were focused mostly on military justice, where they started really getting heavily involved as law of war advisors, reviewing plans, reviewing strike lists, and doing that type of work. And that really came into its own in the 1980s. And then we saw the results in the 1990 Gulf War. The other thing, if I could back up a second on Additional Protocol 1, the U.S. went into the negotiation, as did some other countries, the nuclear powers, and made clear that Additional Protocol 1 didn't apply to nuclear weapons. So then when we look at the International Court of Justice Nuclear Weapons Advisory case, to me, what's critical there is what was the U.S. position going into that case. And again, Matheson, who had made some of those declarations on Additional Protocol 1 in the 80s, in the 90s during the nuclear weapons case, he has both, you have his verbal arguments right on the ICJ website, but you have his verbal statements to the ICJs along with the U.S. written filing there, where he pointed out that the new rules that are in Additional Protocol 1 do not apply to nuclear weapons, but existing law of war does. So if the law of war is a lex specialis of international law, then the U.S. views the employment of nuclear weapons as a lex specialis within that lex specialis. So what my paper tried to do is explore what that might be and what that potentially could look like and what rules would apply. I think what's also important to point out, though, is as along that time with the nuclear weapons, and we don't have declassified war plans that I'm aware of from the 90s or subsequently. But what I'm also aware of is that right around the same time as the nuclear weapons case, the DoD started publishing joint doctrine expressly directing. Now, doctrine is not absolutely something that you have to follow, but the doctrine made clear that the law of war applied to nuclear weapons and spells that out at the outset of the doctrine that was published in the 90s. And then the DoD of Law of War Manual, the Obama administration, and the Biden administration have all made clear in their directives to the military and the DoD, and the DoD Law of War Manual still applies. But they've all said that the law of war, at least with those key rules for valid targets, proportionality, precautionary principles, that does apply to the employment of nuclear weapons. I think the Biden administration nuclear posture review directed readers back to the DoD Law of War Manual for the applicable rules. So again, my main theme is that the U.S. has been a leader in this area, but it does what it says it does, and I think it's fearful to overstep and make the rules too restrictive, I think, as one of the early panelists pointed out, because adversaries tend to use these rules against us. Hopefully I answered your question.
No, that was a tour de force of history, so thank you. All right. And Charlie, I'm going to rely on you to let me know when Congressman Liu is ready, but I'm going to keep going for now, unless we are ready to jump in.
Nope,
Okay.
I don't, but I think Kara will know and will tell us.
Great. Thank you.
Thank you.
All right. My next question is kind of for both you, Mr. Mabe, and Dr. Grego. And I'm going to start with you, Mr. Mabe, but because Dr. Grego pointed out a lot of fantastic things about things that we don't know as to the effects of nuclear weapons, right? We know a lot more than we did in World War II, but there are still a lot of unknowns. And so I'd like your opinion on how does that affect our ability to even come to a lawful decision as to the use of a nuclear weapon if there's so many unknowns about the potential effects?
Yeah. So as you say, there are a lot of unknowns, but at the same time, there is a lot that we do know. Even if some of this research is not the most cutting edge, we know how nuclear weapons works. We know what many of the effects of them will be. We know that they'll have massive destructive power that's difficult to contain in space and time, radiological effects that spread over an unpredictable, uncontrollable area, immense quantities of heat and kinetic energy. And we also know that there is no adequate humanitarian response capacity in cases of the use of nuclear weapons. And so each of these things that we do know, to the extent that we know them, needs to be taken into account. Now, what about that we don't know, to your actual question? The laws of war prohibit indiscriminate attacks, so those attacks that can't be directed towards a particular military target. And there's also the prohibition that was thoroughly discussed of attacks that would be disproportionate. So to the extent that the effects of a particular strike are unknown, or in particular unknowable, it makes it much more likely that a strike would fall afoul or of one or both of those prohibitions. Yeah, maybe I'll leave it there for the sake of time. Thanks.
Okay. Yeah, and to follow on with that, then, Dr. Grego, as to a lot of those unknown effects, given some of the advancements we have, such as using artificial intelligence for modeling, what's the prospect of getting to a much more refined understanding, even in real time, right? Because as was mentioned several times, a lot of it just depends on the weather, as you mentioned, right? What are the prospects of getting much more refined knowledge as to precisely what the effects would be if a nuclear weapon to be used, such that we could then answer some of these legal analytical questions that we have?
Oh, that's a good question. I mean, the question about which way the wind blows, that's driven by the desire and need for prompt response, right? If you can take your time and choose your times, then you can say a lot more about which way the wind's blowing. And I think I actually have never run one of those models. I don't know how long it takes and how intensive that is. Maybe it could be sped up. That's not something I know so much about. There are things, and I think I agree with Mr. Mabe that there are things that we, in sort of echoing what we heard earlier in some of the panels, there are things that are foreseeable. We might not know exactly what the effects are. As I mentioned, sort of economic impacts. We have a different sort of economic system than when we last did the last studies I could find that looked at the economic effects of nuclear war were in the 1980s. That's kind of fallen out of fashion with economists these days. But back then they indicated that even a relatively limited nuclear war could cause a US economic collapse that would take many years to recover from, and larger scale attacks could cause damage from which a country's economy could never recover. So I think it would actually be really important to understand how that works. And I'm sure FEMA has some ideas about those things, but I don't know that those models would be incorporated into decision-making. And so to your larger question about, how do you make good legal decisions? I think when you're talking about foreseeable consequences that could be existential, and some ways of prosecuting nuclear war can be existential, especially when you don't know how to control escalation properly. It's hard for me to imagine that this would be purely a bureaucratic legal analysis, or sort of, that seems very parochial, to be honest. Then it really should be a policy question and of course, a much bigger discussion. So I agree with Brady that we know enough to know that those decisions probably should not be solely legal decisions. Even if we start to get a hand on some of the finer points of consequences.
Okay, great. Thank you.
Let me.
I believe. Oh yeah, go ahead, Charlie. I think we've got the congressman.
Yes, we do. So, Kara, could you bring in Jules Zacher, and we have Congressman Ted Lieu. Welcome, sir, and Jules, take it away. I think you're muted, Jules.
Sorry about that.
There you go.
Thank you. Good
Welcome.
afternoon, Congressman. How are you? Can you hear me?
I can hear you. It's a little less clear.
Okay. How about if I talk more into the, can you hear me better now?
Yes.
Great. By the way, thank you so much for taking the time to meet with us today. Given the, I think the last time I spoke to you, I think you used the words crazy conditions that are going on in Washington right now. And I appreciate your taking the time to meet with us. Thank you so much. By way of background, Congressman Lieu is an American attorney, politician, retired military officer who has represented California's 36th congressional district in the U.S. House since 2023. Congressman Lieu came to the United States from Taiwan at the age of 3. He studied political science at Stanford and then attended Georgetown University Law Center, where he was editor-in-chief of the Georgetown Law Journal. He then clerked for Judge Thomas Tang of the U.S. Court of Appeals in the Ninth Circuit. He then joined the U.S. Air Force, serving 4 years on active duty as a member of the Judge Advocate General Corps. He left the Air Force to enter local and state politics before being elected in 2014 to fill the seat of Congressman Henry Waxman. While serving in the House, he has introduced 2 important bills I think that are relevant to this conference, including restricting the first use of nuclear weapons and keeping a person in a loop in the selection and targeting of a nuclear weapon. So now let's go to the questions that I wanted to ask you, Congressman, if I may. The first question I wanted to ask you is as follows. Can you comment on the recently proposed Iron Dome order of President Trump? By way of background, President Trump has issued an order which calls for the building of a missile defense shield for the United States. More specifically, how might this order violate the law of armed conflict, and particularly whether it may exacerbate any arms race and encourage first use?
Thank you for that question. Let me first thank the international section of the New York State Bar Association for hosting this conference and for all their participants. Specifically to your question, I simply want to note that the United States of America has, in fact, been working on an Iron Dome since 1983. It's called the Missile Defense Agency. It was renamed the Missile Defense Agency in 2002. The mission of the Missile Defense Agency is to develop and deploy a layered defense against missile threats to the United States. So basically what Trump did is he is pretty amazing at branding. He just came up with a brand for it. He just renamed it, essentially. But there is nothing new here whatsoever. It is something the Missile Defense Agency has been working on. Now, what Trump is talking about, if you want to be very literal about it, Iron Dome is designed for short-range missiles. So the primary threat from the United States is not short-range missiles being launched from Canada, right? It is basically intercontinental ballistic missiles. So that's what the Missile Defense Agency has been working on, is to find ways to basically take down ICBMs being launched from, let's say, Russia or North Korea and so on. So I'm not sure there's anything new here. Now, also directly to your question, I know we have Colonel Richard here, who's a Air Force JAG. Just having taught the law of armed conflict, I don't think there is any violation of LOAC for a country to try to, find different ways to defend itself from missile threats.
Okay. So just by way of follow-up then, do you think that the missile defense is in any way exacerbating the arms race or encouraging first use?
Right. So to that question, you may all remember when Ronald Reagan, came up with the Star Wars initiative and SDI, there was talk about how that would sort of fuel an arms race. And I suppose it's possible. I just note that the work of the Missile Defense Agency has been going on for a very long time, and it is very difficult work. I don't think we are anywhere technologically close to be able to stop a large number of ICBMs if they were to be launched from Russia or let's say China. I think what the Missile Defense Agency is trying to do right now is to see, could we take down one ICBM or maybe two if North Korea actually got the ability to launch one that was fairly accurate. So I think just technologically we're very, very far away from being able to do any of that. So it's not clear to me it would fuel an arms race. I myself don't think it's great to invest resources in this because of how technologically challenging it is, how far away we are from being able to have any sort of Iron Dome. And I don't see any way of being able to shoot down a massive launch of ICBMs from a nuclear country like Russia or China. And even if you could, as all of you know, it's just going to result already in devastating effects that even if a few landed, it would be catastrophic. So I'm not a big fan of this. I just want to note that I don't think it's anything new that the president is announcing. He's just very good at branding stuff and then try and take credit for something that's been going on for decades.
Yeah, by way of that, I think the Israelis, that's what they call their system over there, Iron Dome. Second question I had for you, your proposed law entitled Block Nuclear Launch by Autonomous Artificial Intelligence Act of 2023 discusses compliance with international humanitarian law, human control, and human legal judgment in any launch. If arguably nuclear weapons are illegal because they are indiscriminate and disproportionate, how can any launch comply with international humanitarian law, irrespective if there's a man in the loop asserting meaningful human control?
So thank you for that question. So I've got I've introduced several pieces of legislation on nuclear weapons. So one is with Senator Markey that basically says that the President of the United States cannot engage in a unilateral first strike.
I'm sorry for interrupting, Congressman. I'm going to ask you about that as well. That was my next follow-on question, but go ahead.
Without congressional approval. Now, I also introduced a bill, the one that you're referencing right now, because I was concerned that with increasing automation of weapon systems through the use of AI and other technologies, you could get to a point where our Defense Department has an automated system for launching nuclear weapons. So I was able to put into law basically a provision that says, essentially, no matter how amazing AI ever gets, we're never ever going to let it launch a nuclear weapon by itself. There's got to be human control. Separate apart from that, I just want you all to understand something. So the State Department last term had the first plenary session on the responsible use of AI in automated weapons. So I spoke at that plenary session. There is a document the State Department has that's got 60-some countries that have now signed on it on principles for the responsible use of AI for automated weapon systems. That document does not include nuclear weapons. I think it should, and you all might want to look at that and maybe push the State Department to include nuclear weapons into, their principles on how to have the responsible use, because we shouldn't be automating, launching nuclear weapons any way whatsoever, is my view. There always has to be a human, or what I want is actually much more humans to be engaged in any decision regarding nuclear weapons. So that is law. Now you do have to have humans engage in the launching nuclear weapons. I still think it's unconstitutional for the president to order a first strike, and maybe that's your next question.
It was actually more specifically. Well, I'll ask you the question, but it's within the context of sole authority and artificial intelligence, which is an interesting nexus, if you will. My question is, while you do state within another of your proposed legislation that any launch should not be made by artificial intelligence, do you think artificial intelligence, particularly within the context of nuclear weapons, is inherently destabilizing and therefore may violate international maritime law, because any decision to launch would be compressed and may rely on inaccurate information, even though we heard earlier that makers are relying on up-to-date information?
I do. I believe it is inherently destabilizing. Let me just take a step back. I'm also a recovering computer science major. And just sort of looking at AI, and the AI I'm going to talk about are basically the large-scale generative AI models, the large language models. The one thing I want folks to understand is, at the end of the day, we don't actually know how they work. We know they get the right answer most of the time, but because they are so complicated, it's basically, a bunch of linear algebra equations being computed very quickly, simultaneously. And essentially, we can't trace from point A to the conclusion how the AI algorithm got there. So it could be that this AI algorithm is correct 99.9999% of the time. But there could be some random scenario that human beings never thought of where this AI thing goes berserk and then decides to launch a whole bunch of nuclear weapons. And because we don't really know at a very fundamental level how these large language models work, we should never, ever have it control nuclear weapons ever, is sort of my view. And that would be inherently destabilizing also because of how quickly computers act. And, if this AI thing does something totally bizarre, there may not be enough time to stop it. And let me just give you a very sort of concrete example to tell you what I'm talking about. So researchers, for example, were trying to figure out, hey, can we use AI to determine if someone has tuberculosis by looking at X-ray scans. Because if you could do that, then maybe we need like less radiologists, right? So they were doing this program and during the development, and it looked like it was going pretty well. It was being pretty accurate. So then they deployed it. It totally failed. And afterwards, after they did some testing and they were trying to go through it, they figured out what was happening. Basically, the AI algorithm was simply making determination, hey, am I looking at an X-ray scan from a newer machine or an older machine? Because it turned out that people who got tuberculosis were folks in poor areas. They had, less advanced X-ray machines. And then folks who had really advanced X-ray machines were in areas where they weren't allowed tuberculosis. And so the AI algorithm was following this pattern that no human being would have followed, that no one even thought of. And so that is the fear. And they didn't know because they cannot trace what pattern this AI was following. Because again, at a fundamental level, we don't know how these AI models work.
I just wanted to follow up on that, if I may, and put it within the context of sole authority. And my concern is that artificial intelligence could very well reinforce, to some degree, the authority, if you will, of the president to launch on his own authorization or authority. My question is, do you see that as a role that AI might play, that it would exacerbate the possibility of sole authority, and particularly in light of what you just said about how, I think the term is hallucination, I'm not sure, could play a role in making the wrong decision, how that could exacerbate a nuclear catastrophe?
That's a very interesting question. So there is, I think, a fear, right, that people will rely on AI because it's AI, that because AI model algorithm says something, therefore it must be correct. And so one thing I've been trying to do is, because you'll see sort of in the tech sector or even in the government agencies, they'll talk about, AI safety and reliability, or they'll use terms like, AI safety or trustworthy AI. In fact, I think the NIST, the National Institute of Standards and Technology, has a whole section on, building trustworthy AI. And I keep saying, I don't think we should use that term. Like, I don't want people to ever fully trust AI, because that's, again, at a very fundamental level. And the AI I'm talking about are these large language models. We don't really know how it works. And so I want people to always have in the back of their mind, maybe just because AI says it doesn't mean it's true. And so, yes, there is that fear that people might be making decisions solely because AI says it, and they think it's sort of ironclad. And that will be bad in nuclear context. Now, I also note that this is also a problem sort of with technology in general. People do have a trusted technology, and because, sensors say something, therefore they think it's true. And so you all know of that celebrated case where, right, these sensors, I think, were detecting the rise of the moon or something like that, and it looked like it was basically going to be a all-out nuclear launch from Russia. So it's not clear to me AI makes it worse. I think it might be just more a technological thing where human beings might put too much trust in technology that might not be warranted.
Let me jump in, Jules. We are running against the clock again, as has been happening to us all day. We should really have made this a two-day conference, but we've got to roll forward.
Sure. Well, Congressman, thankfully, I don't have any more questions, and I really want to thank you for taking the time to talk with us today. Most appreciative.
Thank you. Thank you for all you do to try to make our world a safer place.
Thank you, Congressman.
Thank you, Congressman. Jeff, back to you.
Okay. All right. We'll pick back up. So my next question is going to be for you, Commander Hart. There's been a lot of discussion today of low-yield nuclear weapons. And in the context of, the ultimate question we're getting at with this panel is, how much is international law and legal advice going to matter within the context of potential uses of nuclear weapons. Is there a way in which you might actually, somewhat ironically, see more legal influence on the use of a low-yield nuclear weapon, because it would be more likely to be used within the context of a military operation, right, as opposed to a strategic use where the intent and purposes behind the use of the weapon might go well beyond military parameters. So do you think you might see a different approach to legal analysis, or maybe not so much approach, but a more of an emphasis on legal analysis as it relates to low-yield weapons?
Thanks for the question. The short answer is yes. I do think you have a different analysis. On the one hand, I think that international law is more likely to say it's lawful to use a low-yield nuclear weapon. So it might not actually be a bar. And let me explain why I say that. In the realm of international humanitarian law, which is a primary body of law we're talking about here, the major things that control the legality of the use of nuclear weapons are what are you aiming at? How much collateral damage is there relative to the military advantage? We'll call that the principle of distinction. You have to aim at a valid military objective. And the principle of proportionality, you can't have excessive civilian harm relative to the concrete and direct military advantage. When you talk about low-yield nuclear weapons, you're talking about something like Hiroshima level, which is a bit shocking to call low yield, but by modern standards, that's low yield. People will refer to low yield as really anything below Hiroshima, and there's some weapons that have a much lower yield than Hiroshima, but even as much as 3 times the size of Hiroshima. In fact, earlier in the Russian war, it was publicly reported that some of the tactical nuclear weapons that Russia was moving to Belarus were 3 times the size of a Hiroshima weapon. Now, those are massive, of course, but they're much lower yields than the thermonuclear weapons, which get a lot of the focus, appropriately so, in these discussions. A thermonuclear weapon, it's not like these low-yield weapons. It generally uses a different type of nuclear reaction, fusion, vice fission, and fusion releases way more energy. And just as a point of reference, in 1954, Castle Bravo was one of our first thermonuclear tests, and one device had an explosive yield 1,000 times of Hiroshima. So there really is a massive difference between high-yield thermonuclear weapons and low-yield weapons, which means, as a practical matter, there's far fewer targets you can hit with a thermonuclear weapon in far fewer circumstances, because there's going to be a lot more collateral damage when you have a weapon that is potentially thousands of times more powerful than Hiroshima. So you can run the analysis with a low-yield weapon and maybe get to yes more easily than you can with a high-yield weapon. So that's one way that the analysis is different. Another way that it's different, and I think we're seeing it play out a little bit on the battlefield right now, about a year or two ago, when it's been publicly reported that it seemed like there was a 50% chance that Putin was going to use a low-yield nuclear weapon in Ukraine, it seemed pretty clear that it wasn't going to be a thermonuclear weapon. If it was used, it was going to be one of these low-yield weapons. And I think it matters that the Russians didn't do it. Now, I don't think it's because Putin was staying up late at night reading the UN Charter and decided it wouldn't be okay, but I think it's a reality that one low-yield weapon isn't necessarily going to lead to the end of the world. It could, and that frightens all of us, of course, but it's much less likely to lead to escalation than the higher yield weapons. So there's going to be legal structures left over after a weapon like that is used. There's going to be other international players who have to respond to that sort of use. And I think Putin probably accurately got the sense that even his own allies would not be able to justify using a low-yield nuclear weapon in Ukraine. And certainly his adversaries were going to respond in some way. And I think international law has a lot to do with shaping both his allies and his adversaries' responses to such an action. And I think he sensed that, or at least I like to. Maybe there was something else going on completely. So yes, I think low-yield nuclear weapons are more likely to be used, they're more likely to be lawful. Whether or not that's a good thing is open to much dispute. But I do think it's telling that of the weapons that were being considered to be used in Ukraine, it seems to have been a low-yield nuclear weapon, vice a high-yield one.
Great, thank you. Another question I have kind of on contemporary issues is, as I was doing my research for my last paper and going through military manuals from kind of the various nuclear weapon states, I was struck by how vague a lot of the language was when discussing legal limitations on use of nuclear weapons as opposed to conventional weapons. So, Colonel Richard, I ask you, is this vagueness, is it intentional as a matter of deterrence strategy? Is it vague because states are still unsure exactly which rules would apply and which ones might not, or how they might apply? Just what's your impression with what's going on there?
So I think there's always a tension, and I think I mean, I think with nuclear weapons deployment, it's probably greatest. I think there's a tension between the angst with the civilian community and communities like this about wanting clarity, and the concern from policymakers and leaders about deterrence. And if you spell out rules too much, how the adversary is then going to adjust their employment of forces employment of forces in response. So, for example, if we came out and said that, hey, we're going to start applying a proportionality value that's mathematical, where that if you kill 20 civilians to take out a leader, then that's going to be disproportional. We know how the adversary is going to move their leadership, and we know that they're going to be putting their military objectives even closer to the civilian populations. That was part of the concern, I think, that the U.S. had about Additional Protocol 1 during the negotiations. During the Vietnam War, we were constantly complaining about how the Vietnamese SAMs were located in their civilian centers that were shooting at our aircraft. So then to counteract those, put civilians at risk, and it helped us develop better precision so we could try to comply. But that's always a concern. So I think there's a concern with deterrence, because deterrence really exists. This is, again, Colonel Richard speaking in my personal opinion, but it exists in the mind of the adversary. You need to know what you're deterring, who you're deterring, and specifically what you want to deter them from doing. And the more, I think the concern is that the more you lay out your rule set, the more they're going to adjust to kind of undermine what you need to do for deterrence. So I think that's the ultimate tension. But there's also that angst within society to try to get the clarification. And I think the ICJ nuclear weapons decision pushed the United States to come out with a lot of clarification on that. And I think that's where you see it when we come out and we actually say, hey, these are the rules that are going to apply, or at least the rules in general that are going to apply to these things. I think there are some nations that are even more vague than we are, and they probably don't have that same type of domestic population that they feel that they need to address and clarify the rules and what they're going to follow with. In other words, they don't have the same concerns that we do, being a democratic state, in trying to necessarily make sure that people understand that what they're doing is legitimate, because they don't need that democratic support to the same extent we do. That's my thought on it anyway.
Okay, great. Dr. Grego, let me put it over to you. So, and in the context of our discussion of kind of emerging technologies, is it possible that some of these emerging technologies might actually preclude the need for the use of nuclear weapons, that could substitute for some of the purposes for which we see doctrine surrounding potential nuclear use?
Yeah, thank you. I mean, there's certainly advances in overhead persistent imagery to facilitate tracking. There's much more precision guidance for conventional missiles. We already, I think, are at the point or close to the point where silo-based missile silos would be vulnerable to conventional strikes if you have the correct precision, which I think we're about at that point. So you can start to imagine missions that are traditionally held for nuclear weapons could be supplanted by conventional weapons. And that's just an example. So I actually think it would be very interesting to hear from our colleagues, about the obligation to substitute conventional weapons when possible, and to the degree that that is starting to penetrate the decision making.
Great. Well, I'll shoot that one over to Mr. Mabe then. I think that tailor-made for you right there.
Yeah, thanks, Jeff. So I want to bring up here the principle of precaution that that Professor Weiner was speaking about earlier, that all feasible precautions must be taken to avoid, or in any event to minimize, incidental loss of civilian life, injury to civilians, damage to civilian objects, etc. And so when a party to an armed conflict has the option to use less destructive means, it should do so. If that means moving from nuclear weapons to conventional weapons, I think that's exactly what that principle would dictate. I also just want to come in here as well and to you mentioned in sort of the framing of your question, would these new and emerging technologies preclude the need to use nuclear weapons? And I want to focus there on need or necessity, to say that necessity is not a justification to violate the rules of war. So we can talk about the need to achieve a military objective, but it still has to comply with all of the rules of war. I mean, this is a principle that was affirmed by the Nuremberg Tribunal that Commander Hart mentioned before. Yeah, I know that we're very short on time. There's more that I could say, but I'll leave it there. Thanks.
Okay, great. Thank you. And then our kind of last substantive question before I'm going to go around for closing remarks for Commander Hart. So there may be such a thing as a taboo on the use of nuclear weapons, given that they have never been used since World War II. And my question is, does that drive, in your opinion, decision makers, particularly national level decision makers, into maybe more of an adherence to the law of war when deciding to use a weapon given that taboo? And then as kind of a follow-on, given some of the changes of doctrine that we've discussed, particularly in the first panel, do you think maybe that taboo is starting to fade, even though we haven't seen a subsequent use?
Thanks for the question. So with respect to the taboo, I know Dr. Nina Tannenwald wrote a great book and has spoken a lot about this. And there's been some debate about the existence of a taboo. I think she originally argued that this was a moral taboo, more so than a legal one. And more recently, some have argued it's becoming a legal taboo to some extent. But in one way, I don't think the taboo is necessary for leaders to follow the law of war. Technically, they're supposed to, but perhaps the existence of a stigma associated with being the first ones to launch nuclear weapons since Hiroshima and Nagasaki, that forces them to pause more, to think harder about it. That seems to be reasonable to suspect that there would be a taboo there. But I think even Dr. Tannenwald has said there's a difference between a first strike and a second strike, and the taboo, if it's effective, is probably effective for a first strike. But in the event you are a country that is under imminent attack with nuclear weapons, it's either ongoing or about to start, I don't think the taboo will have much effect at all, because those things that give a taboo force, a concern about what society will think of you, and perhaps a worry about being prosecuted for committing a crime, those things are useful to stop a first strike. But if you're about to get hit by a nuclear attack, that legal system's not going to be there in that scenario. The world is being reshaped in this scenario, and there won't be a legal system there either way. The people whose opinions you care about, they're not going to be there, unless perhaps with this second strike you're launching, you just might be able to keep them around. And so I think for a second strike, that taboo, I don't think will have much effect, because the reality is the world's already shifted. And now it's just a matter of trying to keep your part of the world a little bit less dark than the other side. And I doubt that a concern about a moral taboo will be as effective if the people that you care about are about to be killed.
Okay, great. Do I have a few minutes left, Charlie? Just for closing remarks?
Yes, of course,
Oh,
just a
great.
couple minutes.
All right. So what I'm going to ask is to just go around to each of the panelists and kind of ask that fundamental question. Do you think that international law will play a significant role in any future decision to use a nuclear weapon? And is there anything that we could do to help promote that that inclusion of proper legal analysis as part of that decision? So I'll start with you, Dr. Griggo.
Thanks. Well, I'm a believer in socializing important commitments and establishing strong processes to reinforce our values and to make executing those values more ingrained and hopefully more robust to pressures that will come to abandon them. So I'm happy to hear how committed the Pentagon is to this type of work and hiring so many lawyers. But I do think for the law to have meaning, it does need to account for the full impact of nuclear weapons use, as I've mentioned in my remarks here, not bounded by military impacts and not bounded by time. And so, and I don't think we're currently prioritizing civilian harm in these analyses in a meaningful way, from what I know. I'm not a lawyer, but I'm persuaded by what I know that if the full scope of effects were included, then nuclear weapons should rarely survive a legal analysis. So while I'm glad that the civilian protections have been operationalized to this degree, I wish for more. And I'm concerned about the current trends. The recently confirmed Secretary of Defense has expressed fairly strong antipathy about the law of armed conflict and an alarmingly cavalier attitude about nuclear use. And the current administration is indicating it wants to close the Civilian Protection Center of Excellence housed in the Army. So those trends are not going in the right direction. So I think it's tricky times.
All right, thank you for your comments. Commander Hart.
So I think international law has a presence in the mind of decision makers. I think the answers that international law gives us change with changing facts. And I think how much someone cares about international law is also variable. But even in the worst case scenario of somebody, a decision maker might not care about international law. I think some of the panelists from earlier made it clear that international law is shaping their decision space. It's international law showing up when countries are deciding what sorts of weapons to build, what sorts of target packages to create, and there's legal reviews as well once those targets are actually ordered to be prosecuted. So there's a lot of law that is around the decision makers, regardless of how the decision makers feel about the law. So I think that's a good thing, and I think those influences will continue. And I look forward to hearing from the subsequent panels what they think on their issues. I've enjoyed this one very much, and I'm grateful for the opportunity to participate.
Thank you, Commander. Mr. Mabe.
Yeah, thank you. So I think that parties comply with the law for several reasons. I mean, first, sort of tautologically, they comply because it's a legal obligation sometimes. They might comply because of domestic pressure. They might comply because of their ethics or their morals align with the law. Or they might comply because of sort of out of a self-interest in international legitimacy. And so when a party has a lack of an interest in maintaining its legitimacy, law might play less of a role in its decision making, whether that's because of the power of its military, its economic strength, its allies, its place in international relations, etc. And so whatever can be done to lead parties more towards an attitude where they are in a position where they should care about respecting the law, I think that is positive. I think that one way that can be done is joining the Treaty on the Prohibition of Nuclear Weapons, for example, because it assures all other states that we are rescinding and will never adopt the power to destroy the world. And I agree with Commander Hart that if someone is making the type of nuclear decision that they think is world-ending, probably law is not at the front of mind, frankly. But if we're in the type of situation where we're looking at an isolated incident where the structures that we have in place will continue to exist, that decision maker will have a lot of explaining to do in front of the rest of the world. Thanks.
Great, thank you. And for the final word, over to you, Colonel Richard.
Thank you. So my position, and I think it reflects a lot of what our panelists have gotten at, is I think international law can have a restraining effect. I think it will kind of apply, and by that I mean, as I started out with Clausewitz, I think once you get past the initial use, I think concerns over law degrade, and I think all the panelists have gotten at that. I will also say that I think the U.S. position, the declared NATO position, and the position of several other states is that nuclear weapons have to be legal, because it's the way to maintain deterrence, at least from our perspective. If nuclear weapons are illegal to have, if they're illegal to use, and then you have countries that don't want to admit their illegality that then possess them, it's going to be a problem, because then you don't have legitimacy backing up your deterrence posture. So I think you have to be careful as we look at that. I think that's the big conundrum that we will have. I will also say that international law conveys ultimately legitimacy, and it's going to be very important for populations and foreign relations. And then international law also is, it establishes frameworks not just for decision making, but also for international decision making, and it's the way to be able to get regional agreements to de-escalate certain conflicts. And I think if you look at the history of the Cuban Missile Crisis during the Cold War and the Organization of American States, to kind of help pressure and legitimize U.S. actions to get the Soviets and Cuba to get rid of the nuclear weapons, I think it was very useful. But the U.S. was also very concerned about foreign relations, and I think as the U.S. has contemplated it in the past, that's always been a concern, is what will the Allies think if we ever were to use these. I also think in the current crisis with Ukraine, one of the main things that holds Russia back from actually using nuclear weapons is, at least what we've seen in the open media, is China has basically told Russia not to use them. And so it's important because it's that framework, and whether you call that law or realpolitik, at some point the two can merge, and I think that's kind of what happens. So it is helpful, but there are limits to how law is actually going to realistically restrain conduct depending on where a conflict goes.
Great. Thank you, Colonel Richard, and thank you to all our panelists for taking your time to join us here and prepare your remarks. Very much appreciate it, very much enjoyed it. And I'll turn it back over to you, Professor Moxley.
Thank you. Thank you, panel. Thank you, Jeff. We now have a 10-minute break. Let me orient everybody to what happens next. We have focused so far today, first on the policy issues, the strategic issues, and an analysis of the current risks posed by nuclear weapons. Then we've had a focus on international law broadly and its importance. And we've talked about law of armed conflict and the law that actually applies to the use of force. So the focus has been on international law of armed conflict primarily. The next panel is intended to be kind of brainstorming, kind of next steps, beyond law of armed conflict. What other law is there? What is the potentiality of law beyond what we can glean from studying, looking at, examining law of armed conflict? So the next panel will be a broad brainstorming on other areas of potential law and potential approach towards these risks. Then we'll turn to what one might say is where the rubber hits the road. We'll talk about deterrence and the policy of deterrence, because we certainly hope, God willing, we're not going to have a use of these weapons, but we have the policy of deterrence. It is what it is, and we need to understand it, examine it, and look at it in terms of applicable law and the like. So Let's call it 3:15. It's almost 3:15. Let's come back at 3:25 and we'll have this brainstorming session on other approaches beyond LOAC/IHL. Welcome back, everybody. We're now at panel 4, which, as I mentioned, is going to look at alternative approaches and kind of brainstorm. I referred earlier when we were listening and talking with Colonel Lieb about how I felt as if I was addressing the Supreme Court, because he's one of the ultimate decision makers who's going to be there advising people on decisions about the kind of things we're talking about, hopefully never involving nuclear weapons, but he's there and we can talk. And obviously, I mean, we've seen from these earlier panels that there's a disagreement. I mean, as one of the speakers recently, as several people have mentioned, there's broad agreement on what the rules are of the law of armed conflict. But when you go to apply them, there are different views across the spectrum, from the status quo, while unfortunate, is the best we can do, to, as John Burroughs said, that the status quo is unlawful, that the use and threat of use of these weapons is unlawful. But thank God we have not had a use of these weapons since Hiroshima and Nagasaki. And so we haven't, we've had discussion and debate and books and articles, but we haven't had what we have in other areas of the world, of the law, right? We haven't had decision making. I mean, I practiced for over 40 years, largely in federal securities law and 10b-5 cases and things like that. And there are decisions coming out of the federal courts in the US. Every week, there's another major decision. And every couple of weeks or more, there's a major decision out of a federal court of appeals. So, how does the law develop? How can we develop the law in a meaningful way in nuclear weapons without, needing to have actual experience here, which led to one of our first ideas when we organized this panel, which was to invite Judge Shira Shinlin to speak. Judge Shinlin was a federal district judge here in New York for 22 years, the kind of judge that we practicing lawyers are most in dread of and have our cases before, because they decide everything. And of course, criminal cases as well, and they have the horrible responsibility of sentencing and the like. Judge Shinlin has also been a federal prosecutor. She was in the Eastern District of New York. She was the chief administrative U.S. attorney and deputy chief of the Economic Crimes Unit, and so brings this broad perspective. And when I called Judge Shinlin and said, could you do it? Judge Shinlin said, well, I'm not an expert in international law or nuclear stuff. And I said, that's why I called you. We're looking for something new and some new ideas. And, and I know no one better who could help us in this way. Since Judge Shinlin retired, when was 2016, Judge Shinlin has been an arbitrator, and I've had the pleasure of serving with the judge in a number of cases, and see the creativity and the dedication to legal analysis. So, Judge, take it away.
Well, thank you, Charlie. Thanks for that introduction. What I want to explain to my co-panelists and to the large audience we have is that, as Charlie warned you, I am not an expert. I am what's called a generalist judge. And a generalist judge has very general, broad ideas, and that's the best I can do. So if you feel that my presentation is a little bit dumbed down, just stick with it for a few minutes, because I think it's a broad overview, as Charlie said. It's also a chance for you to relax your brain, because I've been listening to the conference and we've had some real experts teaching us about the issues that are so important. So I am delighted to be here today as a part of this discussion. And of course, I agree with Professor Moxley and so many of the speakers that this area of international law concerning the use of nuclear weapons demands serious attention and clarification. I'm a little afraid to use the word clarification because our last speaker on the previous panel said it's deterrence versus clarity. I thought that was very interesting because as a lawyer and a judge, we think about clarity over everything. So, you know, I want to talk about the rule of law because every day if we read the newspaper, we keep hearing that this is a country of laws. We have to be bound by the rule of law. We don't have dictators, although maybe we have some would-be ones, but we don't have dictators. We have the rule of law. So I want to really start with 101. That's the lowest level of class and say, how is law developed? Law is developed by statutes passed by legislators, but it's also developed by judges who write judicial opinions. And Charlie just referred to that, talking about securities law. So every week, judges make the law. They also explain the law that is passed by statutes, but they also make the law. And how do they do it? They do it from experience with common and repeating problems. So again, I'm being very basic for a minute. Let's start with some simple examples. Contract law. Since the beginning of time, parties enter into contracts or agreements, and then parties breach those agreements. And so the law says, how do we cure the breach? What are the remedies for breaching a contract? And then we have tort law. And since the beginning of time, a neighbor's well overflows and injures the neighbor's house, or a neighbor's horse and cart run over a neighbor's child, causing injury. Again, we say, what is the remedy that can be claimed by the party injured in her property or her person? Now, criminal law, as Professor Moxley said, federal district judge, which I was for a long, long time, we do civil and criminal law. So a man assaults his neighbor's wife. A man steals from his neighbor. A man murders another man because he perceives him to be an enemy. A man murders a man because the man is about to attack him. That's self-defense. So what does society do with these different scenarios? How does it impose punishment? And again, the legislature will pass laws telling us the punishment, and judges have to mete out sentences. So we saw yesterday, a judge in the Southern District had a sentence, a former senator, a big decision. How many years was the appropriate punishment for what that former senator did? So nations develop their own laws, and these laws differ from country to country depending on the standards and culture in each society. So the laws in Iran are going to be different than the laws in China and differ from the laws in the United States or the United Kingdom. There's no standard or common law. We don't have a common law across nations. We're all culture bound. We're all different. But over the last several centuries, there have been efforts to create laws that bind every nation and all peoples, and the recognitions of such laws have emerged. And you've heard about it all day. It's international law, international humanitarian law, the laws of armed conflict, but it's not an easy area for the rule of law. Why do I say that? First of all, does every country truly agree to these international laws, even though such laws are recognized as customary international law binding all the states? But will they be recognized? Two, how will they be enforced? And who will be the enforcer? Three, does every country trust the other countries to apply these international standards equally and fairly? Those are the questions. And finally, who writes these laws and who agrees to be bound by them? For countries that believe in the rule of law, it is important that notice be given to all those who are bound by law. That's a basic principle of our law. You must have fair notice. The notice must be clear. It must be unambiguous. People need to know what is permitted, what is not permitted, what conduct violates the law. So clarity and notice are the hallmarks of the rule of law. And I would add another term besides clarity and notice, and that's specificity. The law should be as specific as possible as to what is or is not appropriate, which brings us to the question of whether there is any clarity and notice when it comes to the use of nuclear weapons. The first problem is, and we probably talked about this today, is we have no experience from which to discern patterns regarding the use of nuclear weapons and the consequences of using them. When we think about other laws, humanitarian law or the laws of armed conflict, There are unfortunately many wars and many patent violations or breaches of humanitarian behavior, such as mass starvation, mass transfer of populations, mass rape, mass extermination, from which one can evaluate what is acceptable conduct and what is not acceptable. Concepts of self-defense, first strike, distinguishing civilians from combatants, military justice, all these have developed through the study of human conduct over at least the last several centuries. But we do not have, and hopefully will never have, that type of laboratory experience with the use of nuclear weapons. We have only theory. These weapons, as we've gone over and over today, have only been used once in Japan, 1945. What we learned then is that these devices cause tremendous destruction geographically and in human suffering. Some say that the use of such weapons also showed that they have to be considered the last resort to end a conflict that otherwise would continue indefinitely and cause more loss of life, maybe, than the use of this weapon. But my point is only that any international law on the use of nuclear weapons must develop through thoughtful study of really essentially a theoretical problem. Well, where do things stand now? And I think you've heard this, so I'm going to rush through this. The International Court of Justice of the United Nations ruled in an advisory opinion in 1996 that the law of armed conflict does apply to the use of nuclear weapons and that the use of such weapons is generally considered unlawful. But this advisory opinion does not have what we call the force of law. We also have the Nuclear Non-Proliferation Treaty, 1969, took effect in 1960, but several nuclear countries aren't signatories. Israel, India, Pakistan aren't part of it. North Korea withdrew. And this treaty, anyway, didn't address the use of nuclear weapons, but rather looks to disarmament and the peaceful use of nuclear power. In the US, our Department of Defense has written a hugely long 1,000-page law of war manual, which is too vast to summarize, but it concludes that the use of nuclear weapons is subject to the same law of armed conflict as conventional weapons. Open questions. Are there, as the US argues, times when the use of nuclear weapons might be lawful? And as you can see now, I'm raising more questions than giving you answers. Might nuclear stockpiles fall into the hands of dangerous non-state actors if not very carefully secured or disposed of? Are there lower yield nuclear weapons that may be used without causing the mass destruction of higher yield nuclear weapons? Would such limited, so-called limited use be lawful? Is it fair to say that nuclear weapons can never be used in or within range of urban areas, but may be used, maybe as a last resort, in remote areas, far from densely populated areas? Or would even such use be unlawful? And does the risk of precipitating nuclear war and escalation preclude any use? What would be the guiding principles of drafting a multinational convention governing the use of nuclear weapons to which the nuclear weapon state might agree? We've heard about proportionality as the first principle in the law of armed conflict. And perhaps the use of nuclear weapons is never a proportional response, except in response to someone else's use of nuclear weapons, but that guarantees mutually assured destruction, which can't ever be lawful. Indeed, could any such use be lawful given the potential effect on civilians? Another approach is a risk analysis. How does a state actor balance the risk of using such a weapon, that is the consequences, against the risk of not doing so? Namely, the other side may use it or the loss of life without the use is too great. Perhaps the best principle is that the most important consideration for the use of a weapon should always be to judge the effects of using that weapon. Call it an effects test. And taking that as a guidance, could any use of nuclear weapons ever pass an effects test? So why is it so difficult to draft a multinational convention on the use of nuclear weapons, a convention to which the US and other nuclear states could adopt? To my mind, there are several problems. I'm just going to list them. First is independence. Many countries, the US in particular, have a general aversion to international treaties that limits its discretion and its independence to act whenever and wherever it deems necessary. Certainly the US has made a point of not joining international treaties if it feels it limits their right to act as it sees fit. Secondly, enforceability. Who will enforce the provisions of such a treaty? And will the other countries really subject themselves to the jurisdiction of the enforcing entity? Third, lack of trust. Namely, certainly non-state actors are outside the community of nations, and even state actors vary in their commitment to adhering to the treaties they sign. And yet we have seen signed international treaties governing the use of chemical and biological weapons. So why not nuclear weapons? As Charlie has written in his book, with 5 billion deaths potentially at stake in a nuclear strike, can such difficulties that I've listed be overcome? In a sense of human survival, overcome these obstacles. So it's really time for a proposal. At least I would hope that there might be an agreement on the safeguarding of nuclear weapons. If nothing else, safeguard them. There has to be a security concern for all nuclear states. Loose nukes falling into the wrong hands, namely non-state actors, may be the biggest threat of all. So we have a unique situation here. We need to convene, in my opinion, more conferences and gatherings like this one. We need to hear from experts in the field across the political and legal spectrum, from the military sector and from civil society, from academia, from NGOs, from industry, technology, and certainly artificial intelligence. The more, the better. In this way, we may be able to reach a consensus as to how to apply the laws of armed conflict to the use of nuclear weapons, when, if ever, they can be used, how they should be safeguarded, and how to deter their spread. So to paraphrase a great American, I have a dream. I have a dream that someday leaders from around the world will convene to develop and adopt laws governing the use of nuclear weapons. If that is too much to hope for, I can at least hope that there could be an agreement on the safeguarding of nuclear weapons in armed conflict. This should be a security concern for all nuclear states. We've talked about that. An international convening of experts on the use of weapons, these weapons, is a worthy goal. And with that, I'm anxious to hear the thoughts of my fellow panelists. Thank you, Charlie.
Thank you, Judge. Thank you so much. You know, when I was writing the book, I had a bunch of students working with me, and I had the idea, let's figure out at least what the restraints are, as Judge Shinlin mentions. What are the restraints on a state to exercise reasonable security of its nuclear weapons? You know, is there a law comparable to the law we know exists domestically that one can't keep a lion or a boa constrictor in one's yard and is responsible if it's released? And to my extraordinary discovery, and we looked and looked and looked, and if anybody has an answer beyond what we found, it seems that there's just no clear rule on that. The Obama Loose Nukes Project, what was that? Was that the Nunn-Lugar project, came out with a recommendation that we need that. But that is low-hanging fruit, which we haven't even established, where there is absolute joint interest of all nuclear and non-nuclear weapon states to have a security, particularly in the age of cyber and AI insecurity. But let's move on. Thank you, Judge. David Gibson is working a particularly important part of this project. The first year we had this program, we learned about a big group, the Catholic Peacebuilding group that exists across maybe, 20 different universities, and has fostered peace studies and efforts to address WMD concerns and the like. John Feerick jumped in. We were having a discussion with then Father Christensen from Georgetown, who was one of the leaders of that. And John Feerick jumps in, and we had a discussion, why don't we get Fordham involved in this? And John, being who he is and the activist that he is, the next week he met with the then president of Fordham, and Fordham decided to join it and brought in David Gibson, was assigned this project. And David, take it away.
Well, thanks so much, Charlie. I appreciate the invitation to speak here. I'm something of the outlier. I appreciate Judge Shinlin's modesty in saying she's not an expert. I'm going to lower the bar way further. I'm a career journalist of all things. coming here to Fordham a few years ago is honest work for the first time, as I say. And I have none of the expertise that any of you all have, but I do, again, I focus on kind of real world experience and engagement, and especially trying to get young people and channel their passion and their activism into some of these issues that you've all been discussing, and to generally make a difference. So I just want to take a few minutes just to make two main points. Again, I'm director of the Center on Religion and Culture here at Fordham University. We put on a variety of public programs with speakers and cultural figures. And the 2 points I want to make are about religion and culture. The importance of religious faith-based partners in the movement to eliminate the nuclear threat, and 2, the importance of cultural engagement. Again, culture is where people, especially young people, connect with so many issues. First, the religious actors in this movement. I'm going to quote my friend and colleague, Jerry Powers, longtime director of the Catholic Peacebuilding Network, as Charlie referenced. The Catholic Peacebuilding Network links 20 bishops' conferences, hierarchies in 21 different countries around the world, various Catholic development agencies, universities like ours, independent peace organizations, really in an effort to enhance the study and practice of conflict prevention, management, and post-conflict reconciliation in war-torn areas. I often think, as we've seen popes and various people try to avert conflicts, that the Catholic Church and other groups are better at post-conflict cleanup and reconciliation than they are preventing anything, alas. But Jerry has said, quote, "The nuclear debate must not be a norm-free zone, and it must not be a religion-free zone. Norms and religion must not be uninvited guests at an exclusive nuclear party dominated by realists. On nuclear weapons, morality and law rhyme. Moral and legal criteria for judging nuclear weapons are similar: discrimination, proportionality, necessity, concern for the environment. Catholic social teaching and social teaching of religious traditions across the board has long insisted on the need to strengthen international law and international institutions in order to move toward a world free of nuclear weapons. Catholic Church in particular has been a strong supporter of arms control, disarmament. I'd note that in November 2017, at a major Vatican conference with 11 Nobel laureates present, Pope Francis made a prudential moral judgment. He said that not only the use, but even the possession of nuclear weapons was morally problematic. I note that Pope Francis is the first Jesuit. We're a Jesuit university. Those of you may be familiar with the Jesuit order. He's the first Jesuit ever to be elected Pope in the 500 years of the Society of Jesus. Many would say he'll be the last, given some of the opposition that he's generated, especially here in the United States. But it is interesting, he was a great follower of another great Jesuit, Father Pedro Arrupe, who was a longtime Father General of the Society in the 60s and 70s, really moving the Society towards this active engagement in social justice and peace issues. And it's important to remember that Father Arrupe is the seminal issue in Father Arrupe's formation was the fact that he was living and working in Hiroshima when the atomic bomb went off. And again, everybody's noted that that was the only instance of the use of nuclear weapons, and that has had that legacy down to this day in terms of certainly the Catholic Church and other groups in their commitment to this issue. I'd also note that just recently, 2 years ago, Archbishop John Wester of Santa Fe put out a 51-page pastoral letter looking at how nuclear weapons have impacted his archdiocese and New Mexico as a whole, including the work of Los Alamos and the Sandia National Laboratories, downwinders from nuclear tests, those impacted by uranium mining, and the environmental consequences of nuclear waste storage. There's also, again, the Catholic Peacebuilding network is also puts on many programs. I've just a pitch for one that's coming up February 11th. The Berkeley Center, Notre Dame, ourselves are co-sponsoring an event, New Cold War, New Anti-Nuclear Activism. And one of the panelists there will be Professor Miyazaki from Northwestern University, who's been key, and again, in working with us in some of these things, especially the project of mapping nuclear legacies, committed to documenting on the ground stuff, documenting and critically engaging with local efforts to address nuclear weapons issues across the United States. So these things are really critical, I think, these moral and faith-based actors in my experience, and in channeling the anxiety that so many young people have into activism, which is where the rubber hits the road. And just one last point on the cultural aspect. Again, this is where people, young people especially, manifest their anxiety about what's going on, whether it's climate change, and of late, increasingly concern, which I grew up with, of nuclear annihilation. For better or for worse, culture, from social media to cinema, is where the young people live. And it's up to us to channel those fears into action. Just a recent New Yorker article asked, are we living in dystopia? And it was an article that looked at the cultural landscape of all these Netflix series and other series such as Silo, a string of post-apocalyptic dramas that have a real resonance for so many young people, so many viewers today. We recently had Dorothy Fortenberry, a Catholic screenwriter out in Hollywood, wrote The Handmaid's Tale, another dystopian series. She wrote the Extrapolation series for Apple TV on various climate change and post-nuclear scenarios for our world. We had somebody from, you might remember a couple of years ago, the Don't Look Up movie about a meteor slamming into the earth. The Last of Us is a series. Station 11. The end, I was really struck by the end of that New Yorker essay, noted that after the wildfires erupted just a couple weeks ago in LA, many people turned to Octavia Butler's 1993 novel, Parable of the Sower, which is set in the 2020s now, and describes this kind of dystopian post-apocalyptic California, blocks of boarded up buildings burning in Los Angeles. Turns out Octavia Butler, who died 20 years ago, actually owned a house in Altadena, one of the neighborhoods that was entirely destroyed by these recent wildfires. Her own grave is in a cemetery that was burnt over by these wildfires, and it's marked by a footstone that quotes has a quote from Butler's book that says, "All that you touch, you change. All that you change changes you." And I think that's really the challenge that we have, is to take this into the real world and touch these people who are looking for answers, who have all this deep anxiety, looking for answers, and giving them hope and someplace to go.
Thank you, David. I think this effort to involve young people is so important and really so challenging, because nuclear weapons have been internalized now. I mean, I've taught the course at Fordham Law School for years on nuclear weapons law, and smart students come along and take the course and are interested, but they don't have the sense of the issue that those of us of the Cold War generation had. So it's very challenging. And of course, the faith groups. I mean, Jonathan Granoff has been very involved in this, and across, as you say, the different faith groups, and we've had a number of programs and speakers from that. So it's very, very important. Thank you. Professor Richard Painter is a law professor at Minnesota Law School, and during from 2005 to 2007, he was the associate counsel to the president in the White House counsel's office. And I've never met you before, but I saw you on TV. You were on CNN a lot talking about these issues of, not in the nuclear context, but ethical concerns as has to do with public officials and the like. So we're so delighted that you could join us. One area that we've talked about in organizing these conferences, obviously, we have the government, our government, the Defense Department and state, and the whole executive has policies on nuclear weapons, and the military is responsible for these weapons and deployment and potential employment, unfortunately. So we have all of that, but what else do we have? We have private industry, right? Private industry manufactures these, and so the thought is that perhaps you could give us some perspective, Professor Painter, on your area of corporate responsibility, ethics, fiduciary duty. What responsibilities do companies have, or do any of us have, if we want to go to work for a big corporation that's manufacturing component parts for these weapon systems, or we're asked to go on the board of one of them, or something along these lines?
First of all, I should emphasize that David Gibson is absolutely right, that we need to bring to bear on this discussion values, moral values beyond that which the law specifically requires, including the values of persons of faith. And we need to engage the faith community in this discussion. It's vitally important. For too long, the discussion of nuclear deterrence and nuclear weapons has been dominated by rational actor theories, game theory, models of tit for tat and the like, when it turns out that in wartime, a lot of people, decision makers, will be very, very irrational. And that is the great danger to our existence on this planet if we don't do something about the proliferation of nuclear weapons and nuclear weapons falling into the wrong hands. I should also emphasize that the law is not going to do very much about this problem when the most powerful nuclear power in the United States is the United States, and our Supreme Court has held that the President of the United States in his official capacity is absolutely immune from criminal prosecution. And what message does that send to the rest of the world about our potential use of nuclear weapons or commission of other war crimes? My focus in the Bush White House, however, was not on war crimes and the clear abuse of prisoners in Guantanamo Bay and those issues. I made my views known on those issues, and I was told they were being handled over at the Defense Department and the Department of Justice. Those matters I have since expressed my serious disappointment with the way the Bush administration covered up clear violations of international law with respect to the interrogation of detainees. But my focus in the White House was on financial conflicts of interest of business executives coming into government. And this concern feeds directly into the problem identified by President Dwight Eisenhower in 1961 in his farewell address, where he spoke about the military-industrial complex, of the collaboration of persons inside the government, inside the Pentagon, and elsewhere in the government, and the large defense manufacturers to build ever more weapons, more and more, to get the United States into an arms race with the Soviets, and to divert money to that purpose that could be used otherwise to strengthen the American economy, to assure that our system, our capitalist system, our democracy worked for everyone at home. And President Eisenhower was very concerned also about the grave threat of nuclear war. Since his speech in 1961, the Defense Department budget has only grown. The defense contracting is a substantial part of that budget, close to 50%. We have a defense budget that will soon surpass $1 trillion. In the White House, I dealt with financial conflicts of interest of people going into the Defense Department, including from the arms industry. from companies like Lockheed and Boeing, and people who leave the Defense Department to go into the military manufacturing sector. And those conflicts of interest, if not monitored very carefully, will dramatically increase our defense budget and our spending on weaponry, conventional weaponry, as well as potentially nuclear weaponry. And we all know that conventional weaponry, when used in war, could easily lead to the use of nuclear weapons. So controlling defense spending, not only in the United States, but around the world, and arms control is absolutely critical. And yet the interests of the defense industry are quite to the contrary. To give you one example, we have coming into the new administration, the Deputy Secretary of Defense, Stephen Feinberg, who is invested heavily through Cerberus Capital Management, a private equity fund, in the defense industry. I have made it clear that the United States Senate needs to insist that he divest entirely from any interest in the defense industry before he starts work. That standard has been observed in administrations, Democratic and Republican, up to this point. But all we may be seeing now is a relaxation of the ethics rules. And in the Defense Department, if we're going to have high-ranking officials who are invested in the defense industry making decisions that could very well increase military spending yet further, we're not only going to be wasting taxpayer dollars, the exact opposite of the efficiency program being promoted by Elon Musk and the Department of Governmental Efficiency, but we also are going to be contributing significantly to warfare around the world, and eventually, I think, increasing the risk of nuclear war. So government ethics, the area I dealt with in the Bush White House, ties right on into what we're concerned about here with nuclear weapons and warfare. The other side of the equation is what happens inside the companies that are contracting with the United States government to build these weapons. What should their priorities be? The officers and directors of Lockheed and Boeing and Raytheon and the other corporations that make billions of dollars off defense contracts. Should they focus only on profits or on the national security of the United States, their client, and the ultimate objective of achieving world peace, which may very well mean the long-term objective of decreasing defense spending on unnecessary weaponry, persuading other countries to decrease defense spending so that we can spend our money on the priorities we have here at home. But what should the priorities be of the officers and directors of those companies? I have heard plenty of corporate law scholars in academia talk about the shareholder wealth maximization norm and the idea that directors and officers have an obligation only to increase profits for the benefit of shareholders. Now, never mind that many of these people have never actually been in the business sector, and that the Business Roundtable and other leading organizations of business executives have rejected that ideology. But unfortunately, it may be true that too many companies, too many executives, directors of companies across the economy are focusing exclusively on profits, or too much on profits at the expense of the public interest. I have publicly in a book chapter I wrote, and also in a number of speeches and in other contexts, called upon the United States government to insist that defense contractors, as a condition of their entering into a contract with the United States government, agree that the fiduciary duties of the directors and officers of the company that is contracting with the government, that those fiduciary duties run to the customer, the United States of America, and to our national security, and to our long-term objectives, hopefully long-term objectives to bring peace to the world and security, and to de-escalate the arms race. But the companies that are making money off these these contracts with the government have no right to simply focus on profits and say that is the fiduciary duty to their shareholders, and that they will do everything they can within the limits of the law to make the most amount of money at the expense of the American taxpayer, and ultimately feeding the arms race that President Eisenhower was concerned about. Now, we can't work all this into a defense contract, but we can simply say to every defense contractor, we do insist that it's in your charter, your corporate charter, that the fiduciary duties of the executives and of the board of directors run not only to the shareholders, but to your largest customer, the United States of America. At least let's insist upon that, and then figure out what we can do to work with the defense industry to make sure that the United States military has the equipment we need to defend our country, to defend our allies, but that we also can pursue the long-term objectives that we have to pursue in order to avoid nuclear annihilation. And those objectives clearly must include the de-escalation of the arms race, elimination of nuclear weapons, scaling back on defense spending across the globe, and also arms sales to foreign countries that are engaged in warfare. We need to scale back in many, many instances. And the defense industry, unfortunately, profits from just the opposite. And the lobbying power of the defense industry in Washington is immense. I saw this after 9/11 in the Bush White House. The defense companies circling like vultures over Washington, D.C., seeking large contracts. Some of those contracts making sense and some not. Throwing lavish parties for government officials and for members of Congress, simply in order to enlarge their profits. And I don't think the United States should be doing business with companies where the officers and directors believe their only fiduciary obligation is to profit maximization and their shareholders rather than to their country. And with that, I will leave this open for discussion of where we can go from here. But once again, I want to emphasize that the rule of law in the United States is in a very, very perilous state right now. When we've sent the message to the world that there's lack of accountability under our criminal law, we are not part of the International Criminal Court. We will not enforce the criminal law, at least against the President of the United States for his official acts. And this is leaving the world very, very nervous.
Thank you, Professor Painter, for your sobering reminders of these things. Much to think about. Our next perspective is perhaps slightly, at least potentially, more hopeful. As Judge Shindlin and I have discussed, and we didn't get to in this conference, talking about justiciability, getting a court to hear these issues, even aside from the issues that Professor Painter mentions of the recent Supreme Court decision on presidential immunity and the absence of the ethics provisions leading to the revolving door substantially raising our costs. Aside from all of that, even if the challenges that some of us see as very valid to the lawfulness of our nuclear weapons policies and war plans are valid, it's very hard to get justiciability in our federal courts or other courts because we have the doctrine of political question where courts don't want to hear issues that are more appropriately within the decision-making realm of other branches of the government, and where the court decision would be hard to enforce, if not impossible anyhow. And there are sovereign immunity issues, there are standing issues. It's very hard for somebody to bring a case challenging a government policy. So justiciability, what we call it in the legal circles, is very, very hard, but not impossible. I mean, we'll have another program on this perhaps, but very hard in the federal courts or other courts in our country. But our courts and courts internationally and in the EU, as we're about to hear, are potentially appreciably more open to claims based on human rights and human rights regulations and statutes. So Professor Daniel Riddicker, who is a lecturer at Lausanne University and an adjunct professor at Suffolk University Law School. The University of Lausanne is in Switzerland, and is also, by the way, a senior lawyer at the European Court of Human Rights in Strasbourg. So is a real expert on human rights law and has lectured and spoken on it in programs at Harvard as well. Daniel, give us something hopeful here that, that there's a potential for pressing concerns that we have about the lawfulness of the nuclear weapons policy of the U.S. and other countries. How can we challenge them? And is there a potential in human rights area? And of course, environmental is another area too.
Thank you, dear Charlie. Thank you also to the New York State Bar Association for having me tonight. Here in France, it's already night. I am trying to reply to these very complex questions you just asked me by giving you another layer, another dimension to the discussion, human rights. I have been working and researching moreover on issues of human rights quite a bit in my career. My background is more international law and human rights law, but then for a couple of years I'm trying to focus on to analyze to what extent human rights can serve for our concerns for human rights for nuclear arms issues. Now I'm trying to share my screen. Does this work? Not yet, maybe.
Maybe Kara, right? You need to make Daniel a co-host. Yep.
Yeah, it is okay. Can you see that already?
Yes, we can, Daniel.
Ah, perfect. Okay. Okay. So I'm trying to get. Okay. Okay, I don't want to take the time. I try to be structured, but I will jump right on the different points of my talk. It's not a talk with big results. It's more to ask questions for the discussion. So I think what is really important from my point of view, if you want to talk and think out of the box, is that there is another approach. We always talk about state security, security of nation, but for a couple of years already, there is a new approach, a human or victim-centered approach to nuclear weapons. A couple of states, Austria, Kazakhstan, and others, bringing this up, trying to make sure that we're not only talking about the state security, but about human beings, victims. One of the triggering ideas is that really there's no adequate response possible to nuclear weapons, especially in a nuclear war, basically. And WHO, World Health Organization, already in 1987 made it clear that there's no way how we could adequately respond to nuclear weapons, especially if they trigger a chain of use. And this has been used and identified recently in what we call the humanitarian initiative or the humanitarian pledge. Which finally resulted in a new treaty, which I'm going to mention later, the TPNW. I think it has been mentioned today already. Human-centered approach or human rights language is already present in the 1996 advisory opinion, in particular in the dissenting opinion of Judge Vera Mantri, who uses really humanitarian human rights language. So it's basically nothing very new, but it took just another a bigger dimension in the last couple of years. And here, I would say the most tangible expression of this human or victim-centered approach, the TPNW, this treaty, which has, by the way, now ratified by 73 states, which forbids the use and production and testing of nuclear weapons. So there is an instrument which could be used by nuclear weapon states to jump on board and to make this world without nuclear weapons. And here, what is really interesting, the human rights language in the preamble to this treaty. We talk about this proportional impact of nuclear weapons on women and girls, including of result of I think radiation. So it's really a new dimension in arms control law, this human-centered approach. And we also talk about the Hibakusha, we talk about indigenous peoples in the same treaty, and of the state's duty to comply with international humanitarian law and human rights law under all circumstances. I think this is quite important in times of peace, in times of war. So this as a background, I wrote a book and articles on these issues. I don't want to go into the details of the boring details between the relationship of human rights law to other areas. But just I came out with a couple of advantages, pros of human rights law compared to other branches of international law. For instance, the application in all circumstances. I think this is quite important. In international humanitarian law, we always have to ask ourselves, are we talking about an armed conflict? Are we talking about the international or non-international armed conflict? So I think human rights law, it's easier, it's applicable under all circumstances, at least the core rights like the rights to life under the International Covenant of Civil and Political Rights is always applicable. Other advantages, I don't have to go into detail, I always come back afterwards. I think one of the important issues is that we concentrate on vulnerable people, indigenous peoples, women, children, girls, as much as the TPNW does also. That it is a good match between human rights law and this new approach to arms control. We also talk about particular nature of certain rights in human rights, use cogents, like imperative law, erga omnes. It applies to everybody, to all the states, even if they have not ratified a treaty, like the customary aspect. And in red, what makes the human rights law attractive also for this question is the institutional dimension. We have treaties and we have actual bodies who can hear cases, and I will give some examples. So the right to life may be the most important human right enshrined, among other things, in the International Covenant on Civil and Political Rights, which has been ratified by the US, by all the nuclear weapon states, by the way, apart from China, who has only signed it. They will talk about the inherent right to life and an arbitrary deprivation of life. So I think this makes really sense if we talk about mass destruction by nuclear weapon. So Article 6 enshrines this right to life, binding also on the US and all the other nuclear weapon states. Very interesting. This General Comment number 36 on the right to life by the UN Human Rights Committee. It's quite a recent document, 2018. It's kind of a compilation, a summary of the practice of the Human Rights Committee, which is implementing the International Covenant on Civil and Political Rights, and quite in tough language tells the states what is expected under this human rights treaty. So the threat or use of weapons of mass destruction, in particular nuclear weapons, which are indiscriminate in effect and are of a nature to cause destruction of human life on a catastrophic scale, is incompatible with respect for the right to life and may amount to a crime under international law. So this is really a statement made by the body implementing the Covenant on Civil and Political Rights, to which the US and all the other members, other nuclear weapon states apart from China, are are members. So it's quite remarkable. And then reply, they also recall the Article 6 NPT obligation and the duty to pay reparations to victims. So it goes quite far in the language. And this statement actually has been used by, especially by civil society, by our circles, civil society, but also by states. For instance, there's a joint statement by Kazakhstan on behalf of 38 states, 38 states to the Human Rights Council. This is another UN body who discusses on a periodic level human rights issues around the globe, around certain topics. And here also, based on this General Comment number 36, it basically it confirms that the right to life would be violated in the case of use of nuclear weapons. And again, the special attention paid to certain groups, women, children, girls, and pregnant women. So you can see that now in the human rights universe, we have this kind of arms control issues. I think there's a clear breach between the human rights world and the arms control world, which is being taken. Just a couple of thoughts to trigger discussion, maybe the different scenarios or the different situations you want to litigate or you want to address testing of nuclear weapons. It's probably quite an easy one compared with others. Probably has been done in the US courts. We have real victims. We have cancer victims. It's easier to have success in these cases. There is a case in Strasbourg, European Court of Human Rights decided against the UK of servicemen who had to be present in the Christmas Island nuclear tests, and his daughter got leukemia and complained about that and not being informed about all that, also in light of the rights to life. Another probably easy task would for a court, if it still exists after nuclear war or after nuclear explosion, would be for the court to say that the use of nuclear weapons is actually illegal, is a problem on the right to life. Here's just a case again of the ECHR, the European Court of Human Rights, against Russia. And here, of course, we're not talking about nuclear weapons, we're talking about a fragmentation bomb, a high explosive fragmentation bomb of 250 kilogram caliber used in the war against Chechnya in a town, basically. And here we clearly say, the court clearly say that Russia did not try to avoid or minimize the risk of loss of life. They used these weapons in a densely populated area, and it was quite easy for our court to find a violation of the rights to life. And again, if there would be a court to judge a nuclear weapons use, I think it would really come to the same, or even more so to the same conclusion. More difficult, I would say, in terms of how to tackle nuclear problems. Is the possession of nuclear weapons also already a human rights problem, or the threat of use? Is this already a human rights problem? I think it's a bit more complicated because normally in human rights terms, we need a direct affected person, a victim. A direct victim of human rights violation can address a court. And this is, of course, more complicated if you want to reach a human rights court and say, look, I'm violated in my right to life because on the territory of France or the UK, we have nuclear weapons. I think it is more complex. And a possible avenue might be, I have not done much research so far, but this could be an interesting avenue, like environmental and climate change litigation, to see what can be used as a source of inspiration for our issues. A recent trend, and this is the last slide or almost the last slide. Again, concentration on the rights of victims, maybe because of the frustration in terms of nuclear disarmament. We try to find more concrete, more realistic ways and avenues. And so in the TPNW, again, we have Article 6, victim assistance and environmental remediation clause. And we will soon have the third meeting of states parties of the TPNW in New York in March. And this will be one of the focal point of discussion, how to help victims of testing and use of nuclear weapons to get justice. And what I really find an interesting trend, or let's say avenue, not so much exploited yet, I would say, is the so-called disaster law, international disaster law. And it's interesting to remind that in 2016, the ILC, the International Law Commission, adopted articles on the protection of persons in the event of disasters. And I wrote in articles that, from my point of view, nuclear weapons use would amount to a disaster defined under Article 3 of the articles. Disaster means a calamitous event or series of events resulting in widespread loss of life, great human suffering and distress, mass displacement, or large-scale material or environmental damage, thereby seriously disrupting the functioning of society. So these articles want to make sure that if something like that happens, a disaster happens, that human rights apply to the victim of this disaster. And the really good message is, or the good news is that in November, if I remember well, the UN General Assembly decided that these articles, non-binding as such, shall be negotiated into a binding treaty, so that we have states ratifying this treaty and being bound by these norms. I think this is a great opportunity for our discussion and for our circles to engage on that level. This is just something I wrote a couple of years ago. If somebody's interested in more of that sort. Thank you very much.
Thank you so much, Daniel. On these topics, as on so many of these other ones, we really need to devote the day to it, but it's well worth it. An overriding objective of this conference was to bring in as many perspectives as we could. And with our next speaker, we bring in one perspective we haven't hit and another level of a perspective we have talked about. Randy Rydell, who is now the executive advisor to Mayors for Peace, and but is the retired senior political affairs officer, Office of the High Representative of Disarmament Affairs at the UN. Randy was at the highest levels in the disarmament group at the UN for many years, and before that, worked in the legislature, in the Senate, for on issues involving international affairs, and so brings both the UN perspective and, like Congressman Liu, the legislative perspective. And so we've asked Randy if you could talk broadly about what the UN is doing and can do, and what we should be looking to it for, and also broadly to the legislature. But before I turn it over to you, I'll mention that one of Randy's other main accomplishments, and one I've heard him mention often recently, he's the principal trumpet in the UN Symphony Orchestra. So sound your trumpet on these issues. And I should also say Randy is on the board of advisors to LCNP, and we work together with him there, with Jonathan and John and Jules and Deeps and others who have been involved today.
Well, thank you, Charles. I think perhaps I should start by playing taps. Anyway, I'd like to talk about a tale of two crises that we're all experiencing right now. Two crises, a tale of two crises. The first one is a crisis in disarmament. We see new hints of intentions to resume nuclear testing. We see no real progress by the nuclear weapon states in implementing their commitments made repeatedly and reaffirmed under NPT meetings in 1995, 2000, and 2010. We see a resurgence of threats of use of nuclear weapons. We see no nuclear weapons. You may find this hard to believe, but not one single nuclear weapon has been destroyed as pursuant to any treaty. They put caps on deployments, they put caps on strategic weapons, but not required destruction. There's no disarmament agencies in the nuclear weapon states. There's no disarmament budgets in the nuclear weapon states. There's no plans for implementing disarmament commitments. There's active modernization underway on warheads and delivery systems. There's repeated reaffirmations of deterrence and the indispensability of nuclear weapons and deeply embedded first-use nuclear doctrines. There's a lack of interest in disarmament in the nuclear weapon states legislatures. The UN Security Council is inactive on disarmament issues, especially relative to non-proliferation and nuclear security, where it's been quite active. The Conference on Disarmament, which is supposed to negotiate multilateral disarmament treaties, has been in stalemate for almost 3 decades now. There is a funding crisis facing NGOs who work in disarmament. Foundations are cutting back. Funding priorities are also skewed at the United Nations, where disarmament receives less of a budget than cleaning services. There is different approaches to disarmament throughout the UN, mainly 2 blocks of countries, one saying that we need progress toward disarmament, and the other saying we need progress in disarmament, namely actual steps in the course of reducing and eliminating weapons. There was a total elimination, a total ignorance by the nuclear weapon states of the UN's ultimate goal, repeatedly reaffirmed, of general and complete disarmament, which involves not just the elimination of nuclear weapons, but also conventional arms control, peaceful resolution of disputes, and reaffirmation of the prohibition on threats and use of force. There is also widely uneven transparency of existing declared arsenals. So much for the crisis in disarmament. I'm going to now talk about the crisis of the rule of law for disarmament. Number 1, lack of disarmament negotiations, lack of verification for nuclear disarmament, the long-standing practice of including withdrawal clauses in disarmament-related treaties, the fact that there are missing treaties. There's no treaties for space weapons, for missiles, for the anti-ballistic missile defense capabilities, and for delivery systems. The nuclear weapon states have rejected the 1996 ICJ advisory opinion. The nuclear weapon states have rejected the TPNW, the Treaty on the Prohibition of Nuclear Weapons, and the more comprehensive Nuclear Weapon Convention. There is an uncertain future for the New START Treaty and its follow-on. There are also cases of treaties losing parties via withdrawals, such as the Outer Space Treaty, the ABM Treaty, the Nuclear Nonproliferation Treaty, the Treaty on the Conventional Forces in Europe, the CTBT, the Test Ban Treaty, and even the Moon Treaty. There's a lack of universal membership in any international disarmament treaty. There's a persistence of compliance problems with respect to Iran, DPRK, nuclear weapon states under the NPT. There's a lack of international enforcement capability and weak accountability. There's a lack of, this is a theme that I've emphasized a lot in my writings at the UN, lack of congruence, a gap between international norms and domestic laws and institutions. There was a huge gap in that area. There was a chronic failure of the CTBT to enter into force. There's treaties that have ceased to exist, like the ABM Treaty, the INF Treaty, the Intermediate Nuclear Forces Treaty, the Treaty on Conventional Forces in Europe, and Open Skies Treaty. And lastly, there are the cases of the 5 treaties establishing nuclear weapon-free zones, whose protocols have not been ratified by all the nuclear weapon states, and who have different views on whether transits of nuclear weapons are permissible through nuclear weapon-free zones. All right, that's the bad news. Now some positive news. There is ample evidence of international humanitarian law norms that they are recognized by US military and strategic doctrines, at least those that we know are public. there's widespread international recognition that the international humanitarian law norms apply to any and all use of nuclear weapons. There is let us not forget, there's also the fact that there are in existence today 186 countries that are officially non-nuclear weapon states, bound by treaty commitments to be non-nuclear weapon states. That's a significant achievement. There's the virtual total elimination of all chemical and biological weapons. There is a persisting international support for disarmament throughout the UN, throughout the NPT states parties, and also in regional zones around the world. There's also a very encouraging broadening of the political bases of support for disarmament, including diverse groups, and also cross-country, cross-issue linkages involving disarmament, including economic development, the environment, climate change, human rights, the legal and medical professions, etc. All of these have great implications for the wonderful factor of political will, which is needed to revive disarmament as a priority. And I also want to note that there is strong international support for the Treaty on the Prohibition of Nuclear Weapons, which has 94 signatories and 73 states parties. The path ahead involves a sail and an anchor. The sail is political will, the anchor is rule of law. In terms of political will, there's an essential need to bring disarmament, to bring democracy to disarmament, to explore creative ways and means of strengthening the political will to support disarmament, expanding universal participation in disarmament deliberations in multilateral and regional forums, efforts to encourage greater roles for legislatures, expanded opportunities for civil society participation in disarmament events, expanding appeal to the public opinion via media and education, and support for youth involvement. I entirely support what my panelist, fellow panelist, Mr. Gibson said about, and Charles also, about the importance of youth involvement. The foundation of political will ultimately is to build support and the understanding among the general public. Popular support is the foundation for the political will necessary to achieve disarmament. Raising the issue priority in national laws and policies, and for encouraging greater international cooperation in this field. Let us recall the first 3 words of the UN Charter: we, the peoples of the United Nations. We have to keep the focus on humanity. Secondly, bringing the rule of law to disarmament by expanding universal membership in treaties, seeking improvements in transparency, incorporation of irreversibility in disarmament agreements, advances in the verification of disarmament treaties, and a more intensive treaty review process, including issues of compliance and accountability, negotiation of new treaties, such as in missiles, missile defense, nuclear weapon design, delivery systems, a comprehensive nuclear weapon convention, and advancement of general and complete disarmament, and the establishment of disarmament agencies with negotiating mandates. And needed most is congruence between international disarmament commitments and domestic laws and institutions. In closing, I can only rely on my former boss, Jayantha Dhanapala, who told the American Bar Association the following in 2002, specifically to the ABA. He said, "As lawyers, you now have the task of working on behalf of the majestic equality of a law that can and must serve the interests of human security rather than just the interest of particular states. More precisely, you must convey the message that the advancement of the interests of human security is the best way to advance the interests of all states. I cannot imagine how this will be possible to achieve in a world without the rule of law, a truly majestic law with equal rights and equal protections for all. You have my best wishes in all your efforts to reach this goal, and you will not regret the journey." Thank you.
Thank you. Thank you so much, Randy. And thank you, everybody. I wish we had time to spend another hour, but the next panel, I can see some of them arriving. And we now get a 10-minute break, and we turn to really the day-to-day issue, right? Bruce Blair, whom many of you will remember, who was a major thought leader in this field, who had been had he not been an ICBM launch officer, if my memory is right, it may not be exactly right, and then he was at Princeton for many years and wrote prolifically about what deterrence means in terms of the readiness level with thousands of nuclear weapons on our side and on Russia's side, ready to use. And so it's always in play. And even when there was no, new Cold War, even in the post-Cold War world, Bruce Blair wrote about how the American and Russian planes, somebody mentioned that it's happening again, and there's some recent incidents off of Alaska. But even after the end of the Soviet Union, you had, constant kind of in-your-face confrontations between planes and ships and at times even submarines because of deterrence. So anyhow, we will move after the 10-minute break into deterrence. Thank you all, and we are adjourned until 4:50. Thank you.
Charles, I have a question. Shall I quit this meeting and join through the speaker's link?
Oh, no, you don't have to. Once you're here, and Karen knows all. We don't know how she does it.
Yeah, we can stay on the same link.
Thank you.
Thank you.
Okay, welcome back, everybody. As I said earlier, this is the panel. We styled it as International Law of Threat and Nuclear Deterrence, a deep dive. When John Burroughs and I were talking quite some time ago about organizing this panel, and actually for the one last year, we discovered something that certainly I hadn't realized. While there's not a lot written on lawfulness of the use of nuclear weapons, there's a fair amount. I mean, a number of us have written books and articles, and there's a reasonable amount of literature on the lawfulness of the use of nuclear weapons. But there's far less. There's very little literature on deterrence, and really, I mean, that's really after a search for it. There's just not a robust body of literature on it analyzing the law. So the issue that Judge Schindler was talking about, in effect, how do we develop the law where you don't have not only case law development, but you don't have literature, you have occasional conferences. It's really quite interesting, right? So we decided to make this a long panel and try to have as robust a discussion as we can. And I will tell, and we still have 87 people with us. So happy that we're still having a robust and broad discussion. In our prep session, we all wanted to talk about use because we all know so much. We've thought about it, written more about it, and it was challenging getting us really to think about deterrence. So I almost think with this panel, we may end up with as many questions as we get answers. But the way we decided, and we decided to at least try to be somewhat disciplined, is to divide this panel into first an analysis of threats. What is the law, the international law, as concerns threats? And as many of you, probably most of you will know, there's two bodies of international law about use of force. There's use ad bellum and use in bello. And use ad bellum, long-standing law that goes back hundreds of years. When is it lawful to use force? And then use in bello, once you're using force, what limitations are there as a matter of law on the kind of force you can use? And then there's another issue we'll get to. What's the interrelationship or the overlap between use ad bellum and use in bello? So the way we've organized this is we're going to try to talk about threats under use ad bellum and use in bello first. What is the law, to the best any of us have been able to put it together, on threats, right? And we're going to look at them separately, first under use ad bellum and then use in bello, and then the overlap. And then we're going to spend the first hour on that, and then we're going to reserve the second half hour. This panel will go on for 90 minutes, I think, on deterrence itself. And there'll be issues. Is deterrence a threat, or is it a threat in some ways and not in others? I mean, there are issues that deterrence will bring up beyond the threat thing. So the way we decided to break it down is we're going to first talk about jus ad bellum. Under international law, what is the law as to threats, as to when it's lawful or not to use threats under that body of law? And we've said 25 minutes for that, 5 minutes per speaker. John Burroughs sent me an email last night saying he was going to reserve most of his jus ad bellum time for use in bello, because that's what he wants to do. And if anybody else wants to do that, please do. But here we go. So let's get going, and sort of a continuation, I hope, of my comment earlier, Colonel Lee, that I see you as, I'm before the Supreme Court here. We said we'd lead off with you.
Yeah, thanks again, Professor Moxley. I really appreciate it. Want to extend my thanks one more time to the New York State Bar Association for putting this on, and the entire the cast of individuals that really came together to put on a great day with so many experts in this field. Once again, it is humbling and an honor to be included, to be here today. Before I get started, just a little disclaimer that the comments that I've made today are of my own. They are personal in nature, do not necessarily affect the views of the Department of Defense, the United States Army, or United States Strategic Command, where I currently work. Charlie, do you want me to give a view from the inside again, or do you want me to launch into jus ad bellum, or which way do you want me to go with it?
What I was thinking you might do, if it's okay with you, is just sort of give us your perspective. We're going to talk about threats.
Perfect.
And we're going to talk about deterrence too. I mean, just address that broadly, notwithstanding my comment that we're going to sort of bifurcate. But,
yeah.
You're on the inside. What does this look like to you? Sort of help us understand, and then the discussion, I think, will be led by that.
Yeah, no, and that's what I was hoping you were going to say. So just a brief introduction to United States Strategic Command and the mission of the combatant command that I work for. There are 11 combatant commands. Typically, they divide up the world. Oftentimes, there may be also functional areas. United States Strategic Command is a global command. United States European Command covers Europe and much of that area. AFRICOM, or African Command, and then the Indo-Pacific as well, are just a few other examples of the geographic commands. But I'm at United States Strategic Command, and our mission is to deter strategic attack through a safe, secure, effective, and credible global combat capability, and when directed, ready to prevail in conflict. And what does U.S. Strategic Command mean by deterrence? It's the influencing an adversary from making a decision under specific conditions based on expected outcomes. Essentially, we want the leader of an adversary nation to wake up each morning and decide today is not the day to launch a strategic attack against the United States of America, as well as our allies and partners. And because I know it come up in a previous panel of who exactly are we deterring, and I think as far as U.S. Strategic Command is concerned, that's who we're taking a look at are those adversary decision makers out there that truly make those decisions on behalf of that country as to whether or not to engage in a strategic attack. What makes up a credible deterrence, though? It's attribution. Who does it? The capability. Do you have the ability to deliver on what you're talking about, whether it be to impose costs or deny success? Do you have the will, or otherwise known as the determination and the resolve to use that capability? And then finally, how are you communicating that you have the will and the capability to follow through? In each of those cases, United States Strategic Command takes a look at the three different adversaries that we're oriented towards and try to tailor our deterrence towards each one of those adversaries. And then finally, the current policy for the United States on the use of nuclear weapons is that the United States would consider employing nuclear weapons only in extreme circumstances to defend the vital interests of the United States and its allies and partners. I think that Professor Hood may have said in one of her articles that, you know, deterrence could actually be seen as a threat, you know, because that's what you're doing. You're saying that, you know, if you do something, if you take an action, we will respond in a certain way. And I just kind of wanted to use that as maybe the lead in then to the discussion on threats under the jus ad bellum.
That'd be perfect. That's a good, you know, I mean, it's very much appreciated, the perspective. And now let's sort of move into our kind of disciplined process where we first talk about jus ad bellum. So that's perfect, Colonel Lieb, if you care to do that.
Sure. Yeah, from the jus ad bellum, I think another thing that at least helps me think about it then, you know, when we are talking about the jus ad bellum, what are we talking about? And it's that national decision to use force in a situation. And it's made up of two things, necessity and proportionality. Necessity being that all peaceful alternatives have been exhausted. In other words, diplomacy has failed, and there's no reasonable alternative means of redress. And then proportionality in this case, different from jus in bello proportionality, but that the state would use no more force than is necessary to stop the threat and to restore security. So are threats legal under the jus ad bellum? Yes, I think that they would be in certain circumstances. It needs to be a lawful use of force. The nation would be entitled to resort to the use of force if they were gonna be able to make this threat. And I think that the current United States policy actually captures that part of it. And I tried to highlight it when I read the current US policy, is that the United States would consider employing nuclear weapons only in extreme circumstances to defend the vital interests of the US and its allies and partners. So coupling the prohibition that exists under Article 2.4 of the UN Charter, that all states should refrain from the threat or use of force in their international affairs, along with Article 51, which reaffirms states' inherent right to self-defense in there. So coupling those two aspects together, yes, I think that it would be okay for states to threaten to use nuclear weapons in self-defense.
Understood, and that's very helpful. I think what we said is we'll just go down the list. Everybody's in alphabetical order here, and John Burroughs is first, although John, as I said, told me last night he's not going to use his full 5 minutes here on jus ad bellum. He's going to use it in jus in bello. John?
Well, we'll see if I actually live up to that. It is certainly true that there is not a lot of writing about threat, and interestingly, the legal status of threat. And interestingly, that was the case in states' arguments to the International Court of Justice, even though the ICJ was asked about the legality of threat or use of nuclear weapons. Most of the states' arguments concerned the issue of use of nuclear weapons, not threat. Well, let me start with something which to some of us will be obvious, but not necessarily everybody. An aggressive attack on another country's territorial integrity or sovereignty is contrary to the UN Charter and is contrary to Article 2.4 of the UN Charter. And a nuclear threat as part of an aggressive attack is contrary to the UN Charter. And that is certainly the case with respect to the nuclear threats that Russia has been deploying in connection with its invasion of Ukraine. Now, what about nuclear threats as an element of self-defense under the UN Charter, under Article 51 of the Charter? Well, first of all, it comes through the ICJ opinion that threats as well as use of force in the exercise of self-defense must be lawful. That use of force must be lawful is clear to anybody who studies such things. But there had been some dispute about whether threats as well, as opposed to use of force, must be lawful under international law, under the UN Charter. But the ICJ made reasonably clear that threats are subject to the same analysis under the UN Charter. Now, as Travis has just said, threats made in self-defense must meet the requirements of necessity and proportionality. The ICJ said, I quote, "There is a specific rule whereby self-defense would warrant only measures which are proportional to the armed attack and necessary to respond to it." Now, this jus ad bellum proportionality, you see different definitions for it. I've come up with my own sort of common sense definition of it, which is that defensive use of force or defensive threats must have a reasonable relationship to the aggressive attack responded to, and they also must have a reasonable relationship to the lawful goals of the defensive use of force. A simple example is expelling troops from the attacked state's territory. But more expansive versions can be like the security situation in a particular region needs to be restructured in order to order to be restored. That's a complexity what we don't need to get into. As Travis said, this requirement of proportionality is a requirement of reason. It differs from the very sort of technical requirement of proportionality in attack during a conflict. That requires that the collateral damage and injury resulting from an attack not be excessive in relation to the anticipated military advantage. Now, an interesting question, which we've sort of been thinking about more over the last couple of years, is, well, does the jus ad bellum requirement of proportionality apply not only prior to the initiation of the defensive use of force, but does it continue through the armed conflict? And it seems to me that it does. After all, proportionality in part is about the restoration of peace. So it continues to apply in that respect. But more generally, it makes sense that this requirement of reason in the application of force would continue to apply during an armed conflict. Well, this is interesting with respect to nuclear threats, because if you take the requirement of proportionality in attack, it could be argued, well, the planner, the legal advisor, the decision maker doesn't need to take into account, for instance, the risk of escalation, because that's just too difficult to determine. And it's not really related to the standard understanding of proportionality attack. But clearly, it has to be taken into account in terms of the jus ad bellum requirement of proportionality, the reason and restraint. And it seems to me that most, if not all, first uses of nuclear weapons and threats of first use of nuclear weapons would be contrary to the jus ad bellum requirement of proportionality. And so I went into some of this in an article I did just about a year ago in Arms Control Today, and I'll put a link in that to the chat. Let me add just one more point, which is that the UN Charter is basically concerned with jus ad bellum, not the conduct of warfare. But the Charter does imply that the legality of threat and the legality of use of force should be analyzed together. And the International Court of Justice reflected this in saying that under Article 4, threats are illegal when the use of force threatened is illegal for whatever reason, quote, for whatever reason. Article 2.4 also prohibits threats inconsistent with the purposes of the UN, among them promoting respect for human rights. So you can see some bases within the UN Charter for sort of a broad prohibition of nuclear threats. I'll stop there.
Thank you very much, John. You all have not yet had the pleasure of meeting Professor Claire Finkelstein, who is the Algernon Biddle Professor of Law at the University of Pennsylvania, a well-known and often speaks and has written a lot on national security law and policy, and is co-editor of the Oxford series in Ethics, National Security, and the Rule of Law, and an editor of 6 of its volumes, and has, as I said, published broadly, often through CERL, which is a center at the University of Pennsylvania, which is active in this space. Claire, thank you very much. I know you've written on deterrence and threats, and look forward to your comments.
Thank you, Charlie, and thank you so much for organizing this marvelous day. I'm sorry that I couldn't participate in more of it, but teaching duties and other commitments kept me away, but it sounds as though it's been a fascinating conversation. And CERL is honored to be a co-sponsor of today's event. So I'm so glad that we were able to engage with it. So I'm fascinated by the question of nuclear deterrence and its legality, because it engages not only critical issues of law and policy, but a fascinating question that I've long studied in what's called philosophical rational choice theory, namely the rationality and or morality of issuing a threat in relation to the legality of the underlying action. It addresses the question of whether or not it is legal to issue a threat to do something that itself would be illegal to do. Now, the question of whether or not nuclear deterrence as a policy is itself a legal policy hangs in the background of this question. Because on one view, the idea that it is permissible to threaten nuclear annihilation to deter the use on the part of other countries of nuclear weapons does seem in part potentially to depend on the answer to the first question, namely about whether or not it is lawful to threaten to use weapons that it would not be lawful actually to use. There are some differences, however, between these questions, and I'm going to address that in a moment. So let me start with the simpler question, which is complex enough, of whether or not it is ever lawful to issue a threat that it would not be lawful actually to make good on. And then we'll see how that discussion applies to the overall case of the policy of nuclear deterrence. So in general, the question that gets posed in rational choice theory and in the writings on deterrence that spun off from that, largely in the 1970s and beyond, goes something like this. Well, it's clearly not permissible to engage in certain kinds of aggressive actions. And now the question is whether or not it would be lawful or permissible for me to threaten to engage in those actions simply on the grounds that I'm seeking to deter another individual from engaging in similarly unlawful actions. And at first blush, there's no reason to suppose that the legality of a threat would depend on the legality of the underlying action. After all, a threat is just a kind of speech act, and no one gets killed by a speech act. There are no physical injuries that seem to result. And so where is the unlawfulness of the conduct? Where is the impermissibility of the conduct? But this question is raised very interestingly when we tie in Article 2.4 of the UN Charter, which lumps together the illegal use of force with the threat to use such force in one sense, which says that if it that under certain circumstances it is unlawful to use force, namely unless you have a self-defense basis under Article 51, as Colonel Travis Leaf just mentioned, then in that case, the suggestion from Article 2.4 is that it would be similarly unlawful to threaten to use force unless you have an Article 51 defense for actually using that force. The question, however, might arise whether or not you could have an independent Article 51 grounds for issuing the threat itself, which is not attached to the actual underlying action. Now, such a threat, let's identify two types of threats that might be issued. One is a bluffing threat, in which you actually have no intention of using the force in question, and the other is a credible threat, or a threat in which you actually intend to take the action in question. One of the issues with bluffing threats is that while you might think that they are more easily justified because you don't intend any kinetic action, you don't intend any use of force from them, but they pose the following conundrum, which is that a bluffing threat, if credible, could generate a right of self-defense on the part of another country, especially given the background of Article 2.4. We could therefore have a situation in which I issue a bluffing threat, another country then sees that threat as imminent, regards themselves as having the right to engage in preemptive action to forestall my use of kinetic force, not perceiving my threat as bluffing, but perceiving it as credible, and then would be justified in taking action against my bluffing threat. If that use of kinetic force is justified, of course, I would not be justified in taking force, in engaging in force against country B, which is presumably engaged in a lawful use of force against my bluffing threat. Well, it's easy to see where this goes, which is that we end up with a kind of bootstrapping effect in which we end up with a lawful use of force, possibly a lawful use of nuclear force based on no threat at all to begin with. Now, that's not only problematic from a prudential standpoint, which is we run a serious risk of escalation once we detach the legality of the threat from the legality of the underlying action. But it seems problematic from a legal standpoint, because one of the foundational principles in international law is symmetry. And our whole understanding of the way the legality of action, kinetic action, in armed combat works is that if one side is justified in using force, another side is not justified in opposing that use of force. Sort of basic correlativity principles applying a Hofeldian architecture to the use of force. It's that principle that also allows other countries who may come to assist you to be justified in providing assistance when one country is using force. So if Ukraine is justified in using force, then other countries are justified in coming to its assistance to use force because of the transitivity of the principle of right involved in such a case. If we detach the legality of issuing a threat from the legality of the underlying use of force, however, the correlativity of rights and duties will no longer hold, because I may be permitted to issue a threat that I would not be permitted to make good on, but another country may have a right of self-defense against my threat. And so we can very easily get into a contradictory series of use of force where the legality of using force does not track the underlying legality of the threatened actions. That I think would be a disaster for the law of armed conflict, for the jus ad bellum, and the way all of this plays out. So let me just go back now to the original question. If one buys, and I haven't had a chance to make a full case here, but if one buys the argument that the legality of a threat to use force should depend on the legality of the underlying use of force, that raises the question whether or not the entire principle of nuclear deterrence is itself an unlawful policy. Now, faced with a large number of nuclear weapons sitting in silos, the threat is not specific, right? We don't know exactly what is threatened. We can't say whether or not the use of these weapons is intended for a first use principle or a second use principle. But we do know that a first use principle is almost certainly going to be unlawful unless we're talking about the very rare circumstances in which it would be justifiable to use nuclear weapons in response to a conventional attack. Personally, I do not believe there are any such circumstances. This is Vladimir Putin's doctrine. He has articulated that it may be permissible to use nuclear weapons in response to conventional forces. That's for another panel. But other than that circumstance, the buildup of weapons in our nuclear arsenal suggests a lack of distinction between a first use and a second use threat. Unless, therefore, the buildup of nuclear weapons is coupled with a no first use principle, I don't think that the buildup of weapons as a deterrent can be lawful, because it's not, that deterrent effect is not necessarily limited to a second strike capability. So I'll leave it there. There's a lot more to say, but I would extend the illegality of issuing threats that one is not permitted to act on under certain circumstances to the entire policy of nuclear deterrence, because it constitutes one big threat, unless it's coupled with a number of principles that cabin what our follow-through use would be as implicated by the deterrent threat.
Thank you, Claire. I think what you've done, at least in part, if I understand your reasoning, is you've done something the ICJ didn't do, which is give a rationale for where it came out, if I get this right. Because what the ICJ said, and I think Colonel Lieb was referring to this in part, but sticking to the ad bellum in this instance, but what the ICJ said was two things. They said it's unlawful to threaten an action that it would be unlawful to take under both. And we've already conflated, and we're pulling together use ad bellum and use in bello. So John Burroughs will be able to will get to come back on this. But what the ICJ said, it's unlawful not just under the charter law, use ad bellum, when a state may lawfully use force, but it's also unlawful under use in bello as to limits on force when a state is using force. And the challenging part of what the ICJ said for international lawyers is we've always all understood that, under the charter, while there are, contrary interpretations, as we talked about in the prep session, but generally the charter section, Article 2.4 says you can't threaten force that you couldn't do. And so we know that's a reasonable support, although some people argue with it, for the first conclusion of the ICJ, right? But the ICJ the second conclusion, which I know John is going to address, but its second conclusion that it's also unlawful to use force under jus in bello when you're embroiled in the middle of armed conflict, in a way that would be unlawful to use the force, right? And people have scratched their head, where's the support for that? So Claire, in a sense, you gave us a rationale, but I'm sorry, let me stop talking. Anna, what is I know Anna Hood wrote a series of articles that got everybody's attention. I forget exactly, a year and a half or two. I remember actually it was Randy Rydell who circulated the second of them to me. I'm sure John already knew about it some time ago, with a co-author, on threat theory and deterrence theory. So take it away, Anna. Sorry to go on so long there.
Thank you so much. And my thanks to you for having me as part of this panel on this day. It's really wonderful to be part of the conversation. There have been great points covered so far. Maybe in my couple of minutes now, what I might do is come back to the jus ad bellum conversation, so we wrap that up, and I have things to say on jus in bello as well. And maybe the angle I'll take is to do a little bit of a deep dive into Article 2.4 and the criteria that have been developed over time as to what an actual Article 2.4 threat has to have to be illegal under 2.4, so that where some of those criteria have come up, but maybe if we put them all together, we'll get a little bit of a sense. And I think by seeing those criteria, we can start to see that very clearly many nuclear threats can never be made. And then there's a category where I think it's a little vaguer and more contestable. So as has been said by the other panel members, Article 2.4 requires UN Charter members to refrain from threatening to use force. And the key criteria as to what is a threat. First up, we have to have either an explicit or implicit threat to use force. So with nuclear weapons, an explicit threat would be, we are going to use our nuclear weapons if you do X, Y, and Z. But there can be implicit threats as well. So if we have a situation, if we think about, say, during the Cold War, go back to 1962 and the Cuban Missile Crisis, when the Soviet Union was putting nuclear weapons into Cuba, that build-up of nuclear weapons in and of itself, in a context where there's hostility between the US and the Soviet Union, that can potentially amount to an implicit threat to use force. Similarly, if you had a situation where there was hostility between a couple of countries and one country was to fly a plane that was nuclear armed very close to the border, that too could be seen as an implicit threat. So we have first criterion is explicit or implicit threat to use nuclear weapons. Secondly, that threat has to be communicated to the other side. That seems pretty obvious, and mostly this happens without us having to think, but there are situations, if we go back to, say, to the Cuban Missile Crisis, where, at least for a period, the US did not know that those weapons were in Cuba, and it wasn't until the US became aware that we could say that there was potentially a threat in play. So we do need that communication element to be present. The third element is that the threat has to be credible. This isn't a high bar. It's not we don't have to definitely know that the threat will be carried out. We do need to know that the country that is threatening to use nuclear weapons has the capacity to use them and has some level of intent. It doesn't have to be a high level of intent, but we have to have a sense that, yes, maybe they actually would follow through on what they're threatening to do. Next one down is potentially controversial. There's not a complete agreement on this in the literature, but my reading and the work I've done with my co-author, Monique Cormier, is that the threat has to be specific. So it has to be a threat that is directed at a specific entity, normally another country. Most of the threats that we see bandied about these days, for example, threats from President Putin, are specific. They're directed to NATO countries or to Ukraine. Similar, the same goes in sort of the Korean Peninsula. Most of those threats are quite specific. I think where this becomes an issue is with some deterrence policies, because many deterrence policies are very broadly cast. If we are attacked, then we will use our nuclear weapons. It's not directed towards any particular entity. One exception to that, though, is sometimes we can look at contextual factors with deterrence threats and make arguments that actually, when you look at what a deterrence policy is actually aimed at, even though it looks like it's general, it's actually targeted at a more specific entity. So, for example, with India and Pakistan, India has a general nuclear deterrence policy that suggests it will use nuclear weapons if it's attacked. But when we look down at what the context of when that policy was developed, it's very much targeted at Pakistan. So potentially, we can say that actually India's deterrence policy is an illegal threat because it's very specifically targeted. Whether that sort of logic can apply to all deterrence threats, I think, is up for grabs. It's not clear that all deterrence threats would come under that. So we've got those criteria. I realize I'm probably pushing my time. So the last point is just one that's been made very eloquently already, and that is that a threat will be illegal if it meets those 4 criteria. It, however, will be excused or be okay if it's been made in self-defense under Article 51, as others have said. Like a couple of my other panelists, I really struggle to see that the requirements of self-defense could ever be satisfied in this space, but nonetheless, those are sort of the criteria that are on the table. So sorry, Charlie, I'm going over time. I'll leave it there. I'm very happy to come back and talk further as we keep going along.
Not at all, Anna. And this is something that I think you and Daniel and I talked about last summer when we were on those panels in Hiroshima there at the Peace Palace talking about this stuff. If one of the purposes of these discussions is that we have this opportunity to sit down with Colonel Lieb, who, is the man on the spot with others with, responsibility on the place, we have to make the distinction that was made in an earlier panel by a number of people between policy and law. And sort of the question I have on so many of these things, and this is really me as a guy who spent 35, 40 years, as a lawyer in the courts in commercial securities cases, where's the law, right? If we want to talk to Colonel Lieb and make an argument on what our policies, where we think there should be a consideration of some legal points, I suspect he'll take them back if we're citing the charter or we're citing some case law that he hasn't heard before. But if it's kind of, interesting theory and thoughtfulness, then it's kind of interesting, but it's not something that needs to be looked at, right? So I mean, how do we divide this up? I mean, where do we come, and I say this out of not knowing the answer to any of this, right? Because we've said there's not much literature on this. I mean, we could look under the UN Charter, right? A source of international law are general principles of law recognized by civilized nations, by other nations, right? So someone, and I don't think anyone has done this exactly, although John showed me something that an intern, I think it was at LC&P, did a couple of years ago, but it was only like a very preliminary first effort. Someone could say, I'm going to look at the law across the world's systems. And under the world's legal systems, you can't make a threat to do something illegal. If we could give that to Colonel Lieb, I think he'd have something he'd have to take back to his team and say, tell us why this is wrong. So I don't know. I'm sorry, just to go on, but do you have a sense, Anna, where are we talking about political science policy here? And where do we kick in with with a rule, I mean, what the ICJ said, and of course, Judge Shinlin said, well, it's an advisory opinion, it's not law, but the ICJ is the court for the UN, and it has some salience, but where's actual law here that we can ask, Colonel Lieb to take back?
Good question, Charlie. So I think what my argument would be, everything that I just laid out, I think is legal doctrine. It is law. I wasn't going straying into policy. The points I was making is the elements of Article 2.4 that I laid out are well established in the legal literature, in case law. I think they are widely agreed in military manuals around the world. And the one point where I think there is a little bit of debate is that, is it a need for a specific threat or a general threat? While I personally have a lot of sympathy for saying we should get rid of all threats, and I've written about that idea, where I think the law stands at the moment and where there's agreement amongst states is actually that it has to be a specific threat. So my argument is that at the moment that is where the law sits, and there's lots we can do in terms of talking about where the law could go. But at the moment, I think that represents a state of international law.
Yeah, so I think that's something we should talk about. I mean, what case law support is there? Plus, there's a question: what does specific threat mean? Right? I mean, we all remember we had Professor Painter, who had been in the George W. Bush administration, but those of us who are old enough to remember the identification, of the rogue nations. I mean, we all remember who they are, and I don't think we'd have to do more than much research to find that our policy of deterrence, based on statements by our political leaders, I mean, we know that they're addressed to Russia, China, North Korea, Iran, right? I mean, but is that a specific thing where we can find policy statements saying those are our countries of concern? I mean, I don't.
Charlie,
Yeah.
can we address these questions? But maybe let's give Professor Luban a chance to
Yes,
talk.
of course.
Yeah.
Yep, absolutely. Oh, and let me just say that with David Luban, who teaches at Georgetown Law School, and also at the U.S. Naval Academy, the Stockdale Center for Ethical Leadership, and is the author of a number of books in this space, and is an extremely well-known person in this space. Thank you, Professor Luban.
Well, thanks. And I've been at the conference since the beginning, and I think that this has been a fantastic event. So I'd like to thank you. And I've just taken so much from the speakers. I'm going to try to keep this short so that I can reserve time to talk about our second group of questions, which is about the link with IHL. With the in-bellow. And that's because I think that these two issues can't really be separated. So obviously, if something's illegal, I can't do it. Can I threaten it? Well, sure, I can threaten it if I don't carry out the threat. Let's just start with an ordinary non-nuclear case of everyday life. Somebody snatches my backpack off a table at a coffee shop and bolts for the door, and I pull out my gun and I point it at them and say, I'm going to shoot you dead unless you drop the backpack. Now, I think that carrying out the threat is illegal and immoral. Because of the gross disproportion, and I hope that's the law of self-defense in most states, although it may be changing quite rapidly. But let's just suppose for the moment that it is. And the person drops the backpack and leaves. I get my backpack back. I've prevented something wrongful with a deterrent threat. Carrying out the threat would be illegal. So let's just take that as an interpersonal example. Now, would I actually carry out the threat? Well, no, I wouldn't, because I'm a decent human being. So the threat itself is a bluff. So I'm picking up on Claire's distinction between bluffing and non-bluffing threats. Now, let's move to the nuclear realm. Is it possible? Let's suppose, just for the sake of argument, that carrying out a nuclear deterrent threat would be illegal. And I'm going to add immoral, but that's not the legal category that matters here. Well, in that case, can I make a bluffing threat? Now, it seems to me that, of course, I can in the interpersonal case, because I can form this intention not to carry it out. But can I do that in the international case? The problem with deterrence is this: a deterrent threat is going to be ineffectual unless it's credible. And arguably, the only way to make it credible is to form a conditional intention to carry it out. You know, that's by conditional intention, I mean, if you do this, if you attack us, then I'll launch. If you threaten my vital interests, I will launch. Now, in my interpersonal case, I didn't have to form the conditional intention to make the deterrent threat. But I don't think that's possible in the case of nuclear deterrence. That's because of what it takes to make a threat credible in this space. To make it credible, all the pieces for carrying it out have to already be in place. All the protocols have to have already been written. All of the military personnel who are going to carry out the threat have to have been trained and practiced. So if you think of the decision to actually launch, to carry out the deterrent threat, is the step N after a lot of steps from 1 to N-1, then all the steps up to and including N-1 have already been taken. Now, you might think, okay, well, step N is the commander-in-chief giving the order. Now, of course, that's something that can't be guessed, but we have to assume that an adversary has very good intelligence about all of those steps N through N-1. So leaders can't assume that they can form this intention, this complex intention involving billions of dollars worth of equipment and thousands of human beings who are all trained to carry it out. We can't assume that we can have a secret policy to make it a bluffing threat and keep that secret. So I think that in this case, we have to form the conditional intention to carry it out. And that means that the distinction between forming the intention, making the threat and carrying out the threat is really thinned, because I've already formed this conditional intention to carry it out. So I think that everything turns then on the question of whether, if the actual launch is unlawful, then I think that the threat to launch is unlawful, because the only way that you can make that threat credible is to put the pieces in place to carry it out. And at that point, there can't be any confidence that it won't be carried out. And so that's why it's going to be important for us to talk about whether these threats, if carried out, are lawful or not. But this is, I think, my case for why there's an inextricable linkage between the two. And I'll stop here.
Thank you so much. Colonel Lieb, I guess we circle back to you if you care to respond to any of the points made and then take us into in bello.
Yeah, I agree with most everybody with everything that we've gone through thus far. And I think that Dr. Burroughs had brought it up earlier too, that the use that and Professor Lubon just highlighted as well, that the use ad bellum and the use in bello are so closely linked in there, and that was going to be my point when we came to the use in bello portion of it, was that at least from my perspective and where I sit, these are not, to use the 3 levels of warfare, these are not tactical or operational decisions that are being made. These are strategic decisions that are being made by the president. The same authority that determines whether or not we go to war in the first place, that implicates that use ad bellum. And just like Dr. Burroughs had mentioned before, the whole point behind doing any of this should be to bring that conflict to a close as fast as possible, without using any more force than is necessary. So I think that the jus ad bellum is a continuum on there, and potentially each uses of a weapon would go through that jus in bello analysis under the principles under international humanitarian law, needing to comply with proportionality, distinction, humanity, and the like. But coloring each one of those would be the jus ad bellum in the background. And when I take a look at it from a jus in bello perspective, and each of the principles in there under international humanitarian law, I come to the same conclusion. I think you could make a threat under jus in bello in order to use nuclear weapons. And others may come to a contrary conclusion. If you feel that there's no way you can use these weapons proportionately and they're inherently indiscriminate. I respectfully disagree on both of those points. But if that's your going in position, then no, you probably couldn't threaten to use it in jus in bello. But from my perspective, if we're taking a look at a military objective that we're striking there, and the decision maker makes the determination that the potential civilian casualties or civilian harm is not excessive in relation to the military advantage to be gained, then no, we can use that weapon in order to do it. So, along that same logic, I think a threat would be permissible in that situation.
Understood. Thank you. Thank you, John.
Right. So during the course of conflict, is it permissible to threaten to use nuclear weapons, or does illegality, if that's your position, which is my position, or does illegality only arise with respect to the use of nuclear weapons? Well, as we've already touched upon, the International Court of Justice found that any threat to use nuclear weapons, whether aggressive or defensive, must be of a use that would comply with international humanitarian law or jus in bello or law of armed conflict. In general, the ICJ said that, quote, if an envisaged use of weapons would not meet the requirements of humanitarian law, a threat to engage in such use would also be contrary to that law, end of quote. So under that principle, to repeat, if the use of nuclear arms is illegal, the threat of their use is illegal. Now, it appears that the court enunciated the principle that a threat to use weapons in violations of international humanitarian law is illegal on its own authority. Let me just pause there and say, one cannot really just say, oh, it's just an advisory opinion of the International Court of Justice. The International Court of Justice advisory opinions have a real place in the development and articulation of international law, and are generally accorded a lot of respect. I won't go further than that now. And it's also the highest court in the world on general questions of international law. Its judges include eminent international lawyers. And as we know from the Supreme Court in the United States, it's not unusual for the highest court in a judicial system to develop the law, or put another way, to make visible already existing principles. It can't just be dismissed. And I suggest a thought exercise regarding biological and chemical weapons. Their use would be violation of international humanitarian law, prohibitions of attacks with indiscriminate and uncontrollable effects. Further, a nearly universal convention, the Chemical Weapons Convention, prohibits the possession and use of chemical arms. Another one, the Biological Weapons Convention, prohibits possession of biological arms, reinforcing an existing ban on their use. Should a specific and credible threat to use biological or chemical arms be considered lawful? I don't think so. There are partial prohibitions of threat under international humanitarian law. Protocol 1 prohibits acts or threats of violence, the primary purpose of which is to spread terror among the civilian population. Another provision prohibits threatening that there shall be no survivors. Threats to violate the law of armed conflict would also appear to be contrary to the obligation set out in Protocol 1 to the Geneva Conventions, Article 1, that states parties, quote, undertake to respect and ensure respect for this protocol in all circumstances. Now, the specific treaty prohibitions can be viewed in two ways. One is that their partial character demonstrates the lack of a comprehensive prohibition of threats to use weapons in violation of international humanitarian law. The second is that they are expressions of an underlying principle, namely that it is prohibited to threaten to carry out a prohibited act. This is a position that the International Committee of the Red Cross has taken. So the latter view is more consonant with the evolution of international law, recently illustrated by the negotiation of the Treaty on the Prohibition of Nuclear Weapons and the UN Human Rights Committee's 2018 General Comment on the Right to Life. And both of those Daniel talked about in the last session. View of time, I won't go into detail on those, but they both address threat. Also noteworthy is the position adopted by the group of 20 states and intergovernmental forum that includes the world's major powers. The declaration made in Bali in November 2022 states in part, I'm going to quote the whole paragraph, it is essential to uphold international law and the multilateral system that safeguards peace and stability. This includes defending all the purposes and principles enshrined in the Charter of the United Nations and adhering to international humanitarian law, including the protection of civilians and infrastructure in armed conflicts. Now, here's the money line. The use or threat of use of nuclear weapons is inadmissible. The position clearly was occasioned by Russian nuclear threats, but by its terms, it is not limited to that circumstance. It was repeated in another G20 declaration in New Delhi in September 2023. I'll stop there.
Thank you, John. Claire, what's your perspective when we get to this in bello context?
Okay, so I want to go back to the narrow question of whether or not it's lawful, say in an ordinary criminal law context, to threaten something it's not lawful to do. And I want to pick up on David Luban's comments on that. And we had discussed this example of somebody is stealing something from your home in a prep session that we had for this session. And I believe that even in the criminal law context, the correct answer is it's not lawful to threaten to do what is not lawful to do. And what's my backup for this? Number one is the consideration that I raised in my remarks originally, which is that if I threaten to use lethal force in a context in which I'm not permitted to use lethal force, that would give a license to the other party, the person who receives my threat, to use lethal force in self-defense against me if they believe that that threat is imminent. Therefore, if a robber is stealing your television set and you're in a state in which it's not lawful to use lethal force to defend against theft of property, I believe it cannot be lawful for you to threaten to shoot him to prevent him from stealing your television set, because it would entitle a right of self-defense on his part, as long as your use of that force would itself be unlawful. Consider another example. My daughter threatens to run away from home. Has not happened, just want to make clear. Suppose she threatens to run away from home and I brandish a weapon at her. And I say, if you do, I'll shoot you. If you walk out that door, I'll shoot you. Well, not only is it unlawful for me to use that force, but the illegality of the use of that force translates into the illegality to threaten to use force in that context. And indeed, in many states, the mere showing of a weapon, brandishing a weapon as a threat is itself an unlawful act. It's itself in many states an assault. So therefore, I think it's extremely dangerous to uncouple the legality of threats from the legality of the underlying acts. And I don't think that existing law supports that kind of uncoupling. Now, I just want to mention one thing about the ICJ. Thank you, Charlie, for giving some more context, because I do think that this is a way of supplying a rationale for the 1996 ICJ decision. But there is a caveat here, which has to do with the Nicaragua decision, in which the court held inter alia that it was not a threat for the US to be supplying the Contras with weapons, because the mere supplying of weapons did not constitute a threat to use them. So that doesn't falsify the principle that it is not lawful to threaten to do what it's not lawful to do, but it does suggest that what counts as a threat requires some more refined analysis. Now, I think that refined analysis is going to bring us back to the question of whether or not maintaining a deterrent arsenal constitutes a threat to use them, and what kind of threat to use them is entailed by the mere maintaining of an arsenal. So I think it's awfully tricky to translate this whole discussion about the unlawfulness of threatening to use force into a discussion about the lawfulness of deterrent policy. So there's trickiness there.
Which leads into the point you had addressed earlier, Anna, about specificity and so forth. And you were raising that. What does it take to have a threat? What's your further comments on this in bello context?
Thank you. I'll try and be brief. I think speakers have set out very well sort of the lay of the land and the tensions and the difficulties, and in particular, John, going into the detail of, are we looking at those very specific IHL rules? Are we looking at all of the principles of IHL? That tension there, I think, is one that it remains a live debate and an issue. Rather than diving into that again, what I thought I'd comment on is the level of difficulty, whatever body of law we decide we're working with, there's a level of difficulty in applying it to some of the actual real life threats that have been made during conflicts. So if we go back to as far back as, say, the Korean War, during that war, President Truman made a comment that we will take whatever steps are necessary. That includes using every weapon we have. So in many ways, that's a threat to use nuclear weapons, right? He's talking about every single weapon that we have. If we try and look at that statement, which is made in the context of a live war, and we think about, is it in violation of the principle of distinction or the principle of proportionality, we almost don't have enough information to be able to make that call, right? And it's hard to know what to do with the statement. Maybe we assumed that President Truman was making that statement with the implication that, and it would only ever be if it was done in compliance with with international law. Or maybe we shouldn't make that implication. The same goes for some of the comments President Putin has made in the context of the conflict with Ukraine. He has threatened to use nuclear weapons against Ukraine, saying comments like, "We will protect our land with forces and all means at our disposal." Now, if we have the starting position that nuclear weapons can never be used proportionately and so on, which possibly is close to where I am, then that's easy. All of these threats maybe can say are illegal. But if we don't, if there are, it's clear from this conversation that that's not a universally adopted position. And so once we try to enter into applying these rules to these concrete situations, it becomes very difficult to see how they actually can fit and limit. And so I think what we're really seeing is no matter which body of law we're applying, there are real difficulties here. And I think that's why it would be good for us to continue to develop the law. And I'm very much in favour of sort of the direction that John is heading, is thinking about these statements that have been made in forums like the G20, looking at the norms that are in the TPNW. Unfortunately, I don't think those bodies are yet universally accepted bodies of law that exist, but I think they are where we need to be going so that we have clarity and we don't need to get into these definitional areas, which are so tricky with some of the statements that we see coming out.
We will come in our next topic very imminently on specificity and clarity versus ambiguity. But let's finish this cycle of in bello. And David?
Yeah. So let me just start by saying that, of course, the DoD Law of War Manual says that the law of war governs our use of nuclear weapons, just as it governs the use of conventional weapons. And our nuclear policy is that all of our nuclear targeting is lawful. And I think the main reason is that we have long abandoned the idea of counter-value targeting, counter-population. It is in favor of variations on counter-force. And I think that's more complicated because of, which bits of civilian infrastructure are part of our legitimate military targets, which bits of the leadership are legitimate military targets. So I'm going to raise an uncomfortable question that I don't know the answer to, and that is whether lawful targeting is consistent with effective nuclear deterrence. Let's put it another way. If the only effective deterrent is unlawful targeting, do we give up nuclear deterrence or do we give up lawfulness? Now, just going back to the very dawn of the nuclear age, we know that Bernard Brodie said that the nature of these weapons is so different that they can have only one use, and that is to prevent their ever being used. The Churchill line on how safety is the sturdy child of terror. The question is, if suppose it were true that only nuclear deterrence can give us peace and security, as Article 1.1 of the UN Charter declares as a purpose of the UN. Do we want to give up deterrence if it turns out that deterrence would require us to do things that are unlawful? I mean, in conversations with people, I've constantly thought about the famous Oppenheimer quote after the Trinity test, I am become death, the destroyer of worlds. And my question, do we want law to become the destroyer of worlds? So here's the problem. It may well be that military and leadership targets, so legitimate targets, are located closely enough to civilians that striking them would cause immense civilian casualties. And earlier today, we heard Lauren Grego talk about what would happen if our legitimate military targets were struck and how many civilian deaths there'd be. I've been struck by a recent paper modeling, this is by Steve Fetter and Sebastian Philippe, calculating casualties from a counter-leadership strike in Russia, which would lead to, they think, about 2 million prompt casualties, 2 million prompt deaths, and 2 million deaths from fallout. Now, that's a third of what a counter-population strike would cost, but it's still a staggering number. Now, of course, LOAC and IHL and the moral principle of double effect do permit attacks against military targets that cause unintended civilian casualties if they aren't disproportionate. And it's conceivable that even this staggering loss of life could be lawful if the military advantage was great enough. For instance, if it restored deterrence or prevented escalation. Although I took to heart Alan Weiner's caution earlier today that if he were a legal advisor, he wouldn't even begin to be able to figure out the proportionality calculation given that number of civilian deaths. I want to ask the question, are those deaths unintended? Because that's the requirement. And here I'm afraid that the answer is no. Now, why is that? US policymakers have said that the collateral civilian deaths are an essential part of the deterrent threat. So in 2018, this is Stratcom Commander General Kevin Chilton said that the fear of the effects of nuclear fallout against civilian populations was essential for deterrence. In 2022, General Kaler said the same thing. The risk associated with those collateral effects is a major factor which contributes to deterrence. Now, here's the uncomfortable inferences from these. If these are really essential for deterrence, then if we could eliminate those civilian casualties, our targeting wouldn't deter. If it wouldn't deter, we would have no legitimate reason to target that way, and hopefully we wouldn't do it. So that means that those collateral civilian deaths are not unintended. Now, what conclusions can you draw from this? And this is the question that I've been wrestling with and having a hard time answering. One way to go is to say, well, we could deter without illegal targeting. Another way is that if the only way that we could, the only targeting policies would be illegal targeting, is that proves that we have to move toward a nuclear-free world. The other is to draw the very unpleasant conclusion that since that isn't going to happen anytime soon, we should ignore the law for the sake of peace and for the sake of avoiding the ultimate catastrophe. So that's the conclusion that Feder, Glaser, and Acton have drawn. Feder has told me that his co-author, Philippe, goes the other way, that this proves the need to move toward a nuclear-free world. So I want to leave that as a question, but the main point that I'm trying to get at here is that if it's really true that the collateral damage is essential for deterrence, that means it's not collateral. It means that it's intended.
Well, David, you've brought us to our third and final topic, and it's timely for us to jump into it to get cut right to the core and say, is deterrence lawful, right? And that's the question we should be asking. We led off, John mentioned, I mentioned, and Travis, you didn't, speak on the subject, but I think I saw you nodding. You can correct me, that there's not a whole lot of literature on that, on when you get, certainly in the public sphere, the analysis of deterrence, right? But if we assume we get past Professor Hood's question, and I guess Claire, you mentioned it as well, is it specific enough? If we get past that and we say deterrence is the threat, so our earlier discussion is applicable, that it's unlawful either in ad bellum or in bello to threaten a prohibited act, right? Then we get to deterrence, and certainly on Professor Lubin's perspective, don't we get to, if that is the intent in effect, and don't you get, David, to the same thing by the broad definition of military targets and the reality of co-location? So where are we? Colonel Lee, where are we? I mean, how does one defend deterrence? And one has to step back and acknowledge, I think, that, in a way, this was because of the way the question was framed. But in the advisory opinion, in the advisory case, the U.S.'s defense, I mean, we all remember it well, was it's not true these weapons are indiscriminate and disproportional because we have these low-yield weapons that we can control everything on. So what do we do with deterrence at this point? But let's just go around the room here.
Well, we're still doing it every day. At least we're trying to. And so far, it seems to be working because I'm here and able to talk to you today. So it hasn't failed yet, or at least I haven't got a notice on my phone that it's in danger of failing, and I need to move towards off it. So I laid out, kind of the way U.S. Stratcom views deterrence from inside the building, and it lined up pretty much with what Professor Hood had said as well. But it's also true that the U.S. policy doesn't necessarily define who the actors are. Although once you start, digging into the nuclear posture review and some of those things, we outline who the three adversaries are that we're talking about when it comes down to our nuclear planning. So along with all of that, I still think that the United States can deter lawfully. To Professor Lubin's point, though, with the previous testimony in there, and me having gone back and tried to do some research on this and taking a look at Colonel Ted Richards' article that he wrote, which I thought was incredibly helpful in the evolution of nuclear targeting and policy over time that he wrote a few years ago. Thought that we had moved away from that. With two former Stratcom commanders saying that collateral damage is essential to deterrence is interesting. Fortunately, I've not heard General Cotton say that, and I would absolutely steer him away from making a comment like that. But I do think it comes back to what I had raised earlier when I talked about when we look at deterrence at Stratcom, we want that adversary decision maker to wake up in the morning and decide that today is not the day. But as part of that, we need to figure out what is valuable to them. So what is the and the comments that those commanders made may have been done after they retired and not part of, say, Senate testimony as part of their posture hearings. Nonetheless, what is important to those adversary decision makers? To Kim Jong-un, to President Xi, to President Putin, Travis Lieb is not sure that those population centers are necessarily that valuable. Maybe they are. I could absolutely be wrong in it. But when I see the way that President Vladimir Putin is fighting the war in Ukraine right now, he is perfectly content to feed his soldiers into a meat grinder. Granted, he's drafting folks from the hinterland first, so that the Moscow elites, don't necessarily have their kids headed to the front line there. But and then Kim is sending forces to fight in Kursk right now on behalf of the Russian Federation there, and sent 12,000 soldiers. Reports are right now that they've suffered up to 4,000 casualties. My point with all of this is it doesn't seem like that their appreciation for human life has really evolved for the DPRK since the 1950s, or the Russian Federation since the days of the Tsar, before Lenin took them out of World War I. They seem to be using some of the same tactics that they did before. So I'm not sure that those population centers, when I advise a commander, I'm taking a look at those military objectives in there. And if I take away the tiger's teeth and the tiger's claws, then they can't reach out and strike me anymore either. And that's why I think that, our deterrence is credible in there, and it isn't necessarily counter value like it may have been at one time, post World War II, probably even through the Korean War, but it had started to shift after that in the 60s and the 70s to counter force as opposed to counter value. And with that, I will stop and let us go on.
Thank you so much, Travis. Claire, you had a comment you wanted to make.
Well, with due regard for David's fascinating remarks, the first thing I want to do is what I tell my students never to do, which is to buck the hypo. I really disagree with the premise that we're going to achieve deterrence through threatening a civilian population, some kind of perfect deterrence machine a la Dr. Strangelove, by threatening actions that would violate the law of war to that degree. Now, why do I think that? And am I just refusing to recognize that any kind of illegal action could have deterrent effects? No, I understand that, but I understand that you can get deterrent effects from illegal uses of force or illegal threats to use force. But the idea that if we lift the law of armed conflict or lift the constraints, we could nevertheless achieve a sort of perfect deterrence machinery, I think ignores the reality of what the law of armed conflict potentially does for us and has done for us in creating a fairly high degree of international stability since the Second World War. So partly there's an empirical question here. Colonel Lieb suggested that the reason we're all still standing here is that deterrence has been effective. I would rather assign the relative comparable lack of international aggression since the end of the Second World War to something closer to an international order, an international legal order that makes very clear when a country is acting beyond the bounds of international law. I think part of the robust response in defending Ukraine, it's not just because of the NATO alliance, but it's also because of a sense of the justifiability of Ukraine's position and the unlawfulness of the Russian aggression against Ukraine. And that's not simply a matter of any kind of nuclear calculus, obviously. Now, the question of whether or not Russia would have been deterred if Ukraine had been an actual nuclear power, I'm not so convinced that that's the case, given the very clear understanding on Putin's part, I think, when he did this, that Ukraine was going to have robust allyship among NATO countries. Indeed, his attack on NATO was part of his justification for going into Ukraine, namely that NATO was acting as a threat. And so I think the idea of the setup that we have to choose between behaving lawfully and deterrence under some circumstances is a hypo that I'd want to buck.
Thank you, Claire. John?
Right. First, I'd like to make an observation about something that Travis said, and Claire sort of commented on this also, but something Travis said that I hear constantly. Deterrence is working to ensure security, but it's true that it might one day fail. It's the assumption that deterrence every day is keeping our security that I would refute. Basically, I would reject. It is not to say that deterrence might not work in certain circumstances, but the idea we're in like a permanent condition of peace brought about by deterrence, I don't accept. And yet I think that sort of penetrated discussion about this entire subject matter, and I think we should question that particular formulation. Well, forgive me, I'm going to get back into sort of a discussion of what I see as law relating to deterrence. If specific threats are illegal, that points towards the illegality of the machinery and doctrines of nuclear deterrence. And Claire has essentially said this right at the outset. What if all specific threats are illegal? Well, how could it be possible to have a credible or legitimate policy of nuclear deterrence? The United States observed in its oral argument to the ICJ, it is impossible to separate the policy of deterrence from the legality of the use of the means of deterrence. Well, the same thing could be said about threats. Deterrence cannot be separated from the legality of threats. Earlier today, some mention was made of the Nuremberg Charter, and I just want to make a couple of reflections about how that relates to deterrence. It's long struck me in thinking about nuclear deterrence that planning and preparing for aggressive war was a crime for which defendants were convicted at Nuremberg. Nuclear deterrence, even in its most benign forms, inherently involves planning and preparing for nuclear war. The Nuremberg Charter also provides that individuals may be convicted for participating in a common plan or conspiracy to commit any of the Nuremberg crimes, aggression, crimes against humanity, or war crimes. Of course, aggressive war was actually carried out by the Nazis. And decades later, the Rome Statute of the International Criminal Court provides that an individual may be convicted of planning or preparing for aggression, but only if a state act of aggression is actually committed. Nonetheless, I think that the Nuremberg injunction against planning for the commission of international crimes is all too relevant with a situation in which 9 of the world's states rely upon the possible use of nuclear arms under the rubric of nuclear deterrence. This is a condition of, at best, dubious legality, and I think it is also one of immorality and irrationality. The ICJ's opinion can be understood in this way. Having dealt in depth with issues arising from possession and possible use of nuclear arms, the court laid great emphasis on an issue about which it had not been asked: compliance with the international obligation of accomplishing nuclear disarmament in all its aspects. So I think that the global imperatives are non-threat, non-use, and elimination of nuclear weapons.
Thank you, John. Anna?
Thank you. My comments are actually going to pick up on a point John has just touched on, and that is the obligation under Article 6 of the Nuclear Non-Proliferation Treaty, which requires all states parties to the NPT to pursue negotiations in good faith on effective measures for nuclear disarmament. And the ICJ, as well as many different commentators, have all said that what this obligation under Article 6 requires is that all states, whether they have nuclear weapons or not, need to be working in good faith consistently towards nuclear disarmament until it's achieved. And I think this has implications for nuclear deterrence and for states that are under nuclear umbrellas and extended nuclear deterrence. So if all states are having to work towards nuclear disarmament, at some point in time, nuclear weapon states are going to have to give up their policy of deterrence and relying on that. Now, from nuclear weapon states, there are many other steps that they can be taking towards nuclear disarmament. So it may not be that that has to happen right now, but it will come a time, not too far away, where that has to happen. I think, though, for states that are under the nuclear umbrella, there's a very strong argument to say that they actually need to give up their position under nuclear deterrence pretty imminently, if not, it's the time is now, because there are very few steps that those states can take towards nuclear disarmament, given they don't have their own nuclear weapons. So I think getting beyond the world of jus ad bellum and jus in bello, there are other laws that we can bring to this conversation for trying to advance the goals that John has set out, and I share those goals of wanting to see us in a world without nuclear weapons, where we don't have these policies. Thank you.
Thank you, Anna. Dr. Lubin?
Well, yeah, I think I cannot disagree with that. Suppose that we can't get rid of nuclear weapons in a timely way, which it seems to me is very likely. The best that we can do then, it seems, would be an international agreement to settle on a no first use policy. And that would give us some kind of a hard law that would, in a world that has nuclear weapons, which I really can't see many states giving up, would at least give us a hard law that might substitute for nuclear deterrence. If the weapons are there, the deterrent, I think, is automatically there. It's, this was what Bundy called existential deterrence, because you don't know what happened. Now, and John, I don't read the Nuremberg principles the same way that you do. Let's just, first of all, the Nuremberg Charter itself, in and of itself, was not international law. It was the law of the 4 victorious allies, and by its terms, it applied only to crimes committed by the Axis, not the same crimes as committed by any of the allies. It doesn't become international law, arguably, until the UN commissions the International Law Commission to come up with the principles of binding international law that are in the Nuremberg Charter. The ILC did come up with the Nuremberg principles, but then the General Assembly never approved the ILC doctrine. So there isn't really a Nuremberg hard law right now. There's Nuremberg soft law. And that's the soft law would be the Nuremberg principles, which prohibits planning, preparation, initiation, or waging a war of aggression, which defensive, I take it that this is not planning a war of aggression, but a war of retaliation or self-defense or whatever, or a war in violation of international treaties, agreements, or assurances. And I think that absent a hard law treaty, that we just can't say that deterrent policy is a crime against peace, under the Nuremberg principles. They simply don't apply to it. So it seems to me that I think that you made the point that we don't know that it's deterrence that's kept us safe. And I certainly don't pretend to know that deterrence has kept us safe. I've often thought it's just a big question. Was it deterrence that has kept the nuclear peace, or is it just sheer blind luck that no catastrophic accident or act of human folly or rage or passion, that we've lucked out, and that's what kept the peace. I'm agnostic. If I come down on one side of the agnosticism, which is that deterrence is the thing that's kept us safe, then it seems to me that something that would make deterrence illegal would be very dangerous. Let me pick out something from one of the separate opinions in the nuclear weapons advisory opinion. This was Judge Shahabuddin's opinion, who thought that it was insane to use the Lotus principle to say, well, every state gets to decide on their own defensive policy. Because he said, look, that means that states can do something in their own self-defense that annihilates all law on earth. And he's a little bit snarky about it, kind of says, law depends on the existence of human beings. I'm paraphrasing, but that's more or less what he said. You can't have law if you've destroyed everything on the planet. True enough. Now, you can read that either way. If it turns out that deterrence is the only thing that keeps the planet safe, then his opinion is an argument for the legality of deterrence rather than the illegality of deterrence. So in a system of agnosticism, I I'm not sure which way the precautionary principle points. So that's the question that I want on the table. And I think that I've been making arguments that are more on the level of policy and empirics, but it seems to me that that the questions of law turn decisively on those questions of policy and empirics. So I think that's my sort of parting piece of inquisitiveness.
We are at just
Charlie, can I just respond quickly on the Nuremberg Charter point? I agree with you that planning and preparation applies to initiation of aggressive war under the Nuremberg Charter. But if you go down to the end of Article 6, there's also provision saying participation in a common plan or conspiracy for commission of the foregoing crimes. All three of them, war crimes, crimes against humanity, crimes against peace. I don't remember how the International Law Commission handled that particular point. You've raised a lot of other troubling and fascinating issues, but I'm not going to try to comment on them.
What I'm going to suggest is that everybody take a minute. Let's just go around and get final comments from everybody. And I mean, this discussion could go on for hours, but let's just get final comments. Colonel Lieb?
I just want to say thank you to everybody today, for allowing me to participate and to learn from everybody else. I think that by taking part here today, I will bring this back with me to United States Strategic Command and use that to help inform the way we do things going forward. And I can only hope that someday I'll be out of a job, that disarmament will occur and there will be no need for nuclear deterrence. But unfortunately, those days lay in the future. But thanks again for having me.
Well, we're with you on that hope. John?
I think I've pretty much said what I have to say, but I'm glad that we had this panel. So good job by all of us.
Thank you, Claire.
Thank you so much, Charlie, and all the other organizers for making this possible. I guess I would just say in closing, I'm a deep believer in law and the power of law when norms are very clear to impact behavior. And I think one of the challenging things that we've been dealing with in recent years is a kind of weakening of norms of international law. So I profoundly believe that if we can strengthen those norms through greater clarity about what law requires and what conduct is acceptable on the international front and what not, that can go quite a long distance to ultimately making us safer, and whether that's compatible with large stockpiles of nuclear weapons sitting rotting in their silos, I don't know. But I do think that panels such as today are really critical for moving in the right direction. So thank you once again for organizing this marvelous discussion.
Thank you. Anna Hood? Anna?
It's been wonderful to be part of this. Claire believes in the law. I believe in conversation, and I think now is it's more important than ever. And I think this forum has been wonderful because there's a wide range of views in this panel, and being able to have constructive conversations where we disagree about the law, about the policy, about where we're heading, I think is crucial. So thank you for bringing us all together and facilitating it. It's been a pleasure to be part of it, and I look forward to future conversations. Many thanks.
Thank you so much. Professor Lubin, you get the last word.
Well, I thought that my last round was kind of my last substantive word, but I also want to thank you because this has been an incredibly useful day. And if I have to have a last substantive word, it would be just to quote the first sentence of Oliver Wendell Holmes' book on the common law: "The life of the law is not logic, but experience." And that's where my plea for thinking about the legal questions through the lens of experience, policy, what we know, and above all, what we don't know is really crucial.
Thank you, and thank you all, and thanks for being part of this wonderful discussion. Next is we have a few minutes of closing reflections by organizers, and then we have the cocktail party. I hope everybody will stick around. Last year we had a very interesting after panels discussion. Is Jules Zacher still here, Claire? I mean, Jules was going to say something on an earlier panel and we lost him. I hope, but I don't see him here, which I'm sorry not to, because I wanted to bring him back in. Tell him we were looking for him.
I can't
Jonathan.
see who's in or who's not, who isn't on the current panel, but I did see him earlier, so hopefully.
No, he was here earlier. It looks as if he's gone, but tell him we look for him, and I'll give him a phone call later, because I'm sorry we didn't get his closing remarks. Jonathan, I think you're on our schedule. You are now up as for closing remarks.
Okay. The entire venture of nuclear weapons is designed to protect the state. It's interesting that NATO, I'm sorry here, let's get this together here. Can you release my visual here? Kara?
Tara, bring Jonathan.
There we go.
Down. Yeah.
Thank you very much.
Bring Jonathan down and bring Jeff down. And we have Jeff is
There
here.
we go. The entire nuclear venture is about protecting the state. It's very interesting that NATO has now adopted a doctrine that highlights human security. The state was created in the latter half of the 17th century to separate people with religious fanaticism in Europe from slaughtering each other. The problems we have today arise because we need to bring people together, because nuclear weapons highlight the fact that our fates are interconnected. The climate crisis highlights the fact that our fates are interconnected. So as long as we continue with this extraordinary risk, we're essentially risking the very premise that the state was created to stop. The willingness to cause massive slaughter over ideas. Jefferson, interestingly, in his brilliance, warned us against such intolerance of political zealotry. And let us reflect in his inaugural address, Thomas Jefferson, and let us reflect that having banished from our land that religious intolerance under which mankind so long bled and suffered, we have yet gained little if we countenance a political intolerance as despotic, as wicked, and capable as bitter and bloody persecutions. My deep concern is that we are finding a political dialogue in our country now that looks like the religious intolerance of a previous era. And this kind of conversation that we're having today is exactly the antidote to such a threat. And that's why continuing the conversation is so important and protecting it. I want to end by pointing out that our new Secretary of Defense has committed himself to ending and rooting out policies, education, training that relate to diversity, equity, and inclusion to eliminate the very severe threat that he sees of wokeness. I'm appalled at this immaturity of political discourse and tremendously heartened, and often I'm tremendously heartened by the moral concern and practical thoughtfulness of our military. It was our military who protected us with General Milley's courage. It has been our military that has stood for promoting our values. Our military is often called to tasks that are not completely wise, but they believe in our system of democracy and freedom. I believe that nuclear weapons are unworthy of those values. I believe that nuclear weapons, as to quote my political mentor, Senator Alan Cranston, nuclear weapons are intrinsically unworthy of civilization. And the risks of continuing to pursue security by relying on their extraordinary power is irrational. And in the same way as if you're driving on a highway at 60 miles an hour and there's a speeding sign that says you're in a 25-mile-an-hour zone, you don't slam on the brakes. The car would flip over. You have to gradually come down and come into compliance. We have to gradually come down and come into compliance with international law, which I believe prohibits the massive incarceration, annihilation, destruction of billions of people. God protect us. God protect us. Thank you.
Thank you, Jonathan. Jeff?
I want to thank mostly Charlie, but everybody, not just for being here today and providing your valuable remarks, but for just your thought and consideration and research and teaching and involvement in all these issues. I think as we've seen today, there are still so many questions that need further consideration. And research into many of these questions, for whatever reason, I think lay dormant for many years. And so not by everybody, certainly, but largely. And so, you know, as somebody who works at an institution where we train the officers who are operating 2 out of the 3 legs of the nuclear triad, I appreciate just how important these issues are, and knowing that there are people out there giving them so much thoughtful consideration. I hope we can continue the dialogue. I hope that we can, I don't know if we want to sign on yet for next year yet, Charlie, but
wait a couple weeks.
There's still a lot to discuss. And so from our perspective here out in Colorado Springs, I just want to say thank you very much. Appreciate all of your work.
Thank you so much, Jeff. And as everyone knows, you've been so instrumental in making this what it is through bringing in people you've brought to make this a truly across the spectrum, you know, a real variety of views. And I think I know I've learned a lot, and I'm sure we all have. John?
So I want to appreciate all the participants, the 60 or so right now, I think, who have stayed until near the end of this conference. And I also want to appreciate all the speakers as well. I played a relatively minor role in organizing this conference. I recruited a few speakers and consulted with Charlie about setting up the panels. Then I was happy to speak about threat, which I had been thinking about, but then Charlie said, John, you also have to chair this panel on application of international law, which involves a lot of to potential uses of nuclear weapons, which involves a lot of knotty issues that I had to wrap my head around once again. So I think, thank you for that, Charlie. So anyway, I was glad to be involved in organizing this conference, and I'm glad that it's not just the people who watched it today. It's going to be published in Georgetown University Journal of Law. The video will be available, and the sponsors, the co-sponsors, should make sure to publicize the video once it's available. So thanks to all.
Thank you. I think an insight I had in working on the conference this year is that the principles, the rules and principles are really pretty clear. And I think maybe we've failed to appreciate the challenge in moving into reality the concept that the LOAC and other international law concerning the use of force that applies to conventional weapons also applies to nuclear weapons. We've accepted that, I think, with a complacency that my further thought is this application thing needs more thought because we can't just translate them in. I'm fully on board from what I've read from, as everyone knows, I've studied a lot of the military manuals and the approaches we've taken. And I'm fully on board that in the context of conventional war, I've never been a soldier. I can't imagine it. But what I can imagine is the challenging circumstances that a military person, officer and person on the, and grunt is on, you know, in a conventional war. And we have to defer to them. And we have to say, you know, in the exigencies of the circumstances, we're going to give a leeway. We're going to give a burden of proof. I think we've always done this, and it's in the literature that to some extent that we've done this to the military person acting on the spot, you know, and we do some oversight. But I think we need to take away from this conference and, you know, from at least for me, from my further thinking about it, that we need a new level of thinking. We need a new burden of proof. I mean, I was very taken by Jeffrey Korn in his Pepperdine article, and he had been former head of, as I understand it, law of war for the U.S. Army, you know, that reasonableness and reasonable precautions and the like imposes a duty of inquiry. And that was frankly why I had suggested we invite Shira Shinlin and Professor Painter, because in my world of commercial law and securities law, there's a very heavy duty of inquiry before anybody can act on something of great significance. So I think we do that. I could not agree more, Jeff, with your comments that we need to work on these issues, something you and I have discussed. And I know you were going to raise it with Mike Schmidt. We were going to talk with him, and then we ran into the scheduling issues. But he has this wonderful Holland Manual 2.0, and there's a 1.0 where substantial resources. I can't imagine it didn't cost, you know, I'm making up a number, $5 million. I mean, you had all these people and you brought them to conferences and you had a staff. It would be a lot, but that's nothing in light of what we're talking about. We need a broad process involving people from inside and out and from academe and from practical. And I can't imagine, I mean, we've had this discussion. I mean, Colonel Lieb was so, and I see, Travis, you're still here, and if you want to just come in, but he was so, you know, respectful and complimentary to us. But I join in Jonathan's comments that we owe a debt to the military. And frankly, we have reason to believe that among the most thoughtful people now will be the military, you know, so we need to work on this stuff. I think, and I'm going to stop in a minute, you know, on this deterrence side, I think that several of the comments I heard Claire say it, Judge Shinlin said it, you know, clarity and specificity. And I understand, I mean, I've been studying this stuff for 30 years and I was working on this. I mean, I was working with Jonathan in that group you mentioned, the laws group. I mean, it was probably 40 years ago, you know. I understand that the ambiguity, as Colonel Richard has written and Travis, as you mentioned, you know, is in one sense an important part of deterrence, because you don't want the bad guy to know, you know, when you'll respond harshly and when you won't. But there's a problem, right? Because we heard from panel one that the risk factors are so great and you have to go by what is good. And I remember Dr. Ford saying, you know, you have to go by what's going to deter your adversary. But I think what we have to add to that is what we know about human nature now, right? We don't need to read, you know, 30 stories from Rand, you know, 30 100-page studies from the Rand Foundation from the Cold War on deterrence to know that human beings, when any of us are threatened, it gives us a reaction. And to the extent that our deterrence policy is ambiguous, it's broad, it threatens the use of weapons we know we can never rationally use against targets that are co-located in major urban centers that we know we can't use them. We're raising the risk factors. And maybe deterrence would be better if it were realistically limited and not threatening such blunderbuss. Anyhow, I'm going to stop. Obviously, as Jeff, you said, maybe we need to do another of these, but I don't know about you. I'm not ready to discuss it yet. I think we now go to the cocktail party. We should all take a break and walk to another room and get our beverage of choice. But we still have a bunch of people. We have, what, 50, I can't read this, 52 people. Please join us. And Kara, please set us up now, in the virtual cocktail party.
Okay, see you in a couple.
Kara, are you still here? I know your assistant, one of your colleagues was going to come in at some point.
My name's Emily. I'm
hi, Emily. Emily, yes, of course.
sorry.
Yes. Kara mentioned it. How are you?
Good. How are you? I'm just promoting everybody to panelists so they have the option to join and talk with everyone.
That's perfect. And some of us are going to walk away for just a second.
Okay. And if attendees would like to join the reception, just accept the panelist request.
I only see two people joining. Audrey Kitagawa from Hawaii, right? Audrey, you're in Hawaii?
I'm back in New York City, Ahmed.
Okay. And Driz Larafi, are you in Morocco? Driz?
I had one question. Whoops.
And let me say, excuse me, that anybody who wants to come in but doesn't want to have their camera on because they're not camera ready. I've been there, you go to these webinars and so people can come in without their camera if they like, but we certainly invite everybody to come in if they like.
I had one question that didn't get answered in the Q&A. Can you hear me?
Yes, we hear you.
Professor Reichert's slides on human rights cases, he made some slides. Would those be available?
Daniel, are you still here?
From panel 4, I think. Panel
right,
4.
That's Daniel. I don't see that Daniel's here because it's probably about 1 or 2 in the morning there, but I think so. And I'll ask Kara if she, we'll confirm with Daniel and circulate them to everybody, assuming it's fine with Daniel, which I assume it will be.
And there were a lot of good links put in the chat, but it's hard to kind of pay attention to that and pay attention to speakers. Any chance that you might include those in your follow-up email?
Can you, is that possible? I know Kara said that she was going to copy all them for us. So can we also circulate all the chats and questions that were recorded today?
Yes, that's an option. I can let Cara know.
That'll be great. Yeah, because Kara was going to, was going to save them. I think that's a good idea. We'll just circulate them to everybody who signed up, along with, once we have any permissions we need, PowerPoints.
My team how much for this candy for?
$5.
Give me some sucky with that $5. Let me alone.
Somebody needs to turn off, to go onto mute if they're not,
Let's bring this out of here while I look up on these people. Hey, looking at damn ice cream like that while people in the corner and make me some.
Good.
Charlie, I'd like to recognize Douglas Roach, who's on. He's one of the great towering
I just saw that. Wonderful. Yes.
towering figures in this, and I wondered if Doug could give us some comments about the day's proceedings.
Well, thank you, Jonathan. And
well, let me introduce you to people who don't know you. He was a senator for many years from Alberta, and he was a disarmament ambassador for Canada, and he was the one of the leaders of Parliamentarians for Global Action, and the visionary who helped form Parliamentarians for Nuclear Nonproliferation and Disarmament and the Middle Powers Initiative, among other things. And I think he has about 17 or 18 books. And I commend, and I haven't read all of them, but I've read a number to be able to say, go to his website, Doug Roach, and read his books. He's brilliant. So Senator Roach, please.
Thank you, Jonathan, and congratulations to all the panelists and all the organizers. And I would like to hear, particularly, since I've never had the pleasure of meeting him personally, congratulate Mr. Moxley for his enormous contribution to the understanding of what nuclear disarmament and nuclear weapons is all about. So thank you very much, Mr. Moxley, and I learned a great deal from you and your colleagues today. I will confine my comments to just one. We're living in the normalization of nuclear weapons, and I find this very, very, very disturbing indeed. That what was once considered an aberration of humanity, a terrible thing, is now considered part of the furniture of life, and I find this a very bad thing. So it's led to one dominant thought that I have, and it's been recycling in my mind today when references were made to the ICJ, and it's this, that some people are so perhaps discouraged from the goal of the abolition of nuclear weapons that they allow themselves to say, well, if we just have some reductions, even some reductions, and let's see what happens. To me, that is like saying to a slave, well, we'll loosen your chains, and you won't be quite so uncomfortable, and it will give up on the end of slavery. Or the same analogy could be used for colonialism or civil rights. You just part way. I believe that it is essential